Okay. Well, I will now declare open this hearing of the Senate Environment, Communications and References Committee inquiry into the National Cultural Policy. And today's hearing will focus on emerging technology and the impact on creative industries. We are here in Canberra today, and I begin by acknowledging the traditional owners of the land on which we meet and pay our respects to their elders past and present. On behalf of the committee, I welcome everybody here today. I'm the Chair, Senator Sarah Hanson-Young, and I'm joined today by our Deputy Chair, Senator Gosch, as well as Senator Henderson and Senator Grogan, who is also joining us online. And Senator Pocock, who's not a regular member of our committee but comes in when the issue is important. Thank you. This public hearing and Hansard transcript of the proceedings is being made, and the hearing is also being broadcast via the Australian Parliament House website. Before the committee starts taking evidence, I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as contempt. It is also a contempt to give false or misleading evidence to a committee. The committee generally prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to be heard in private session. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether we insist on an answer, having regard to the ground of which it's claimed. If the committee determines to insist on an answer, a witness may request the answer be given in camera. Such a request, of course, may be made at any other time. I remind senators of our obligations under the Behaviour Code of Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. I remind people in the hearing room to ensure that your mobile phones are switched to silent, and for those online, please have your mute button on until you're called. I now welcome representatives from Maincode and the Productivity Commission. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. I will just also remind fellow senators that the Senate has resolved that an officer of the Department of a Department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions to a senior officer or to a minister. The resolution prohibits only questions asking for opinions on matters of policy, does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of that order is available from the Secretariat, and I'm hoping we don't need to use it. For the Hansard record, could you please state your full names and the capacity in which you appear? And we'll start with you because you're here in person.
Dave Lemphers, CEO of Maincode.
Wonderful. And we'll go to Dr King.
Dr Stephen King, on behalf of the Productivity Commission.
And next to you?
Julie Abramson, Commissioner, Productivity Commission.
Thank you. And do we have Dr Dent on the line? Does...
Assistant Commissioner.
Yes.
We've got you there. Okay, thank you. If we need you, you can shuffle seats. All right. Now, I'd just like to give you both the opportunity to give an opening statement if you have one, and then we'll go to some questions. So we'll start with you.
I don't have a prepared statement.
Okay,
Chair. Thank
no
you.
worries. Does the Productivity Commission have a prepared statement?
Yes, we do. Thank you, Senator. Let me be fairly quick, though, because obviously our time is limited, and thank you for being able to accommodate us in this time slot. So just a little bit of background on where our work's come from. Data and digital technologies are obviously key engines of economic growth, and new digital technologies can create benefits across the entire economy, including speeding up lacklustre productivity growth. So in the late 1990s, development of information communication technologies contributed around 0.3% to Australia's economic growth. Internet and mobile phone adoption in Australia increased Australia's GDP by about 3% across 2004 to 2014, that decade. Now, we've been asked by the Treasurer to look at opportunities for Australia to harness the consumer and productivity benefits of data and digital technology. Our report notes the importance of managing and mitigating against the downside risks of technology change. And we note the government plays a key role in determining the legal settings around new technology. Productivity can be enhanced by rules that foster innovation and ensure Australians reap the benefits of the data and digital opportunity. So, on AI generally, our interim report discusses the potential gains to productivity growth from recent developments in AI technology, particularly generative AI, and for the Australian economy. No one can precisely predict how AI will change the economy. We use a relatively conservative estimate that puts the benefits to Australia at around $116 billion over the next decade, or around 4.3% of GDP increase. At the same time, AI raises an increased risk of harms. So many, if not most, of the harms are already covered by our laws, but generative AI enables bad actors to create some harms faster, cheaper, and more effectively than before. A key element of our interim report was for the government to undertake a gap analysis of our existing laws to make sure they remain or are updated to be fit for purpose in the AI age. So if we turn to copyright, we chose copyright law as a case study in the interim report to highlight the need for gap analysis. One issue for our current copyright laws relates to the training of generative AI models, and that's the only part that we actually discuss in the report. This is because, the reason for this training issue, this is because the data needed to train AI models is often protected by copyright, meaning that its use requires permission from the copyright holder. There are concerns that the Australian copyright regime is not keeping pace with the rise of AI technology, whether because it's not adequately, does not adequately facilitate the use of copyrighted works, or because AI developers can too easily sidestep existing licensing and enforcement mechanisms. So we're looking at the issue of whether, if so, what policy reforms are needed for existing copyright law. Policy options that we have considered include doing nothing, keeping the current law as is, secondly, bolstering the copyright licensing regime, such as through collecting societies, and thirdly, amending the Copyright Act to include a fair dealing exception that would cover text and data mining. Now, we're mindful of the following limitations. The training of generative AI models and applications is already happening, mainly overseas, where Australian copyright laws do not apply. It's not realistic to think that we can stop this, so we are looking at policy options that help us navigate this challenge. Secondly, what we can control is the regulations that govern how AI training happens in Australia. As it stands, we've been told by many parties that our current approach to copyright has effectively taken Australia off the map when it comes to AI training, including training for certain small task-based models that might be used, for example, by research institutions, medical research institutes, and so on. We have not reached a view on what should be done and made no recommendations on copyright in our interim report. We are undertaking public engagement on this issue, including through submissions, meetings and roundtables to inform our final report. Our final report will be handed to government on 13th of December this year. And again, can I just thank the committee for its flexibility. We actually have a copyright roundtable this afternoon and you were able to move our time to be able to facilitate that. So thank you very much.
No worries. I know, I'm sure my colleagues are going to have lots of questions. I just wanted to, firstly, Mr. Lemfers, in absence of having a opening statement, which is absolutely fine, by the way, I just thought maybe it'd be good to understand what your company does and its engagement with copyright.
Yeah, so MainCode is an AI research and engineering organisation. We do two primary things. We built the first from scratch large language model in Australia called Matilda. And then we also created a what's called a model factory, so the capability for us to build from scratch models that can be used by organisations to enhance productivity and deal with a lot of the use cases that aren't addressed by products like ChatGPT. And
so more
LLMs.
kind of closed circuit type of systems, or where organisations feed in their own data.
Yeah, exactly. So they're hybrid models that take in domain knowledge and internal data, and then built specifically for a task. So if you're thinking about classifying a document or a transaction, that's what the models we build are for.
And if you had any interaction with copyright laws and having to license the material that your data accesses?
Yeah, so, and I'll speak specifically to training Matilda. So Matilda is trained on a number of different stages of data. We have a very strict and rigorous process for establishing the source and provenance of that data, and we're very careful not to use anything that would violate anyone's copyright laws. It does mean that certain elements of the model, so it means Matilda in certain categories can't perform as other models do that don't respect those conditions. But it also means that we've designed Matilda from scratch to provide better explainability and traceability into where the tokens are sourced from.
Mm-hmm. And have you had to buy a license to access anything? Has there been any kind of engagement with any of the licensing organisations or collecting?
Not yet. We actively talk to a lot of the organisations, creative music industry, news industries. We have conversations with organisations that have large libraries of stock data, like stock photos. And again, we're absolutely not averse to licensing and remitting the appropriate payments to those producers for models that we build. I think that at Main Code, the way that the factory is designed is very much to produce very targeted models for customer needs, and it allows us to have a greater amount of control over both the inputs and the outputs. So we can treat each of those models as an individual project. We can cost it up. We can understand what it's going to take to acquire all the right data to develop that. And then we can do that commercially with the buyer, ensuring that those producers of that content are paid appropriately.
And you're an Australian-owned company and
Fully Australian-owned.
Fully Australian, so Australian law applies to you.
Yes, absolutely.
As opposed to some of these other big AI corporations that based out of the US or multiple places around the world to avoid any particular jurisdiction. Do you feel that there is a unlevel playing field between the laws that you have to apply by versus what they, get away with?
Yeah, this is something that's very near and dear to our heart at Main Code, and we work closely with the government, providing ideas and concepts on how we think this could be addressed. I think from my perspective as a business owner, and someone who's really keen and kind of interested in seeing the AI economy and industry boom in Australia, there's a number of things that concern me. The first one is that I think we have to be very careful about premature moves to regulate and create policy without evidence. I think there's a number of really great examples historically and overseas where early regulation without evidence actually stymied local innovation and actually pushed that innovation overseas to where those other countries benefited and ended up having to sell back that technology to that company, and that country ended up becoming just a consumer. And I really would hate that to happen, in Australia. I think that we are also have to be very careful about creating a highly regulated environment where large companies actually thrive in that. So, if you're a multi-billion-dollar corporation, you have armies of compliance folks that love wading in all of that stuff. Whereas a smaller organization isn't going to be able to participate in that kind of environment, and that's everything from the laws to procurement. And so I think that, what we want is, certainly what I want, is a opportunity where we have a period of protection during incubation of this AI industry, where the national interest and Australians' interests are protected, and that we enforce, reciprocity of the laws that we are ultimately held to in other countries as well. And I think if we start to think about laws that, advance and encourage the AI ecosystem while protecting us from overseas interests, then I think we have a really great opportunity, to get a start and start to spin the flywheel.
And of course, as a company that's built your product from scratch, totally Australian owned, you would want to protect the coding. You would want to protect your IP.
Yep.
Wouldn't you?
Absolutely, yeah.
And so you could see why other creatives want to protect their IP too.
Yeah, and also I think we have to be very conscious of why we're having some of these conversations. I think the very large overseas entities engage in doomer rhetoric. I think they do that to, create an environment where it does become heavily regulated because they actually thrive in that environment. And it means that it stamps out any grassroots innovation and local capability, while they absolutely do not respect our laws. And one thing I also want to note, Chair, is that a lot of this gets positioned by these companies as a technical challenge. And as a model builder who actually runs our own factory, you learn over time that's not the case. It's purely a business decision. So you can absolutely trace, you can build into the technology true provenance and traceability of the source to the token, but you wouldn't want to disclose that because immediately you open yourself up to potential copyright claims and litigation.
But that information does exist and
Absolutely.
It's easy to access.
If you are inside the organisation and you are a model builder, you absolutely have access to that
So if there was
information.
transparency rules around that,
Right.
at least that would help.
Yeah, exactly. Yeah, and again, I think this is where our experience at Main Code in having to build Matilda from scratch, every single piece of the infrastructure, the team, the software, we've learned so much about what ends up just being rhetoric or marketing, and we start to understand the impact of operating in Australia, where as an Australian company, we follow Australian rules, and so we're at a distinct disadvantage. And then we're also looking for the government to implement, policy and controls that incentivises Australian businesses to buy Australian-made AI in the form of, if we think about the R&D tax credit, but something that's a little bit easier to navigate for companies, much like the movie producer laws.
Yes.
But I also think we need to be thinking about a period of time during this incubation period where if Australian organisations are buying AI overseas, they need to be contributing 1%, for example, of that total contract value into development funds here locally. And I think we need to be thinking about how to stimulate and support the local AI economy while protecting it from overseas. And we've done that before. It's not a new idea.
No, so not just letting these big global companies come in, mine all of our data, and then piss off the profits.
Well, mine all our data, develop the models overseas, and then sell them back to us while our local ecosystem and economy does not get a chance to succeed. And I think that when we started, a lot of the established thinking was that we couldn't create a large language model in Australia. It wasn't possible. We didn't have the capability. And when Main Code released Matilda, we were able to show that that's absolutely possible. Is it easy? No. It's really hard. Does it cost a lot of money? Yes. But it's worth it.
And so this is, yes, as you're saying, this is kind of a sovereignty argument in relation to business, intellectual property. Obviously there's an argument being made that in today's discussion about the need to protect cultural content as a kind of cultural sovereignty project. You're saying all of these things actually are in the same conversation. How does Australia both benefit and strengthen our capacity, but actually investing in Australia and what we have, not just mining it, selling it off and then selling it back, as you're saying, which we've done with minerals in many other ways. Right,
and I think this is the thing where these aren't new issues. We've already seen these things happen, and I think we're early enough. And again, we're told a lot of this overseas rhetoric again that it's too late, the ship has sailed, and that is absolutely not true. We are seeing massive opportunities locally and globally to build hybrid models for these very specific domain internal data tasks. what we also have to understand is a large language model is only one very small sliver of all potential AI that can benefit humanity. There's a lot of rhetoric around, people losing jobs, creatives being replaced by AI. All of those things are not true. And if you look at the research, a lot of the time spent by creatives and producers is in administrivia. And AI is really great at replacing that human toil and that operational administration that needs to happen. And I think we need to be focused on the practical aspects of these capabilities, because that's going to open up more time for humans to do what humans do really well that the machines can't.
Thank you. I'm going to give my colleagues a chance, but I do have lots of questions for the Productivity Commission, so we'll come back. Senator Gosh.
Thank you, Chair. I might stick with Mr Lemfers as well on this first round. In terms of the national training data set that feeds into your model, can I ask you to just briefly summarise what sits behind its description as clean, representative and truly ours? What are the principles that sit behind that?
Yeah, so we start with that data set. It begins with what's publicly available in the research community, and it's not specifically Australian. So it's just whatever's developed for all research organisations. It's very well documented what sources go into that, and at that point it's purely text. So before it's tokenized, we go through and to the best of our ability run filters and screens to make sure that if there's anything that clearly looks like it's copyright, we omit it. And then we bring that information into a set of purely Australian data that is released under the Creative Commons, and they're essentially for public use. And then there's an element once that data is developed where we run algorithms across the top of it to generate net new information. So this is information that does not exist in the ether. Those algorithms are designed to build connections and expand the metadata and the knowledge of what that initial data is, and it actually takes a small amount of data and explodes it into a large usable set of data, and then that is what's used to train Matilda. Obviously there's a lot of magic and stuff that goes into that, but we purposely built the architecture knowing that we would have to operate on smaller data sets if we wanted to follow copyright law, and we needed to develop algorithms and mechanisms to increase the quality and capability of that data set so we could achieve our training goals. So that was by design.
One of the observations you made earlier was that attribution and determining the provenance of information is technically possible.
Absolutely.
And in fact, not at the hard end of the technical scale. No. So it is a commercial choice when companies choose not to attribute or properly provenance their information.
Yeah, so I think that if we kind of go back to the beginning where LLMs and OpenAI and that research came about, it came from the research done in text translation. So back then, the architecture design decisions they made wasn't about in consideration of copyright law. They were just using language sets to do next token prediction. I think over time, when you look at an organisation like an OpenAI or Anthropic, they're so large now and they do the one thing that for them to pivot or change any part of their architecture would be dramatic. I think the benefit we had at Main Code was the ability to sit down and say, given everything we now understand and all the issues at play, how could we approach this differently? And so by design, we thought these issues through and we made very conscious, intentional design decisions. And so that is why, again, as a model factory and a model builder, we start to understand just how much of the information you actually see. And it starts to make you go, well, what we've been told about explainability and provenance is actually not true. It might be true for their particular design, but overall it's not an unsolved problem.
Does that logic or conclusion also apply to training processes? one of the concerns that was raised at an earlier committee into AI last year was around the integrity and ethical framework by which AI models were trained and the impact that has on the way they operate once in the wild.
Yep.
In terms of transparency around training, is that also something that can be, in effect, revealed without destroying the proprietary information or the commerciality of the endeavour?
Yeah, I think it's a very valid concern if you're a buyer to want to understand what's in the product. I think that there are already mechanisms in place for organisations, in commercial relationships to disclose a number of different aspects, whether that's the location of data centres, whether that's the architecture of servers. There's a lot of things that you can share to give comfort to the buyer that they're not violating something without their knowledge. But again, these are all concerns that have to be thought of at the very early parts of the design. And I think that one of the opportunities I do see for Australia is that we can actually lead the world in this thinking, because there are very few model factories like MainCode. It's very hard to set them up. We're the only one in Australia that produces models from scratch. And we have a real opportunity to start to use that experience and that knowledge to guide policy, guide these kind of conversations, because we're essentially at the tip of the spear. So we are having those early conversations with Australian organisations, but also global organisations, actually. And so we naturally go through that process of them saying, how much can we understand about this process? And we sit down and we work with them and say, we can share this much without leaking IP, but the way we do it, or we can demonstrate the process, again, just gives them that kind of comfort, in what they're buying. So I do think it's very achievable, but I do think it's something that needs to be done based on experience and demonstration. I think we should be very careful of any type of policy development that's done in a vacuum and done purely either by looking at what's done overseas or that is done purely based on opinion.
And one of the concerns you raised earlier was ill-considered or perhaps ham-fisted regulation. If we were trying to encourage an ecosystem in Australia that produces the kind of results that you're trying to generate at Matilda, what are the regulatory frameworks or principles that you would apply in order to encourage that sort of ethical behaviour, the transparency and integrity in the processes that we've been talking about?
Yeah, I think that it depends on how you consider, ethical and responsible, Senator. I think that for us, it's actually about what creates a environment that allows Australian AI to develop. I think Australian-made AI is an incredibly important economy and industry that needs to be very carefully incubated and protected and grown. I think that, for a generation of folks to follow who missed out on the mining and property booms, for them to not be able to work in this field would be a shame. I think we've invested in generations of STEM kids who want to work in this industry. And I had dinner last night with a dear friend whose son is in university and is contemplating what to do, right? Where's the industry that this person who, from year 7, in the investment in STEM is ready to participate in? And so we have a responsibility to develop that. And I think, so I start to think very much in terms of how do we protect Australian-made AI? I'm less worried about the intellectual concerns that haven't happened yet, and I'm more concerned around what are we doing to create programs to stimulate spending in local AI? What are we doing to protect local model builders and AI companies so that there is an incentive for Australian businesses to spend their money here, that spin that flywheel and develop that capability? I think that's responsible and that's fair. And that's the type of policies we should be focusing on as a country.
Chair, I appreciate we're going to be right up against some time barriers. Do you mind if I put 3 or 4 questions on notice for the PC just quickly? And
go for it. I think we will extend this session for 15 minutes or so. Yeah.
Okay.
Yep.
So I apologise for doing it in this way, but we're going to run out of time, so I'm just going to put some questions to you, and if you would come back on those so that we can share the call. In relation to the expected productivity gains that are set out in the Harnessing Data and Digital Technology report in August, that was released in August, it would be helpful to sketch for me those, or how that's anticipated to occur as a matter of logic in relation to the Australian economy, and then just a sketch of what the considerable uncertainties that are referred to are, and how that impacts on likelihood. And then in terms of those productivity gains, what proportion of those gains are anticipated to come from the creative arts sector or the creative sector? And please take a broad view of that, including media and anything that's really involved in content generation. And then the final one is, would a requirement to pay for input content into AI systems affect the potential productivity gains as distinct from the profitability or the commercial outcomes for the AI firms?
Yep.
Thank you. Thank you.
Very happy to take those on notice. So thank you.
Thank you. Thank you, Chair.
Thank you. I'm going to go to Senator Henderson.
Thank you very much, Chair. Good morning to you all. Look, I'd like to go to the Productivity Commission. I refer to your interim report, Creating a More Dynamic and Resilient Economy, released August 2025. Can I first understand, when was that report first handed to the Treasurer? Mr King.
Yes, we've got people around the table, mainly Jared, thinking exactly when was it handed to the Treasurer. Perhaps because of time, can we take that on notice just so we get back with the exact date?
You can't take it on notice.
Can we just clarify?
Sorry, Chair, let me just, sorry.
Yep.
You can't take that on notice. So while I'm asking other questions, if you could just have your team check a pretty basic question. You've got a very large organisation there, Mr King, and I expect that those sorts of questions could be answered pretty quickly.
Yep, thank you, Senator, and 5 August.
So it was handed to the Treasurer on the 5th of August.
Yep, we've literally got someone. It was publicly released on the 5th of August.
I'm not asking that question, Mr King. I'm asking the question, when was it handed to the Treasurer?
All right. Well, whilst you're asking other questions, Senator, our team members will try and get exactly that.
Thank you so much. So in this report, you wave the white flag in terms of protecting the copyright of artists in this country. I am raising very serious concerns about the Productivity Commission's approach to the protection of our creators, our authors, our writers, our playwrights, and everyone working in this country in the creative industries. Why are these industries not worth protecting, Mr King?
Could I perhaps answer that, Senator? That is not the position of the Productivity Commission. We have an open mind on this. We are consulting on it. We think that the creative industries are very important, and we've done previous work in this area. As Dr King indicated, this was an example of where we were looking at, is the current law fit for purpose? But we do not have a firm and fixed view, and we think creative industries are important, and we have been consulting heavily. In fact, I think we've got, I'm looking at my team here, over 400 submissions in respect of this issue.
Ms Abramson, I'm going to respectfully disagree, and I'm going to quote your report. And you say, and you propose a number of proposed changes to the law, including a fair dealing exception that would cover text and data mining. And you say in your report, the training of generative AI models and applications is already happening mainly overseas, where Australian copyright laws do not apply. It's not realistic to think that we can stop this. So we are looking at policy options that help us navigate this challenge. So I would put to you, are waving the white flag rather than standing up for our creative industries. You're saying very clearly it's not realistic that you could stop this. Why not? Copyright in this country is worth protecting in this country and around the world. So I would say to you, why are you making statements like this, which I would put to you are abandoning our creative industries?
Well, Senator, I can only say that we are consulting fully on this. One of the purposes of our interim reports is to actually seek feedback on particular issues, and I take on board the comments that you've made.
Well, my feedback to you as a member of this committee and as a former creative myself and as a former member of the MEAA, I condemn the Productivity Commission. I condemn the Productivity Commission for not having appropriate regard to our creative industries. And it's also misleading to say, and as a former IP lawyer, I will say this, it's also misleading to say where Australian copyright laws do not apply. The training of generative AI models and applications is already happening mainly overseas where Australian copyright laws do not apply. Well, as you would well know, are you not aware of international treaties which protect Australian copyright in overseas jurisdictions?
Yes, Senator, but my understanding of those international treaties is a respect for the copyright laws of the relevant country. So that if we were looking at an AI engine trained in the EU, for example, it would be subject to the EU's text and data mining exemption under their copyright laws.
But I would, Mr. King, sorry to interrupt, but I would just say to you that it's quite misleading to characterise the law in the way that you have. It basically suggests that really once copyright is adapted or utilised outside this country, that artists have no protection whatsoever. Now, that is not the case. And so I just want to put to you, where is the benefit to Australian artists in having their works scraped by AI?
So just to come back to your first point, Senator, we certainly never say and would not want to infer that there was no copyright protection overseas. I think our allies, for example, the EU, Japan, Singapore, the US has numerous cases, although it has different bases to its copyright law. Those copyright laws apply to Australian content when it is used for training in those overseas jurisdictions, just as European or Japanese content that is used for training in Australia would be subject to our copyright laws. So to say there's no copyright protection would only be correct if there were no copyright laws in any overseas jurisdiction.
Well, I would put to you, Mr. King, that you need to do a better job at setting up the facts in your report, because what you've written is frankly misleading. And I go back to my question, where is the benefit to Australian artists in having their works scraped by artificial intelligence?
The Australian creatives at the moment, if it is their works are being scraped, being used as an input overseas in a lawful manner, and that is still up for debate because, as we've seen in the US, some AI companies chose to use pirated copies, and there has been a decision in relation to that being against the law, which I suspect we would all be very thankful for. But where is the benefit for Australian creatives? The problem at the moment is that when the copyright material is being used for training AI engines overseas, Australian creatives are not getting the benefits. In general, there are some licensing agreements, but HarperCollins, for example, has one, but in general, they're not getting the benefit. And Australia's not getting the benefit of the development here. That was our starting point, that we're in a situation where it's not clear that copyright laws are fit for the AI age when we're in a situation of relatively little training here, and the evidence from Main Code was highly pertinent in relation to that. There's limitations on training here, but at the same time, our creatives are not getting rewarded when the material is used for training.
You don't seem to be too concerned about the benefits or otherwise for Australian creatives, particularly in proposing that they would lose copyright protections for their work so that tech platforms could train large language models in overseas jurisdictions. Why isn't the Productivity Commission defending Australian creatives rather than looking for ways to undermine them?
And Senator Henderson, one of the things we are doing as we consult, can we just apologise, we're both a bit under the weather here, is that we've been looking at licensing, we've been looking at collecting society. So we are thinking through some of those issues that would provide a return for creatives. So we're certainly engaged on those issues.
Oh, look, I might hand the call back over, Chair, and then maybe come back for a second block if that's all right.
That's fine. I'm going to go to Senator Pocock.
Thank you, Chair. Thank you all for your time. Mr Langford, I know we're pressed for time here, so I just wanted to touch on a few things that you've talked about. I'm interested if you can clarify if you think that creative content should be licensed when LLMs are being trained or built.
Yeah, and a couple of things that I just wanted to add to the prior conversation. I think that the Australian policy around AI imports is really an important focus area too. If the belief is that the products coming in from overseas companies are built through illegal means, then I think we do have powers and possible policy to block that. And I think that is a viable conversation and channel for exploration. So I wanted to just have that noted. For us, Senator, the most important thing is to, first of all, develop models that do not require large amounts of data which don't follow local laws or respect the creators. It's because if you begin that journey with that design intent, you can actually develop models that are quite capable without having to infringe copyright. After that, building a framework into the system to understand what contribution a producer has made is the second step for us. The way we do that is we trace all of the incoming data and we decide what we actually need. And that allows us to go out to organizations like a news organization and say, we already have 60% of the data we need, and your extra 20% will add capability to the model, and we're going to tag that. And by commercial deals, we actually don't need to deal with that many organizations to acquire the relevant information to make the model capable. And so what that allows us to do is there's no conflict and there's no commingling of source data. So if someone is the authority on sports information, they are the only authority in the model. So it becomes a lot easier than if that's produced in tokens to say we're going to remit payment. So it's no different than a catalogue of music, and being able to actually trace the inputs to the outputs.
Sure. And it seems to me, as someone who's not an expert in this, that a lot of these data sources are actually well set up for licensing. They do licensing all the time.
Absolutely.
And so that shouldn't actually be a barrier to paying for someone's work to train your model.
That's a very fair statement. And I think, again, if we zoom out at the overall complexity, like the sheer technical innovation that's gone into AI, it stands to reason even to a layperson that tracing the source data through that process is probably one of the easiest things to do, comparatively to everything else that's in an AI model. So it's clearly a choice.
You said earlier something to the effect of AI isn't the threat to creatives that they think it is, and it's essentially going to help them with their admin. Obviously, hearing from a bunch of recording artists and others later today who I think potentially hold a different view. Can you clarify that, given that I think most of us would have seen some of the tools being demonstrated where you can create a whole album in a matter of minutes, and we've seen on platforms like Spotify AI bands having millions of plays?
Yeah, first of all, I think that AI is a tool. It's not a human. The concern that AI is going to achieve a level of intelligence, I honestly think is largely rhetoric and used to, control the narrative and the thinking of the population. The reality is AI is a tool. Creatives can use that tool to enhance their processes. I think if you look at a lot of the research, though, what is actually shown is most of the time spent by artists is in administration and toil, and that ensures that they don't have enough time to create. And so I think by focusing AI investment in removing that toil and opening up more space for them to create, we're going to find that they're just essentially creating more and better. There's always going to be a market for digital content. There's always going to be a market for generated content. That's not new. That's been something that's been around for a while. And I also think that for a lot of the industries where AI is generating content and generating outputs, it still has to compete against humans. And I don't think we've seen, I certainly in literature review have not seen the research to show that these markets are actually incurring a detriment. We're not seeing the economic impact that we're being told is happening. So I think we need to wait to see what happens, but also invest in equipping our artists with the right tools to help them create more, essentially.
Do you think a wait and see approach is prudent, given, I guess, the value of the arts to us, both in terms of cultural significance, but also economics? We're talking $60 to $100 billion of contribution to the Australian economy. This sort of wait and see approach, where we potentially have AI generated content displacing local artists.
Yeah, so the wait and see for me is collecting information and evidence and data to make informed decisions. And I think that we have a far bigger issue in Australia around the AI economy and the flywheel, in that we don't have the resources, and we're not investing the resources for model builders to build models in Australia for local and export capability. I think if you look at the overall, and the Productivity Commission report states the overall potential opportunity in growth, my perspective and position is that if we were to invest in this economy so we have more model builders building more models, we're in a far better situation as a country to compete. Okay. It doesn't obviate the need for us to attend to matters like copyright and copyright enforcement, but we also need to think about those in very traditional ways. For example, we have laws to protect brand designers from knockoffs. And so we already have these capabilities, and we can deploy them to protect our artists locally. But I think it requires us to be far more pragmatic. And I'll come back to what I said. If you have an organisation, if you have an Australian bank paying $1 billion to a foreign organisation that's selling them AI that's been potentially trained on information that's been copyright infringed, and we allow that, that's the problem. And that's easily solved, right, through sanctions and fines and requiring them to produce information to prove that they haven't done that. That doesn't require technology. It doesn't require us to stop and do anything. So I think there are already instruments and mechanisms for us to protect that. And while we continue to focus on these things and not focus on the fact that we lack the core infrastructure investment to build more model factories and model builders, that's going to be the problem in Australia.
Thank you.
We are going to have to keep on moving.
Can I ask the PC couple?
Yep.
I might just put a couple of questions on those for you, just for the Productivity Commission. I'm interested in examining a text and data mining exception, what economic modelling you've done on the impact of this exception on Australia's creative economy, which estimates have between 60 and 90, $100 billion.
Sorry, Senator, you want these to be put on notice?
No, you can answer it now.
Answer now.
Yeah.
Sorry.
I'll put some more for Mr. Lemfers, but for you, I'm interested what economic modelling you've done, the impact of a TDM exception on the creative economy.
Jarrett, do you want to? Come on.
We didn't do explicit modelling on the effect or the value of a TDM exception.
Why not? You're essentially sort of flagging something, putting something out there as a potential solution, and you're not looking at the potential impact on an enormous, I think, from what I've seen, it's 2.5% of GDP.
So we put it out there as a proposal, which we're consulting on and receiving submissions on. So, as I say, we didn't do explicit modelling on it.
Well, are you doing modelling now, given you're in the next stage? I mean, either you stand by your report or you don't. I mean, it feels as though it's being discredited with every question that's being asked here today. So you didn't do the modelling before you released the interim report. Are you doing modelling now?
We're not doing modelling around any of the potential alternatives for copyright law, including the potential for copyright law not to change, potential for copyright law to just be through licensing, as previously mentioned by Main Code. We are concerned, by the way, with that solution, that leaves smaller copyright holders hung out to dry, if I can put it that way. We've also talked about, in our report, extending the currently statutory licensing approach, which is the collecting societies. We talk about a TDM. Where we are sitting is that this is a case study. It is 4 pages, I think, in our report, where we simply said this is an example of the sorts of questions that need to be raised. We have not recommended any change to the copyright law, and it's simply clear from our report that that recommendation hasn't been made, or any specific change has certainly not been recommended.
Well, I mean, on page 28, where you have your the information request box, every question on there assumes that the system's broken. Every question on there assumes that there should be some type of exemption or workaround. So I just, if you're surprised at the reaction, I think you've really misread the value of creative industries. And I guess you haven't done the modelling, okay. Do you have a figure by which the Productivity Commission understands or bases your work off of what the creative industries are worth in Australia?
Thank you, Senator. So the Productivity Commission has not looked at the creative industries, has not modelled their benefit to Australia, has not modelled whether creative industries would expand or contract as a result of AI.
But what does the Productivity Commission estimate the value of the creative industries is to Australia? You must have that.
No, we don't, Senator.
Wow.
Okay. Could I go back to the beginning?
Up, Senator, but we can go back to the relevant statistics and look it up. But we certainly don't have it off the top of our head.
Do you accept the figures that were put out by the Creative Australia recently, that it's the value is in the vicinity of $67.5 billion to the Australian economy?
Without knowing the basis for those figures, I can neither accept or reject them. It's simply a figure that's being put out there. You would have to know on what basis that figure is derived to see whether that figure is in fact credible or incredible.
But if you are looking at putting in place an exemption of this industry getting paid for its work, surely you must have to have some idea of how much the industry is worth to the Australian economy.
Senator, unfortunately, we're not recommending, or we have not recommended in the interim report. I cannot say what we will do in the final report because that has to be provided to the government.
Feels like a lot of backpedalling, Mr. King. A lot of backpedalling going on now.
Senator, the aim of our case study was to point out the legal issues and ambiguities around a particular group of our society, the creative industries, and their interaction with AI.
Okay.
That's all it was to do, to say this sort of gap analysis must be carried out. This is a tiny part of our report,
So where's the
and it is
analysis?
not a gap analysis that we are carrying out.
So where is the analysis?
Our recommendation in the interim report is that this sort of analysis has to be done by government and by regulators across the Australian economy to ensure that our laws are fit for purpose for AI. That is the underlying task that we believe government has to undertake.
Dr. King, could I ask you, you've mentioned this case study a number of times, and you said in your opening statement that many parties had raised this. Where did this case study come from, and who are the many parties that say that the issue is the protection of content from copyright?
We have been talking to a range of parties, including the creative industries. And
No. When you did the interim report, who
Yes.
put it to you that we needed this case study, that this was an issue?
That's not the way that we thought about the report, Senator. The way we thought about it was going back to this original proposal, are laws fit for purpose, or does there need to be a gap analysis? And I think a number of players are on the public record about their views about some of these issues, and we certainly saw that in recent media coverage.
So who are the many parties that think copyright is a problem?
Well, I think that there are a number of parties who are actually on the
I'm not asking for a general. It was in your opening statement that you came up with this, that this was in this report because many parties, I'm just quoting what Dr. King said, many parties, I'm wondering who those many parties are that have put to you that copyright is a problem.
I'm happy to go back, look at the various submissions and put together a list if that is helpful, Senator.
Yes.
Yes, it would be helpful. It would be very helpful because in your report itself, it doesn't say that. You've got numerous sentences that assert that this is an issue, and you don't say who says it. And when I look at the list of who you have consulted with for this interim report, I don't see any of the collecting societies on here. I don't see the music industry on here. I don't see the screen industry on here. I don't see news organisations and those who create news content on here in terms of who you actually consulted with and the participants.
We have...
I'm talking on page 87 of your interim report. There's a whole list that you consulted, and the creative industries is glaringly missing.
Thank you for pointing that out, Senator. We've certainly engaged, and remembering that there is no recommendation in our report, we're simply saying there appears to be a problem. We have certainly had that determination that there is an issue here well and truly reinforced since releasing our interim report. We have had a significant amount of interaction, and as has already been pointed out, over 400 submissions in relation to copyright. So there clearly is an issue in this area. We have been consulting widely, particularly since our interim report, and indeed we will be having further consultation as we move towards our final report and decide exactly what we want to say in that final report.
And
so you consulted with Amazon for your interim report. You consulted with Treasury. You consulted with... you did consult with the Australian Copyright Council. You consulted with MasterCard, you consulted with Microsoft, you consulted with Meta, you consulted with OpenAI, you consulted with Xero. I mean, you consulted with Deloitte, you consulted with a lot of other players, but you didn't consult with the creative industries. And so I'm really interested to know who these many parties are who told you this was a problem. That you needed that there needed to be an exemption, or that copyright was an issue. So, I mean, I'm assuming you didn't write this report with AI itself.
Senator, We understand the concerns. Can I thank the committee for actually giving us time to discuss the concerns with you? And I can actually guarantee that the Commission's work has wide consultation, but we understand the concerns that have been raised with us.
So in the final report, you're now consulting with the affected industries?
We absolutely are, Senator. We've got over 400 submissions, and we have been consulting with a number of parties. As I said, we don't have a firm view on this, and it's been extremely helpful, the spotlight that you've put on the issues and your committee members. So thank you for affording us time.
Senator.
Could I just respond to Senator Henderson's comment about when the report went to the Treasurer?
Yes, please. Thank you.
The Harnessing Data and Digital report was sent to the Treasurer's office on 30 July, publicly released on 5 August. Our interim reports, it's standard practice for us, is sent to the Treasurer's office in advance, and it's only for information, and that has been the process of the Commission over a number of governments.
I'm not, Senator Henderson, if you've got a final question, otherwise we are going to need to move on. But I would like you to respond to the evidence that's been given by Mr. Lemphers here today, that there is no technical barrier to AI companies knowing where their information comes from and who ought to be compensated or asked for approval to have it used, that it's a business decision by these big corporations, not a technical one.
Yes.
Was that news to you?
No, we've in fact talked to Mr. Lemphers around this issue beforehand, and the issue of transparency is really quite interesting. So can the problems that we have relating to copyright and AI training be either partially or fully addressed through some form of transparency? Mr. Lemphers also noted that maybe we need to think in a different way if the training is occurring overseas. He suggested, I think, a 1% levy on AI companies. We've also raised that issue with parties that we've been discussing the matter with. There are a range of potential solutions which we're considering to make sure that we get the balance between the rights of creators in Australia and the benefits of AI training in Australia.
Dr. King, can I ask you what is the Productivity Commission's view of why copyright protections exist?
Copyright protections exist. They, in fact, go back to the invention of the printing press. What is the principle? The principle behind them is to offset the loss in value to a creator if their creative work can simply be reproduced and used without their permission or without due compensation.
And the Productivity Commission accepts that.
The basis for copyright law.
And the reason for it.
I'm a lawyer, so hopefully I've said the legally correct basis for copyright law. But yes, the Productivity Commission definitely believes that the rights of creatives and the rights of creative artists, the rights of the creative industry are fundamental to ensuring that we use AI properly and productively moving forward. We cannot have a situation where there is no incentive to engage in productive activity or creative activity because that activity does not give a due reward. Now, as Mr. Lemphers has already noted, it's incredibly hard to predict the effect on any specific
Dr. King, we are running up against the clock, and Senator Henderson has some final questions. Senator Henderson.
Thank you very much, Chair. Look, just to clarify, the quotes that I read out to you before, which was very similar to the concerns raised in your interim report, were actually from your opening statement. I do note I have asked for a copy of your opening statement. We haven't been able to get it, but I think your opening statement this morning is pretty contentious because you are... So again, and I would just, Mr King, ask you to directly address this question. So you have said it is not realistic to think that we can stop, and I'll read the full quote, the training of generative AI models and applications is already happening mainly overseas, where Australian copyright laws do not apply. Again, I would take issue with that. It's not realistic to think that we can stop this, so we are looking at policy options that help us navigate this challenge. So I'm going to put directly to you, what is not realistic about protecting the copyright of Australian creatives?
What is not realistic is going to a foreign jurisdiction and saying to them that they must impose our law on training of AI in their countries. My understanding is that would be against our existing international agreements around copyright law.
I'm not, sorry, Mr King, you're mischaracterising what I'm asking. I'm not suggesting that creatives would take Australian law and expect it to be applied overseas. What I'm saying is, for Australian creatives who make a very valuable cultural contribution to this country, and who slave their guts out to create original content, which is their property, and that's what I don't... Perhaps I'm concerned that the Productivity Commission doesn't understand. This belongs to them. Doesn't belong to anyone else. Doesn't belong to big tech. Doesn't belong to the Australian government. It belongs to Australian creatives. And people who create content, no matter what it is, books, plays, music, art, often they train and they work for very many years at very small salaries to create this content. And so what I'm saying to you, why is it not realistic that we would not look at ways to protect the work of Australian creatives, which is being stolen by big tech overseas?
Well, Senator, let me just read out the sentence again from the opening statement.
No, you don't need to. Mr King, I'm reading it out. What I'm asking you to do is address my question. We don't have enough time. Could you address my question?
I believe you're mischaracterising what it says there, Senator.
I'm reading it from... I'm sorry.
We should
Mr King, so I'm just going to stop you there. I'm reading from the closed captions of what your opening statement was. Now, the reason I'm reading from closed captions, which is a transcript, is because so far you've declined to provide us with your opening statement. So I'm not mischaracterising what you've said. I'm reading precisely what I have received by way of closed captions, which is a transcript of your opening statement. So again, I'm going to take you to the question, why is it not realistic to protect the work of Australian creatives, to protect it from being stolen in overseas jurisdictions, including by big tech, utilising their work on AI platforms?
Senator, what the Productivity Commission thinks is needed is a way to reward creatives for their work in an appropriate way. If our current copyright laws are unable to do that in their current form, then we need to think about how those... But
that's not...
hang on. Let me just do this, Sarah. So, but you are proposing a fair dealing exemption. Give me a break.
No, that's incorrect.
That is not the case.
No, that was one of the proposals. And that is what has so alarmed the Australian creative industry. You are proposing a fair dealing exemption. So you are proposing an undermining of Australian copyright law to give AI and the big tech organisations and companies overseas a greater ability to essentially steal the work of Australian creatives. Now, that is one of your potential proposals. And what I'm saying to you again is, why is the Productivity Commission not focused on standing up for Australian creatives rather than selling them down the river?
Well, Senator, that's your characterisation. As I said at the very beginning, we are very interested in exploring other ways in which creatives can be rewarded. We've been talking to people about collecting societies. We've been talking to people about licensing arrangements.
Could I, with all due respect, the summary questions that you pose in your interim report do not talk about how do we support the creative industries being rewarded at all. It is all about how would an exemption covering text and data mining affect the development and use of AI in Australia. It's not even how would that impact on the creative industries. How does this rip value off Australian artists? Not one of those questions goes to this.
A fair dealing exemption basically gives big tech the opportunity to use the works, the property of Australian creatives on the basis that it's fair dealing, on the basis that it's all okay, in other words. So you are... Nowhere is a Productivity Commission giving any confidence to the Australian creative industries that you care about their work, that you want to see them properly remunerated, and you do not want to see their work stolen by big tech overseas. So what about some proposals in relation to looking after our creative industries, as I say, rather than selling them down the river?
Senator, we understand the concerns, and thank you to you and your committee members for putting them so forcefully. As I said, we are consulting at present on some of the options that might be available, but we understand the concerns.
All right, can I ask you on notice, could you provide us with copies of all of the consultation briefs, all of the meetings you've had, all of the briefing notes and correspondence in relation to those consultations, in relation to any proposed remuneration or other models? If there was to be a fair dealing exemption, could we please obtain copies of all relevant documents? And I mean everything. And this committee is asking for all of those documents, and if they could be provided on notice to us within the designated period, please. Because I don't have confidence that you're standing up for the Australian creative industries. There's nothing in your report to suggest this. So if there's subsequent work which makes it clear that you are looking at remuneration models or other ways to protect the rights of Australian copyright owners, then we would ask for all relevant documents, as I say, correspondence, notes, briefings, advices, details of every meeting, and who attended the meeting and at what dates and location, please. Thanks, Chair.
Thank you. I just find it extraordinary that we're now hearing that the question you want us to believe you're considering is how we support creatives being rewarded, when the word creatives or creative industries or artists or content creators does not appear once in the questions that the PC is seeking feedback on. And it just says everything. So perhaps you've realised that you made a mistake, and that's fine. People make mistakes, organisations make mistakes, but it feels to me a very, very big gap to not have consulted with the creative industries and to not even be asking how they are supported in your questions for your final report. So with that, we'll leave it there. You've got lots of questions on notice. Senator Henderson has asked for a number of documents, and we look forward to receiving them. And good luck with the rest of your consultations today. Thank you.
Thank you, Senator.
Thank you. Mr Lemphers, thank you for your contribution today and your information. Very helpful in this ongoing deliberation. Thank you.
Thank you.
So we will now welcome representatives from the National Aboriginal and Torres Strait Islander Music Office. Now, I understand that we have Ms Flanagan on the line. There you are. We'll just test that you can hear us and we can hear you. could you give us your full name and the capacity in which you're appearing today?
My name is Leah Flanagan, and my role is I am the Director of Aboriginal and Torres Strait Islander Programs and Strategy at APRA AMCOS, that also oversees the National Aboriginal and Torres Strait Islander Music Office.
Great, thank you. Ms Flanagan, do you have a brief opening statement for us?
Yes, I do.
Okay.
I was going to introduce myself, but I've already done that. I'm coming to you from Larrakia country up in the far north of Australia. I'd like to acknowledge the land that all of you mob on there in Canberra. As well as the work with the National Aboriginal and Torres Strait Islander Music Office, I also manage a newly formed team that focuses on the registration, licensing and distribution of royalties for Aboriginal and Torres Strait Islander songwriters, composers and their communities. Through my work at APRA, I've seen firsthand the benefits of strong licensing frameworks that align with our copyright law. Whilst these frameworks don't yet account for communal ownership, they have supported significant growth in the First Nations music community over the past 5 years, particularly reflected in the earnings and the visibility of artists like King Stingray, Electric Fields and Emily Wurramara. And a focus on local content has helped drive their careers, especially through grassroots festivals and live music events that prioritise Australian-based artists. But there are also many areas where quotas and prioritisation, I can't pronounce things, could further enhance the discoverability of Australian music domestically, strengthening artists' foundations at home before they expand into international markets. It's an exciting time because we are sort of celebrating momentum and growth. And I would also like to acknowledge the work that the government is doing to establish legislation for Indigenous cultural intellectual properties, for fake arts and crafts. Within my role, I see a benefit to this in the music sector and the digital economy. And I would like to encourage the government to work with people like myself that are in this space to develop protections or propose legislation that can cover music and the digital economy. One of the reasons I mentioned King Stingray, Electric Fields and Emily Wurramara is that they're all examples of artists that create contemporary, innovative new works using their cultural intellectual property. Their languages, their songlines are from their communities, are being performed on the national and international stage, and their artists follow legacy that bands like the Warumpi Band and Yothi Yindi have forged to educate the world on the very unique experiences and the culture of Indigenous people from this country. All of these artists have had great commercial success due to a robust copyright and licensing framework that enables them to earn income as artists and music creators. These are artists with the utmost cultural integrity. They're very valuable to our country. The recommendation is suggested by the Productivity Commission that allows an exemption for data and text mining. It undermines the very cultural integrity that so many of us are working really hard to preserve. Otherwise, we risk enabling a new form of an old practice called carpetbagging, but on a digital and global scale.
Thank you. I'll go to Senator Gosh. Do you have some questions? Yeah.
I do. Thank you. Thank you, Chair. In terms of the proposed legislation that you referred to, are you able to just outline what sorts of measures you think would assist in preventing some of the harms that you've just identified in relation to the use of AI in the space of First Nations cultural and intellectual property?
Yes. So I want to make it very clear that I am not a copyright lawyer and I don't work in AI and tech. I work specifically with artists and cultural communities on their cultural content. What I see is an opportunity for us to, we have recognised that Indigenous cultural intellectual property has a value. We've put that value across multiple art sectors like the visual arts sector, and we also can see how much value it brings to the music community, the music economy. And so what I would like to see is collaboration and expansion of what that looks like to include music once it reached the digital form, because it is out there, it is released, it is on all the digital platforms, it is online, it is in circulation. So what actually are we doing to ensure that there is some form of universality. I know that's a very, very difficult thing to do, but I guess the knowledge that I have from working with these communities, and I work with so many other song people and creatives that can really feed into like a broader protections. I hope that answered your question. Sorry.
No, it did. And from the people who speak to you or raise concerns, is there a method or a model that would be culturally appropriate and suitable for, I appreciate speaking for a really wide range of First Nations groups, to try and prevent that use of material without consultation or informed consent before it gets out into the world or onto the internet, as you say?
Yes, there is. Education is going to play a huge part of this. The work that my team and I have done is, what's the right word? We have, with a fine-tooth comb, an analogy perhaps, gone through the processes that enable non-Indigenous creators to earn a living from their music. And we've seen the gaps that have held up our creators earning in a similar capacity. So we do have, it's enabling the registration process. So working with communities to go, where does this work sit? Is it of this type? Does it exist in the public domain, or because it is a new digital format of, is this within copyright? A lot of the education I do with Aboriginal artists is to talk about the word traditional. The word traditional has two separate meanings. Once you when you are a traditional custodian, you are a traditional person, but once that word translates over to a copyright perspective, it takes on public domain royalty free. So having really upfront educational conversations with writers to go, at first, does this work exist within the public domain, or is this like, does this exist within a copyright framework, or as traditional people and traditional custodians, or does this sit outside of that? And that's the process that we interrogate with all new works registrations, and also follow that conversation through to our licensing and distribution. How are we also enabling distribution practices for people to receive money? Yes. I can ramble, sorry.
No, I think that was a very responsive answer, so I appreciate that. I'm conscious of the time. Chair, I'm happy to share.
Thank you. Senator Henderson, have you got any questions?
I do, but
yes, I'm
could I? Sorry,
yep,
could I come
fine.
after you, Chair?
Yes, that's fine. Ms. Flanagan, could I ask, were you consulted by the Productivity Commission?
No. I made a submission in 2022. I'd have to confirm this, and I can forward it to you if you like.
Great, thank you.
To talk about the importance of Indigenous cultural intellectual property and what that brings within the broader legislation, and just giving it a value.
Yes. Were you shocked when you read the interim report and saw those posed questions around giving the exemptions from copyright?
Yes, very much so. I mean, to me, that translates to languages. It translates to, it translates to property that is so uniquely Australian and is unlike anywhere else in the world, and it is still often not valued enough by the broader Australian population as to what it actually brings to what our country looks like on a global scale. I know I'm always going to speak in heartfelt terms because I'm an artist at heart, but once again I have to bring it down to the fundamentals of the importance of language and culture and what it means to the health and well-being of people, and the fact that it has been undervalued for such a long time. And we are starting to see changes in perspectives across the communities as to what Indigenous culture, languages bring, what bilingualism brings to schools, to society. Like a bilingual society, a multilingual society is a really is a powerful thing. And these types of exceptions, now that there's so much of our language and culture in the digital space, the thought of that being yeah, it is worrying for people like myself and the people that I work with.
And so you weren't consulted by the PC for the interim report. Have you been consulted? Have they contacted you since the release of the interim report?
No.
Okay. And would you be willing to talk to the Productivity Commission directly if they asked you? For your...
Absolutely.
Are you surprised that there was no creatives on the list of participants of their consultation before they issued their interim report?
Yes, I mean, given the scope of the work, I am surprised. I mean, it is our content, it is the content of the creator that is fueling all of these tech platforms, and so our perspectives on, and so much of my work is is found the foundations of it is in consent, ongoing consent. I talk about this all the time to Aboriginal communities and people that want to use Indigenous music is the consent aspect of work. So much consent has been taken away from Indigenous communities across not just music and language and culture. So, to work so hard to get consent processes in there and to then, have those consent processes turned into licensing opportunities to enable a compensation, not reward, to artists would, it is... Yeah, it's disappointing once again. Sorry, I'm not in the room, so it's a little bit difficult to be focused.
Ms Flanagan, thank you for your evidence. I'm not sure whether Senator Henderson's got final question. Yep, Senator Henderson.
Ms Flanagan, thank you for your time this morning. Can I ask how you currently protect your works and how the Music Office actually operates to protect the works of Indigenous artists in this country?
So the National Aboriginal and Torres Strait Islander Music Office was originally started to represent the Aboriginal and Torres Strait Islander membership demographic within APRA-AMCOS. We've since rolled that out, and it is now an industry service to support music creators and the development of the music industry, because that's where there's a real strong need for that within the broader community. The work that we do now internally within APRA-AMCOS is, like I said earlier, we work really closely with songwriters on the registration processes. We work in education on breaking these constraints that previous registration processes put on Indigenous and innovative Indigenous works across all the multiple revenue streams through across royalties, the way you earn royalties. So much of our work really is in that granular kind of first in when the work gets in there, how are we interrogating that and how are we enabling an earning potential on that. I like to say that the work is where commerce and culture meet, and how do we enable it based on what people want, which is the other thing is, making sure that if people are ready to earn an income from their culture and their music and their language, that they are supported and educated enough to do so.
So what would a fair dealing exemption for text and data mining do to your artists? I mean, obviously it means that the work of Indigenous artists would be substantially undermined, but what is the actual impact, and how disheartening is that sort of proposal for you?
The impact is we are finally at a stage where we have such a strong licensing process. The technology that we've started to work with within the environment that I work in a PRO environment is we are interrogating every process to try and make sure that fair remuneration to Indigenous artists and their culture is enabled through our processes. We are seeing an industry want Indigenous artists on the global stage. We are seeing so much of our culture wanted on the global stage. We are seeing people have sustainable careers, and to think that a lot of this could be undermined, even putting a value on it. I would love to be able to put a value on what once we do, I will send it to you straight away. But just the value concept of what Indigenous music brings to this country. we are so close to being on an equal footing for the first time, and this is just another hit that's just come in to just kind of pull the rug out from underneath. I'm full of analogies today. Sorry, guys. I'm just a bit nervous because it's my first time.
No, you're doing very well, Miss Flanagan. So, are many Indigenous artists able to protect their or have licensing arrangements overseas? So it's not as if if they're operating on the world stage, they're able to license their music in overseas jurisdictions and be paid for use of their music currently?
Yes, but it starts at home. You know, everything starts here. What are we doing here? They're only as strong on the global stage if they're strong here. And what we've been able to do, you know, working with major publishers in this space is really, really unique. I mean, our culture is unique. So of course it's going to be unique, but it also means that it's it can set a global standard of what fair licensing looks like to Indigenous communities for fair remuneration. So, but yeah, we need to work on our home base first.
All right, thanks very much, Ms Flanagan. No further questions, Chair.
Yeah, thank you. Thanks, Ms Flanagan, for your evidence today and being patient for your time slot. So appreciate your time today. Thank you. We're just going to take a short suspension, 5 minutes, and then we'll be back with our next panel. Thanks, Hansard. Dan, ready to go? Great. I now welcome representatives of the creative industries. It's wonderful to have many of you in person today and also online. Thank you for making time for us and travelling to Canberra. Could I get each of you please to state your full names and the capacity in which you appear? We'll start with you, Mr Briggs, and then we'll go along the table and then we'll go back to our online witness.
Yeah, my name's Adam Briggs. I'm a Yorta Yorta man from Shepparton, Victoria, Wamba Wamba on my mother's side. I'm a musician, author, actor, writer, comedian sometimes. I'm an artist at heart and at brain and at wallet. I'm the founder of and own and run Bad Apples Music, a record label for Indigenous artists that for over the last 10 years has promoted sustainable careers in the music industry for blackfellas. I'm the founder of the Adam Briggs Foundation, which since COVID has supported Indigenous artists through delivery of grants for various art projects for established and new artists, and also the program Urik Burik, which is a Yorta Yorta word for tomorrow, which sources and releases Indigenous artists' music, from yesteryear, which maybe not had the opportunity to have an audience and or be on DSPs, like digital service providers. And yeah, like that's my thing. It's a focus on sustainable careers. And I'm an artist myself, so.
Great. Thank you, Mr. Briggs. I'm Ms. Rankin.
Thank you. I want to acknowledge that we're meeting here on Ngunnawal country, acknowledge the elders past, present, and the songlines that run through the country we're meeting on today. I'm a recording artist under the name Jack River. It's been my professional career for almost 13 years now. I am a writer, a songwriter. I'm a mother of an almost 3-year-old who loves to sing and dance and write stories herself. I am previously a music promoter. I've run 2 regional festivals in my hometown of Foster and Warramai country. I've been in this industry for over a decade and seen its contribution to our society and to the well-being of our society, also the value that it gives. Am I able to...
I think we'll just get everyone introduced and then we'll come back to opening statements.
Great.
Yep. I'm Dan McNamee. I'm a musician from Thirroul and Darawal country, New South Wales. Play principally music in a band called Art vs Science, and I also am a composer for screen and TV and put on events and things like that. Music's a big musician, in short.
Right. Yeah. Mr. Dempsey.
I'm Paul Dempsey. I've been a songwriter and music producer for over 30 years, from Melbourne, from Boonwurrung and Woiwurrung country. And we'll come back to opening statements, I guess.
Thank you. And online, Mr. Tataz.
Yes, hi. I'm Francois Titaz. I'm a music producer and composer from Melbourne, Victoria. I've had a career for 35 years.
Wonderful. Okay, opening statements. Ms. Rankin, are you? Is everybody doing one? Or yep, Mr. Dempsey. Okay. Yeah. All right. We'll start with you, Ms. Rankin.
Sure. I want to cut to the chase here. A text and data mining exception to the Copyright Act is not a technical tweak or a small change. It would be a fundamental dismantling of our copyright system, legalising the theft of Australian culture at scale. The creative industries contribute $63.7 billion to the Australian economy and employ over 500,000 people. What we're talking about here is really quite simple. Some of the largest companies in the world are asking for handouts from the Australian government. They want access to Australian culture and creativity for free. The AI sector is already thriving under existing copyright law in Australia, valued at $4.8 billion today and projected to reach nearly $300 billion by 2034, and that's just in Australia. Copyright hasn't slowed innovation, it has enabled it. That's why hundreds of licensing agreements have already been signed, from OpenAI's deals with News Corp, Time the Guardian, to Google's deals with AAP. The truth is simple. Technology companies are able to pay for licenses. They just don't want to. I urge this committee, do not legalise theft by allowing a text and data mining exception in our Copyright Act. Keep our copyright laws strong and clear, and ensure that Australian creativity, culture and cultural sovereignty are protected for current and future generations.
Thank you.
Sorry, Daniel McNamee here talking again. The raw ingredients for any sort of company are not free almost anywhere, unless you're sort of in a creative industry where you are making it yourself. A building company doesn't say, can we have the concrete for free, or the steel or the bricks. They have to pay everyone involved, which helps them make the value which passes on. So I think regardless of whatever value you can make from training these models, the raw ingredients, you have to pay for them. It should, just like any other industry. That's my little take on it for now.
A text and data mining exemption to the Copyright Act would amount to wholesale theft, robbing rights holders of the commercial value that copyright protection confers on their work, and robbing them of any agency over how their work is used and exploited. Tech companies want to act like respecting copyright is just too hard. Our rights seem like a lot of red tape for them. But the facts are that all of the necessary infrastructure exists to negotiate and license copyright-protected material fairly, and it's already being done all over the world. They don't need a free pass. It isn't hard. We can have exciting AI investment and a booming tech sector without pillaging our culture and selling out our artists. We can have both. It can be positive, even symbiotic, and it should be fair.
Thank you. Mr. Briggs, have you got anything extra to add, or are you happy to wait for questions?
No, I'm good. I feel like I got it off.
Yeah, great. No worries. And online, Mr. Tataz?
Yes, hi. Just a personal perspective from me. I'm a two-time Grammy Award-winning composer and music producer. And over the past 30-odd years, I've collaborated on some of the most recognisable Australian songs and soundtracks. Gotye's worldwide hit, Somebody I Used to Know, scores for the iconic horror film Wolf Creek, Baz Luhrmann's Elvis, as well as Leor's song Safety of Distance, which was performed at the Anzac Centenary Dawn Service at Gallipoli. I've been an APRA AMCOS member since 1992. I'm now an ambassador for them and work with them across their creative programs. I've built my entire career on intellectual property. From the first check I got in 1992, which was for $2.76, and now 33 years later, it's the majority of my income is from royalties, my IP. So as a creator, for me personally, I feel like I should control or have some control over how my IP contributes to AI development. AI trained on copyright works without consent creates unfair competition. And I think the true innovation builds on permission and collaboration, not appropriation. Thanks.
Thank you. We're going to go to some questions, and I'll start with Senator Gosh.
Thank you, Chair, and thank you to the witnesses for being here today and online. I'd be interested in your view on what a text and data mining exemption to copyright laws impact is likely to be on the creative industry in the future. If something like that came into place, what does Australia's creative industry look like a generation from now, 10 years from now?
I mean, it largely won't be there if you disincentivise people that they don't own their own work, and their work can be stolen and used for whatever purpose without them having any control over it, without being able to exploit it for their own gain. Even if it's just an ideological choice that they don't want it used for certain things, you're just taking away all of an artist's rights and all of their IP.
Yeah, it would take away the right for an artist to negotiate value for their work in that format, for that format. So by doing that today, you would be destroying any potential for future artists to gain value from their works in that format. We know that AI is it is the kind of format of our new economy. We've already noted that it's worth $300 billion today, this industry globally. In Australia, it's going to be worth $300 billion. If you decide to legislate a text and data mining exception today, you shut the gate on the creative industries to participate in that economy altogether.
I think as well, my small twist on that is that creatives have tend to have an innate urge to create, and will probably end up still making things in some capacity. But what you'll see is where there's already massive inequalities between the people who own the companies and the people making the music and whatever it is, that will just go bananas. Like if we have the $300 billion piece, we're looking at removing one of the economic mechanisms through which creatives can actually participate in the benefits of that. And we'd end up seeing just massive economic inequalities in that realm.
Yeah, to reiterate what Paul and Holly said as well, it's like with through the record label, with a focus on, sustainable careers, like what's sustainable about losing our art, music and culture to big tech and AI? Like what kind of incentive does it create, and what kind of example do we set for the next generation to enter into this, industry and, anecdotally as well, chase their dreams?
You can imagine a future where generative AI only has other generative AI to train itself on and compete with. It's like we can all just listen to algorithms competing with each other to butcher Stevie Wonder.
If we asked this question 10, 15 years ago when Napster was copying music and giving it away for free, good old LimeWire days for a moment there when we were in high school, if we said at that point, should we make people pay to access music? If we said no, we would not have the economies of streaming, licensing, YouTube, Spotify. The ways we consume music today would not exist. So you can reverse the clock and look at the same question that was asked when we went from Napster into Spotify, and that's the question we're asking today.
That's a good point to then ask. What do you think is the best way to ensure that Australian creatives get paid for their content in an AI landscape while maintaining the vibrancy of the creative industry marketplace?
Quite simply, it's licensing, like full stop. Full stop. The Copyright Act supports fair, clear licensing to happen at speed and scale. There are already licenses that exist globally and locally where music companies, record labels, collecting societies have licenses with LLMs, large language models, or technology companies at scale. It's really that simple. Same with the media companies. The licenses are already in play. They're already showing that it's possible and it exists. And to keep kind of going on from there would muddy the waters, because it's quite clear. We know how to license. Our data is very clear. It's very concise. We are ready to license at speed and scale with those technology companies who need the content to inform their models or do whatever they want to do with it.
It's inaccurate to suggest that there's all these barriers and obstacles. Like the current licensing framework and robust copyright law serves all the needed purposes.
It would be a good, the conversation hasn't been had about what those barriers are, and we know from our industry's point of view that there hasn't been any consultation or even questioning about what the barriers are. In fact, they already license with creative companies, so they know that
AI companies already license.
Correct.
Mm-hmm. Can we understand that a bit?
Yeah, we can reference licenses that already exist. particularly in the media space, it's extremely clear. OpenAI have a licensing deal with News Corp. They have a separate licensing deal with The Guardian and The Times. Google have a licensing deal with AAP. Merlin Entertainment have a licensing deal with 11 Labs. The list goes on, and we can provide this list as evidence. It's in the hundreds. These licenses exist already.
That would be helpful. I think everyone would appreciate that evidence or that list. Did anyone else want to add to that answer before I've just got one final question? No. It builds on something that you said a moment ago, Mr. Dempsey. I think Australian people would want to know if creative content is produced by a human or a generative AI model or an AI agent or somewhere in between in order to inform the choices about what they consume and what they choose to support with their dollars. I'd be interested to hear the panel's view on how that might be best achieved from the artist's perspective. How do we put in place rules that ensure that when people are consuming content, they know whether it's a human, an AI agent, or somewhere in between?
I mean, I think it goes to a wider discussion as well about general guardrails around AI to protect people from things like deep fakes and identity theft. And there's a lot of discussion to be had about transparency in AI from an artist's point of view. What data sets are they using? How do you even know if you've been part of a data set that's being used for training and things like that? So, it's. Do you want to add to this?
I'm not sure. I feel like in a way that's a question for the artist in terms of their honesty with their fans. Have I used AI in this or not? So I can't really speak to whether or how that can be enforced or whether it should. In fact, we just released a single with a music video which was made with generative AI in a way which I thought was still artistic and actually brought to life ideas which we couldn't have achieved otherwise. So I think we're for the technology if it can be used to help artists express themselves in genuine ways. But the most important part is that the data on which those models are trained is paid for appropriately.
Yeah, and that question you pose, which is obviously a separate issue and a separate idea, but if you allow a text and data mining exception in the Copyright Act, you open the gate to free and unfettered access to all content. So it removes the precedent to even figure out attribution if you're interested in attributing to content or if you're interested in understanding whether it's AI or not. So when you let those models train at scale, there's no transparency, there's no attribution. Those guardrails aren't in place yet, but they won't be able to be in place if you allow text and data mining to happen at scale. You just allow free, unfettered, uncontrolled, non-transparent, non-attributable access to content. So it will leave us in a really messy, sad, unfortunate position that we won't be able to roll back from.
Yeah, I agree. It'll be, much harder to get that genie back in the bottle once that, is done, because, you set a precedent that's okay. The technological evolution is inevitable, but, the inevitability shouldn't be at the cost of the artist and the integrity of the art and the artist. Our art and work should be valued and protected. Valuing art should be the cornerstone of the evolution of this, proposal.
And Mr. Titaz, I'm conscious that you haven't had any input. Did you want to add to anything that's been said?
Sure. I think there is a big danger to do with that, obviously, with attribution to do with it. The comment I'd make about this more broadly, it's difficult in music, I think, because it's so different to the way we assess other things to do with this. How and why I write music is spiritual in nature, and where it comes from as an act of creation is something that's beyond my understanding or knowledge. I couldn't tell you why I created something. In many ways, I don't have a coherent answer about any of those things. And I think that's a strength to do with the nature of creation and human creation. It's a very different thing to taking something that exists already and then using that with whatever modal input you like, to be able to say, I've made something that's like that. That is not an act of creation in many ways. It is. It has its nature to do with that, and I'm sure those models and will develop into something that's interesting. But the act of creation itself is something that I would regard as being a sacred human act, and within that, I think that it should be acknowledged that it is connected to the person who is the creator to it. So I think that's an important thing to distinguish.
Thank you.
Thank you. Could I ask, we had the Productivity Commission up earlier today, and in their opening statement to us, they said one of the issues being confronted in terms of Australia developing AI capacity, one of the issues was that data is protected by copyright. I mean, I just would like you to respond directly to that. Do you see that that in of itself is an issue or a problem?
Yeah, like why is it a radical notion that artists should be compensated for their work?
Exactly. But it's like saying it's an issue that I have to pay rent. It's an issue that I have to buy milk. It's an issue that we can't copy Microsoft's code and make $1 billion company ourselves.
Yeah.
They're all issues.
Yeah, I mean, it would be an issue for them if someone wanted to steal their intellectual property. It's, the hypocrisy it's hard to fathom.
Yes.
So it's saying your value is an issue to us. The fact that your work has value, that is an issue for us.
Because they're not writing the albums, they're not writing the plays and the things that we, the artists that we make and the audiences that we entertain. We're just an issue to that, just the red tape.
And what a heartbreaking notion to say that the blood, sweat and tears and the hard work of an artist or a creator or a writer, the tens of decades they might have put into something, is an issue.
The issue I have regarding this that isn't really spoken about is, Leah Flanagan did touch on it, is Indigenous IP and how we can be sure that cultural protocols are upheld about keepers of stories, who can tell the stories and when. Like, what kind of parameters do they have in place to make sure that the cultural safety is paramount when it comes to Indigenous IP?
And we know there's been a long history of stealing Aboriginal generated work, or we've got an issue with fake Indigenous work, and you just need to walk down any main street in any city and walk into a souvenir shop and see souvenirs that claim to be made by Indigenous communities that are made in China or made in Indonesia.
That's what gives them a licence, right, to create those dodgy boomerangs.
But it should be noted that a text and data mining exception would apply to all First Nations culture, art, creativity. So not only are you talking about Australian copyrighted content in itself, you're talking about First Nations content, creativity, culture, stories, art. You would be giving a free unfettered access to that content as well. And we haven't heard about that much today either, but the Australian government would essentially be legislating free access to First Nations culture for AI companies to train their models on. It's an abominable proposition.
Could I'd just like to put some other quotes to you that from proponents of this exemption. And in saying so, I just want to put on the record that we did invite both OpenAI and the Australian Tech Council to appear today. OpenAI didn't even see fit to respond to our request, which I think says everything. And the Tech Council didn't have anybody available today. As the committee, we will consider what we do. We have the powers to subpoena witnesses, and we will consider whether that's the action we take, because I think these voices are important in this conversation. And the chair of the Tech Council, Scott Farquhar, has said, and I quote, "These copyright laws are a barrier to AI companies training or hosting their models in Australia." So he's directly saying that the copyright laws as they are a barrier. Have you had any consultation, any discussion, any engagement as artists with the Tech Council or indeed Mr Farquhar?
No, I've only read him in the newspaper erroneously stating that that America has a text and data mining exemption when they don't, and it's far from settled over there. He had that wrong.
To our knowledge, the Tech Council haven't requested any formal consultation with industry bodies in the music industry. We're not aware of any. I'm not aware of any. Same with the major technology companies who have come out in support of a text and data mining exception. There has been no consultation or outreach to our peak bodies that, well, I'm certainly a member of, APRA and ARIA.
So the license, I mean, there are collecting societies and licensing organisations that already exist. Just kind of step it back a bit, because those purporting that that copyright law is a barrier seemingly want a view that it's near impossible for a tech company to go and find who you are, Mr Dempsey, and get a deal with you, pay you for your work, and then also find you, Mr Briggs, and pay you for your work. And Ms Rankin, you know, how would they know which work is yours or not, that it's all that complicated? But your work is already licensed and covered by bigger, broader licensing agencies. So it's not like they're dealing with the individual artist if they were to follow these rules.
That's correct. It's very easy to approach those bodies for licences or those companies for licences, and in fact they can use their own tools like ChatGPT to ask that question, and it will tell you very quickly.
APRA AMCOS's function is to provide those licences. Larger companies, such as big streamers like Netflix and so forth, have deals where they have a percentage of their income as a licence fee that they provide through. And that's the very function of APRA, is to provide that as a body for all the individuals, the 124,000 members that they have.
Mm. No.
Well, the question I would ask is, like, he's presenting this as a barrier, the copyright law, but what do we get as artists by removing that barrier?
He hasn't even walked up to the barrier to understand what it looks like. There's been no conversation. So, yeah, it's very easy to, like, anyone, if Scott wants to do anything, it's very, like, it's stupid to even have the conversation. You can Google that in like 20 seconds and ask how to get a licence off a collecting society, a record label, ARIA or APRA. And if they're worried about going on Google or using ChatGPT, they could ask Spotify, they could ask YouTube, they could ask any of their fellow technology companies how they already license.
And there are other, third party sort of lower level companies popping up who are, their mission is to facilitate these connecting AI companies with data sets, but done the right way.
Could I go back to the point, and I think it was you, Mr Dempsey, said this was wholesale theft. And it seems to me that in any other sector, if you were to create a product, if you're the manufacturer of a product, you need to have a list of what those ingredients are, what it is that you need, what other services you need to engage to provide that product. You pay your you pay the people to do the work, so you've got salaries, you've got ingredients or components that you have to pay for. You then have to pay for, the assembly. You have to pay for the administration. I mean, there are all these things that go into creating a product that you then sell. It seems that what these big AI companies want is a key component of their product or an ingredient of their product for free. So if you were to, be a baker, should you have access to free flour? Should you have access to free butter? Should you have access to free rent by which to sell your baked goods?
Yeah.
And is it as simple as that?
It really is. It just doesn't make any sense. It's like Dan said, you're a building company, you don't get your bricks for nothing, you don't get your materials for nothing. It's just kind of ludicrous. It really is that simple. It's especially when it isn't an obstacle or a barrier. The frameworks exist to do direct licensing deals. It's not that hard. They're pretending that it's all this gigantic red tape, and it just isn't. They just don't want to play fair.
How did you feel about the Productivity Commission's interim report? Because when we had them in front of us today, frankly, it sounds like they've changed they're backpedaling. Because their report clearly says that the barriers are all about how you let these tech companies, big global tech companies, mine for data and information by which to build their systems, how to make it easier for them. There's not one reference in the questions they're posing about creatives, about supporting creatives, about what the impact this has on our creative industries. And yet the PC today told us that what they want to do is find a way to ensure creatives are rewarded.
They haven't asked.
They haven't asked.
They haven't consulted. We haven't heard from them. To my knowledge, the collecting companies and industry bodies haven't heard from them, and they were forced to admit this morning that they haven't even done any economic modelling on what the impact of their recommendations might be. They didn't even know the value of our creative industries to the economy. I think they did a better job of undermining their own credibility than we could.
Would you be prepared to sit down with the Productivity Commission and tell them what this really means for you?
For sure.
Absolutely.
Yeah, definitely.
They've written a proposition around our industry and the kind of critical legislation that safeguards the value of our industry. They've made a proposal to the federal government about the thing that means we have a career and an existence, and to do that without consulting our industry and our peak bodies is again quite shocking. And if that was to any other industry, you can see the kind of problem that would cause for any other industry if you apply it. So,
could I ask today, ahead of this hearing, some of the media commentary from the Tech Council and those pushing that copyright is a problem and they want an exemption, is that perhaps an opt-out option. It seems to me that the only option there is to opt out of not being paid. What are you opting out of?
Well, that is ridiculous. And to continue my building analogy, it's like getting bricks is hard because there's a fence between us and the brickyard, and we have to pay for it. It's like saying, if you make it an opt-out thing, you're saying build your own fence again, basically. You have to go and tell them not to steal your stuff, which is also like...
But even if you're opted in, they're not proposing to pay for it.
Well, yeah.
That's right.
Yeah.
So you can opt in to give your work away for free, or you can opt out for not giving your work away for free.
Yeah.
Yeah, we're asking them to opt into licensing. Do they want to opt out of that? Like, the opt-out concept has been tested in Europe, or it's alive in Europe right now, and it does not work. The actual technology that they propose, called robots.txt, a site you're meant to go on to opt out, it's been proven that it does not work, and it's an absolute mess in Europe for not only technology companies but also copyright holders. So you can look at hard evidence from around the world to show that that does not work, and any person can imagine the mess of that kind of system, opting out.
Also, just the fact that there is so little transparency around their data sets anyway, that you sort of be like a leap of faith to believe that you had opted out. How could you really even be sure? As Holly said, the system over there has proven to be a mess anyway, but it's also opaque what the data sets are. There's no transparency around any of it.
What about artists that don't understand what they're opting in or out of? Like, what kind of education is going to be presented, for those artists? There's artists that have trouble getting onto DSPs at the moment, like, that's a pretty big step to take, and a pretty, cornball offering to be like, oh, you just say no.
And in an opt-out system, you're pitting individuals, single Australians, against global billion-dollar companies. And the fervour and the speed and the money behind their systems to scrape and move at speed, you're putting that force against an individual, and in this proposition, against an Australian citizen. You're putting the burden on them to opt out and fight for their right to their content somehow. It's, again, quite preposterous, the scale of that proposition. For Scott Farquhar, a billionaire, to say, hey, little individual artists, you should opt out against our billion-dollar machine.
Yeah, they're making us do more labour for them. Like, how does that work? How does that benefit us? How does this whole thing benefit us? At what point?
And I can imagine that Mr. Farquhar wouldn't be wanting his intellectual property being given away for free.
Might be an issue.
You wouldn't be a billionaire if you'd given all your work away for free, would you?
Well, he should just opt out.
Exactly.
All right, Senator Henderson.
Thank you, Chair, and good morning to you all. Thank you so much for your time today. I just want to ask firstly for your response to what the Productivity Commission told us this morning, and that is, in proposing one of the so-called solutions, that the Copyright Act would be amended to include a fair dealing exception that would cover text and data mining. The PC Commissioner said the training of generative AI models and applications is already happening mainly overseas, where Australian copyright laws do not apply. It's not realistic to think that we can stop this. What's your response to that statement?
We couldn't be bothered.
We couldn't be bothered.
That just sounds like what they're saying.
We don't care. We don't care about Australian artists.
But they admitted themselves they don't even understand the value of it. They haven't looked at the value of it to the economy. They haven't modelled the impact of their suggestions or recommendations. They're completely ignorant of what it is they're willing to just let go.
I'm pretty sure Dr. King also said he was their stance would be to wait and see how to reward artists or down the track. And
well, the Commission is certainly going to consult, but the interim report gave very little confidence that they showed any care or regard for the ownership of your work.
No.
And the fact that it's actually your property, not theirs or not anyone else's.
That's the thing. I just think they just fundamentally don't seem to understand what it means to own the intellectual property and the copyright in what you've created. I just don't think they can. It doesn't seem like they've wrapped their heads around that at all.
Senator, to your question, can I just say what your question there was about the Productivity Commission saying that we can't create laws in Australia that are different to, that essentially saying that because of laws in America, we can't protect content in Australia. We are sitting here in the Australian Parliament House. Our government should be creating laws for Australians and for our jurisdiction and activity in that jurisdiction. So it doesn't matter what happens in any other country and on any other topic. That is, again, quite a ludicrous idea that we should be copying laws from other countries just because they happen in other countries. So I just want to make sure we're talking about Australian law here today. We're talking about Australian copyright law that protects Australian creators, our culture, our creativity and our economy here in Australia.
So this is a government-commissioned report, commissioned by the Treasurer, Mr Chalmers. What do you say to the Albanese government in relation to the erosion of your property, of your rights, of your copyright? Because we're seeing a very muted response, frankly, from this government.
Do your homework.
Yeah.
The government hasn't taken a formal position on this, and we acknowledge that. But this is an existential issue for our industry. So not only do your homework, but please rapidly consult with our industries. It's not, again, like we've said, it's not a small issue at all. This creates an existential precedent that could absolutely destroy the future of our industry. So we'd like to be consulted rapidly, and we would like proper economic modelling to occur.
But can I put it to you that it's the responsibility of this government to give you the assurance right now that your work, your copyright, your life's work in many cases will be properly protected. You should not have to worry for months and months and months, potentially years, worrying about the protection of your work, surely.
Correct. We would absolutely love that assurance.
Yeah.
Mr Tetez, have you got anything to add to that?
Two things on the points. Just going back to the previous point, copyright law around the world is different in every territory. Every country has its own copyright laws. Australia's are different to the United States with it. I don't think the Productivity Commission sort of understands how copyright law works in Australia or what it is. And maybe that's a little bit of work they need to do to be able to get their head around what they're trying to do. With the point of the government now, for me, and I'm sort of making this as a personal point for me, because my entire career is built on intellectual property. It pays my mortgage, pays for my 3 daughters, and so forth. And so for me, it's built into my planning for me, because we are on shaky ground with this. I am now having to navigate what I do with my intellectual property. Do I sell it? Do I exit it? What do I do now to be able to make sure that I'm secure as I get older, as it's a major central investment in my life? And I think, I'm certainly not alone in that as a creator, but this is what I've built my life on. This is central to, and IP has enabled me to do the work that I've done. None of it would have been possible without there being IP attached, because I didn't get paid, or I have paid to be part of these projects. So IP is the thing that actually fuels my ability to have a sustaining career. So that thread is something that's really fundamental to me, and I feel on a daily basis.
Mr Tetez, I'm a big fan of somebody I used to know, so congratulations on all your success. I actually just put into ChatGPT if there was a tech and data mining fair dealing exemption under the Copyright Act for a song such as Somebody That I Used to Know, what are the consequences? And they are very serious. So this would allow the mass copying for AI training. This would allow the generation of derivative AI songs. So that's songs that would mimic the sorts of sounds that you have created, the very unique sounds that you have created, which has, of course, happened to other artists. That would mean no attribution or no royalties and the undermining of future licensing markets. So the consequences are dramatic, aren't they? And even
yes,
ChatGPT recognises that.
Well, you've got to praise that. Incredible. I did know that already, though.
Yeah, no, I'm sure you did. I mean, this is what I find extraordinary about this proposal. It doesn't seem, the Productivity Commission doesn't seem to have taken any regard of the fact that this is property owned by artists in this country. But I am a Liberal senator, but putting all of that to one side, I am deeply concerned that this government has not been sort of screaming this from the rooftops, that we will not allow your property to be stolen, either here in this country or around the world. There are very established ways in which you can protect your property, that you can gain remuneration through licensing, that you can exploit your future, and also that you can invest in your future. And I just find it extraordinary that you are left in no man's land while, you know, this process is playing out.
We're trying to future-proof our industry. Like, that's like, nurture your artists. Like, otherwise, like, it goes away.
Of course.
Yeah, and like it's actually like it's good for everybody, AI companies included, if you continue to incentivise and nurture artists into the future, you know, and negotiations and licenses can be done between the AI sector and the creative sector that are mutually beneficial and you know keep artists going, you know.
Albo's
so can I just ask?
Might look a whole lot different.
What's that?
Albo's DJ sets might look a whole lot different in 10 years.
So have you received any guarantees from the government that it won't allow big tech to scrape your work through AI platforms without fair compensation?
No, there's been no guarantees. No, there's been no formal position statements or guarantees from the Albanese government just yet. So, yeah.
And meetings. Have you been able to get in to see anybody in government?
Some ministers have met individually with peak bodies, but it's been tough. It's been hard to get meetings on this issue, even for the kinds of copyright holder groups that are, you know, interested in
Can
this
I just
issue.
put to you that is not good enough.
No, it's
when
not
something
good
as
enough.
alarming as this is handed down, that is not good enough, that you are left in this terrible position of not knowing whether your work is going to be stolen or not, sanctioned by this government. Mr. Tataz, did you want to add to that?
Yes, I've had a meeting with Tony Burke about this, and it's been expressed pretty clearly to him. So so these concerns are part of the conversation. They have been raised very firmly.
And so, what could you tell us about that meeting with Mr. Burke?
Well, it was to put forward positions around art, but certainly it was also around expressing this ideas around IP. So and the things we've been talking about today. So they have been expressed, yes.
And did Mr. Burke give you any reassurance at all? What did he say?
He's certainly very much on the side of the artist. So that's the way that felt, and he expressed that. Yes.
So did he give you any guarantees that this TDM fair dealing exemption would not be a part of the government's plan?
He didn't give guarantees, no, not to me, no.
I would put to you that those guarantees are absolutely critical and that the government needs to do that now, not in next month or December or next year. What do you have planned further to ensure that your voice is properly heard? Do you have any other... Are you seeking further meetings or consultations, protests? Anything? Do you have anything further planned in terms of your advocacy?
I know that I can speak for the music industry, the recording industry. The recording industry and artists are eager to meet with governments and the ministers responsible for looking at this. And we are absolutely here for all of the consultation and conversation that needs to be had to get this right. And we know that the government values workers, and we know that the Parliament values workers and creative culture in Australia. So we very much hope that that our concerns are heard and the right decision is made here.
Thank you. Thank you very much. No further questions, Chair.
Thank you. Senator Pocock.
Thank you, Chair. And thank you all for being here today, and thank you for the huge contribution you've all made to our country. Senator Briggs, could a generative AI tool currently make a sort of fake Briggs track?
I doubt it very much. I don't think at the moment, AI understands what a lounge room in Shepparton, Victoria smells like. It's like the innate human quality of the art and the authenticity that, we strive to create, that our audience strives for and expects from us as artists. And, quite simply, all we're trying to do is future-proof that to make sure we have sustainable careers, not just for myself, but for the next generation of young blackfellas from Shepparton, from Wagga Wagga, from throughout the country, and that is like paramount to our art. We spoke about this, earlier with Senator Hanson-Young. It's like, it's the equivalence of seeing a boomerang in an airport, that's been mass-produced. It lacks authenticity, and that's why you don't pick it up. The things we make are steeped in authenticity. It's steeped in our heart. It's steeped in our knowledge and our experience as blackfellas, as Australian artists, and you can't replicate that.
And so, I guess, talking about your iconic Shep Life album, which I've read, you said was basically you just talking about your experience of growing up in Shepparton. Say an AI tries to recreate that sort of album, what are Australians missing out on without the real life experience of it?
Well, for me to look back at that, it's not so much about what the rest of Australia looks back on. When I do things, it's for home. When I make these things, they're for home. They're for kids that grew up in Shepparton and other, rural cities, gateways or whatever, like myself. So it's about them, and, big tech can't replicate that, and you miss out on inspiring a whole new generation of young artists. But it's not just about the artists, it's about seeing someone from their area achieving something that hadn't been achieved before. So opening their scope about what they might be able to pursue. When I made Shep Life, I was very much still in Shepparton. And, I make my albums like a time capsule, and that's what it was, and that's what it is. And, AI might be able to replicate something like it, but it won't be it. And my audience will smell that, but also if AI replicates it, what does AI inspire?
And what do you get if AI is if there's AI music inspired by Briggs on Spotify, you don't get any sort of revenue from that?
No, Spotify. I think we should be, like I said, like the evolution of technology is inevitable, but this should be and should remain a tool. Artists should still be at the forefront, especially in here, like when they're talking about, copyright laws in other countries. The United States is a huge economic market comparatively to here. So different rules are going to apply. You can't apply the same rules to here. It will decimate us.
You mentioned Indigenous IP and cultural protocols. What faith do you have that Sam Altman and Mark Zuckerberg will abide by cultural protocols without a government actually forcing them to do that?
Oh, even Scott, very little. Zero.
Thank you. Mr. Titaz, earlier you talked about, I guess, the creative process and creating music, art as a sacred human act. Can you maybe talk a bit more about, I guess, what's at stake here if we are at the point where it seems to me we're hearing this kind of language that's been well ventilated, where you're all kind of just seen as a bit of an impediment to this new future where AI can do it all and it will be better for GDP?
Yeah, this is the music and the music business and where they meet. And it's always a very awkward marriage, these two things. The act of creation, the act of what every artist does, makes something, And then at this point where either you as the individual, as the artist, are wanting to exploit that in some kind of way, share it with people, or other people are helping you as part of that, it's always a crunchy spot. Historically, it always has been. The history of copyrights like this, when it's related to the printing press, that's when copyright first started in music. I think the divergent place here is that the threat of this, the business of it, the money of it, really then can affect or start to really infringe on that very central thing to music, which is about what Briggs was talking about, self-expression, authentic self-expression. And it's the relationship of music to you as an individual and your identity. It's something that can be quite, for a lot of people, it's very private, or it can be very public. But it is central. I sort of regard it as an invisible lever in society. It says a lot of things that you can't possibly say or whatever in different ways. So it's a very important part of our culture. And I think this is why this is so difficult to say there's now going to be something else that's going to somehow replicate that and make versions of that for monetary ends, not done for expression ends necessarily in that way. So, it's a very tricky area is what I'm trying to say, to be able to make those two things sort of meet up and make sense next to each other. Yeah.
Well, thank you. And then maybe just one I'm keen to throw to the panel at the end and maybe get any thoughts. Is one of the things that's been put to me is, well, AI may be able to create music that then can go up on Spotify and your streaming platforms, but it can never replace the live experience, the live, performance that people want to see. But as artists, as small businesses, can you maybe talk about how connected it is and what this would potentially mean for future artists and how you actually become a household name and how live performance fits into that?
I think that, if we just leave the copyright laws as they are, it actually could represent a nice extra little income stream for artists. But every month or quarter or so, we get a check from APRA, and you're not expecting it because it's not big enough for you to rely on, but it goes, oh, this is good. Okay, that's rent for a couple of weeks or whatever it might be. But as generative AI becomes more and more commonplace, that is now watering down the streaming pile. It's because you get a share of the big of whatever's played. More and more AI goes into it, means your share gets smaller and smaller. At the very least, maybe the stuff that it's trained on, you might get paid a little bit for it. So, it slightly balances that out. So that's one thing. For us, at least, right now, live performances are our chief source of income, and they can't mess with that because a bunch of fellas playing everything live. But yeah, having a bit of extra money coming in to help us print some vinyls or get our guitars repaired or whatever it might be, that's kind of helpful, and they even want to take that away.
Can I just... you're not a charity.
No.
You're not asking for some money to come in to help pay for it. You are asking to be paid for what you have created.
Yeah.
For the work that you have done.
And just to hold on to the rights that we've always had.
Yeah.
That there is just no good reason to have removed.
But growing a career means people need access to your music, right? Right now, a lot of people access through streaming, etc. That will change. Everything changes. We're moving into generative AI. A lot of people consume or get their information from large language models. In the future, they might say, hey, ChatGPT, play Chef Life. If you remove our access to that next iteration of the general economy, general consumption, you remove our ability to grow engagement with original music and human-made music and Australian music. We can only play to 10,000 people at Splendor because, a couple of 100,000 people stream our music every month, or Triple J plays our music, or whoever plays our music. What we're talking about here is removing our ability to engage with and put our music on large language models, have attribution on those large language models, it will completely dilute and destroy the consumption of Australian music. So we won't be able to grow our audiences and grow our careers if you remove us being able to be paid for what we do in these new formats.
Exactly what you said, Senator Hanson-Young. We are participants in the economy. This is not a charity. We're not here asking for handouts. We're here asking to remain participants, you know, and with what Senator Pocock, you know, put to us, it's hard enough right now for artists in precarious positions with, you know, 1,200 odd venues closing just in New South Wales, festivals falling over. They want to deliver another blow to our IP, our intellectual property. Like, at what point, you know, is it still viable to be an artist?
And it goes back to the Napster into Spotify analogy. Again, if you went back to that moment in time and said, no, artists don't need to be paid for their content, you don't need to license this content on streaming services. If we said that, we wouldn't have careers. We would not have careers here today. So if we allow text and data mining to occur today, the artists sitting here in this building in 10, 20 years, actually I should say there likely will not be well-known Australian artists sitting here in this building in 10, 20 years. So looking at what we're saying to future generations, my daughter, for instance, who's 3, I don't know if I can tell her she can be a singer or a recording artist, or if she can be like Taylor Swift or Jack Ripper, because I really don't have assurance that we're putting protections in play, or we're protecting the existing protections that are here right now. So the question is that large.
I think like the other question I would have is if they are going to text, you know, data mine, are we then lumped in as Australian artists with a global network of artists that have been mined? Like, how do we maintain our identity?
Our cultural identity.
Within that model.
Yeah. We are going to have to move on to our next lot of witnesses, but really appreciate your frankness today and your first-hand experience, seeing as it is your work that is being purported to be taken for free. You know, your voice is absolutely important in this conversation. So thank you, everybody.
Appreciate it.
Thank you, guys. Thank you, Katie.
Thank you.
I will now welcome representatives from the music industry, the Australian Recording Industry Association, the Phonographic Performance Company of Australia, the Australasian Performing Rights Association, the Australasian Music Publishers Association and Australian Music Centre. While you're all getting busy to take your seats, we've got a few witnesses online as well. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. For the Hansard record, I need each of you to give us your full names and the capacity in which you're appearing, i.e. who you're appearing for. And we'll start with our in-person witnesses. We'll start with Ms Morris and then move along the table.
Hi. Thanks for having us here today. It's actually a pleasure to be answering your questions today. I'm Jenny Morris, I'm the chair of APRA, and I'm also a singer-songwriter.
Great, thank you.
Morning everyone. Dean Ormston, CEO from APRA AMCOS.
Thank you.
Annabelle Hurd, CEO of ARIA and PPCA.
Damien Rinaldi, CEO of the Australasian Music Publishers Association Limited.
Great. We'll go, I can't read all of those, but Mr Appy, or AP?
Tushar Apte here. I am a producer and songwriter from Australia, currently based in Los Angeles.
Thank you. Ms Yeo?
Hello, thank you for having me today. My name is Caitlin Yeo. I'm an APRA board member, writer-director board member, and also a screen composer of over 21 years and a songwriter. Thank you.
Great. Mr. Maguire. You're on mute, Mr. Maguire. There you are.
That's better, I hope. Thank
Yeah.
you. Marshall Maguire is my name. I'm the chair of the board of the Australian Music Centre and also a harpist and an arranger.
Mr. Rinaldi.
Yes.
Oh, you've already done yours. Sorry. Apologies. There's quite a list here. Mr. Goff. You're on mute, Mr. Goff. There you are. Go ahead.
Sorry, there's a delay. Jamie Goff, Managing Director of Concord Music Publishing and Chair of AMCOS and Board Director at APRA.
I think that is everybody. All right, great. Quick opening statements. I imagine each of you have prepared something for us, so we'll just try and keep it as short as we can so we can get to some questions. And we'll start with Aria and Ms. Hurd.
Thank you, Senator. I'm the CEO of ARIA and PPCA. We represent Australia's record labels, recording artists, producers and distributors, telling our nation's stories and comprising a major part of the copyright industries. I want to start by saying don't be persuaded by the rhetoric that you've heard exclusively serving global tech giants. In fact, music licensing, and for that matter all creative licensing, has been solved in this country. Spotify, Apple Music, YouTube Music, Netflix, hyper-successful modern platforms that license music and are built on current copyright law. And there are numerous examples of AI licenses for music use, which have already been mentioned today. These companies aren't seeking an exemption because they can't afford to pay or because it's too hard. They just don't want to. Yet the Productivity Commission is considering a text and data mining exception that would upend this working market. And getting this wrong risks everything. Even the smallest decisions made right now will have a measurable impact on the value of our creative industries and their future viability, and it will happen fast. A TDM exception would wipe out licensing markets, losing potentially $500 to $600 million annually for Australian creators. It would trigger market collapse. It would legalise theft of Aboriginal and Torres Strait Islander culture, destroying cultural sovereignty. Without copyright incentivising creation, we face erosion of Australian content itself. And for what? The claim this drives productivity is false. The digital economy, and in fact the entire technology industry, is built on intellectual property, patents, trademarks and copyright. The United States leads AI investment with $109 billion in 2024 without a TDM exception. And countries with exceptions have not seen the promised investment. This is an existential moment that will send a clear message to Australian citizens and those around the world. The message will be who we value and who wins from AI. We either protect the rights that sustain Australian creativity or watch our cultural output get strip-mined. The path forward exists, the foundation is correct. Protect copyright, enable licensing, value culture and creativity.
Thank you. AMCOS? APRA AMCOS?
Thank you, Senator. Thank you, everybody. I'll make some complimentary comments and just to acknowledge the comments that have been made by industry colleagues and APRA AMCOS members earlier today, in particular Leah Flanagan from the NATSMO, National Aboriginal and Torres Strait Islander Music Office. Just to contextualise, APRA AMCOS has 124,000 songwriter, composer and music publisher members across Australia and New Zealand. And our members are watching what might be the largest intellectual property theft in human history unfold in real time, globally and locally. And in terms of Australia, to put that in perspective, undermining what we would say is a juggernaut Australian music industry worth around $9 billion. APRA AMCOS is connected to the international collective community through CSAC, which is the International Confederation of Societies and Authors and Composers, and I'm chair of that organisation. This argument shouldn't be pitched as technology versus creativity. It's about recognition and compensation. It's about multinational corporations extracting Australian culture and with absolutely nothing in return. The narrative that copyright protections are blocking AI innovation is not just false, it's a complete delaying tactic. If there's a real concern about productivity from the perspective of the Productivity Commission, then let's be clear where it sits. It sits with tech companies' refusal to engage with established licensing pathways, and that's the real barrier to AI innovation and productivity in Australia. Australia has a Copyright Act that is fit for purpose, and it supports a world-leading licensing framework. These deals are everyday business for us. It's what we do every day of the week. We've successfully navigated every technological disruption that has come before, so the solutions exist. What's missing is quite simple. It's a phone call. The AI tech doesn't need an exemption, they just need a licence. Creative content is and will be the single most important ingredient in the development of large language models and generative AI services and outputs. And just the final point to make here is that obviously creators are not tech Luddites. They are early adopters of tech. We did a survey last year of our members and we had 4,000 of our members respond in 3 weeks around their use of AI, the fact that it is a tool. There's people who have made comments today already around how powerful AI is as a tool, and the position that we have put in submissions and public statements to the tech industry is that we want tech platforms, AI tech platforms, to be successful in Australia. We just want creators and owners of creative IP to enjoy in that economic dividend. So I'll leave it there. Thanks very much, Senator.
Thank you. Mr Rinaldi?
Thank you. So just to provide my context, AMPAL, or Australasian Music Publishers Association Limited, is the Australasian peak body for music publishers. It's part of a broader group called the International Confederation of Music Publishers, a global body of which I'm also a global board member. I read an interesting quote last night from the Chief Executive of the Tech Council of Australia in the Sydney Morning Herald. He said, "The TCA is hopeful Australia can find a path forward on copyright that allows AI training to take place here while also including appropriate protections for creators who make a living from their work." From AMPAL's perspective, that path can be readily found in licensing. Every one of our 50-plus music publisher members does it, as do APRA, AMCOS and PPCA, every day. The Productivity Commission proposes, obviously, a TDM copyright exception. For context, the last copyright exception brought into law in Australia related to access by persons with a disability, clearly an exceptional special case. A TDM exception, however, isn't so exceptional. The issue it seeks to address can be fixed by licensing. As for the idea of an opt-out compromise, that's like your home being overrun by complete strangers, and it's on you to have to ask nicely for them to leave. No songwriter or publisher should have to grovel like that for their own songs. It's un-Australian. So our recommendation is clear: licensing, yes; exceptions, no.
Thank you. Mr Maguire.
Thank you, Senator. Yes, I've been the chair of the Australian Music Centre since 2021. The Australian Music Centre this year celebrating 50 years as a national service-based, not-for-profit organisation representing over 1,000 art music creators with over 1,200 members. Just to give an outline of what we do, we provide publishing services for independent creators, for aggregation services for art music record labels and publishers. We create unique educational resources with our artists' music, and all of which are utilised in classrooms around the country on a daily basis. We provide a multitude of professional development opportunities and hold an unparalleled archive of contemporary Australian art music not available anywhere else. We advocate for our creative art music community. In doing these things, we amplify innovative practice within our sector to a global audience. We enhance participation and, importantly, increase awareness of Australian music. Alongside our colleagues, we stand firmly in rejecting the Productivity Commission's proposed text and data mining exceptions for AI training. These would legitimise, frankly, the wholesale theft of our composers' intellectual property, the very foundation of their creative livelihoods. And it seems to us that existing copyright laws appear to be robust, and we support a continued respect for and compliance with these laws. We do note with some optimism that since the publication of the report, the Treasurer has stated that the government doesn't have any plans to change or weaken Australia's copyright arrangements, and we certainly hope that's the case. The committee asked for reflections on taxation implications, I think, coming out of last week's tax summit. I don't know if that's relevant to this hearing today.
Not for this hearing. We have said that it's a subsequent hearing. We'll take evidence on that, but we want to be focused on this particular challenge,
Fine.
if that's okay.
Thank you, Senator. In which case, my minute is up. Thank you.
Thank you. And I'll go to Senator Gosh.
Thank you, Chair, and thank you for the witnesses both here and online. Can I ask your view on what the impact of a text and data mining exemption means to the creative industry 10 years or a generation down the road? Is it an existential threat, as the evidence has suggested?
I think it's absolutely an existential threat. I think you would have heard from the creators themselves this morning what the impact would be. When I think about it, I think about two ways that it's really going to wipe out the creative industries. Firstly, you're taking away the opportunity for the creative industries to be involved in the AI growth that we're all predicting is going to happen, basically saying, no, that door is shut for you. There's no revenue opportunity for you there. And then secondly, it's going to create substitutable product, which will lessen the demand potentially for human product and compete with human created product. So to me, those are the two clear ways that a TDM exception will destroy the creative industries in this country.
I completely support that. I think that is exactly right. The only thing I would add, I don't think it's a matter of 10 years. I think a text and data mining exception, the impact would be much more radical than that. And the study that we did last year around if we're unable to license AI services in Australia, it could be the loss of $530 million between now and 2028, cumulative loss. So that's a very fast decline, and so I'd say the risk is much more extreme from that timing perspective.
I'd be interested in your perspectives on the challenges individual creatives, but also your organisations face in enforcing legal rights and copyrights against tech giants in the present landscape. That's certainly something that seems to, in terms of the scale of the theft of material, there doesn't seem to have been accountability mechanisms that have caught up to those acts. What do we need to do, or what's the framework that you think needs to be developed in order to permit the enforcement of these laws against institutions that are breaching them?
I suspect the others will concur with this. The framework we already have. I think it's the challenge facing us, I guess, arising from the Productivity Commission's interim report, is that something's being thrown into the mix. We actually have a really good copyright framework. There are solutions and paths that can be mapped out to get there. So really, the main thing that we need is not to go down the TDM route, because that will throw everything out of whack. And TDM, I guess, the very nature of it has hairs on it anyway. I think any government that's thinking of trying to bring it in, firstly, faces a potential constitutional issue, and then potentially also it may not actually pass what they call the three-step test, which is needed for a copyright exception, because it should be exceptional circumstances. So I guess my point would be stick with the current regime and enforce within that regime.
I think the thing that's been so bizarre to me in this whole debate is there's been kind of acknowledged mass piracy and infringement, but instead of focusing on how we stop that from happening and work out licensing and correct engagement with copyright, it's been, oh, well, it's already happening, we may as well legalise theft. And, what was the comment from the PC in the opening statement? Oh, it's unrealistic to think that we can actually put that genie back. That is just garbage. We have copyright enforcement frameworks here and globally. There are more than 50 cases happening in the US right now where companies are being sued for illegally copying copyright material for AI training, and we would pursue that path here. The thing that is hard in all of this is the scale of the theft and the fact that we don't know what is being ingested into these training systems. So, we've talked about the need to actually look at how to better enforce through some transparency provisions. But on the whole, it's just bizarre, this concept that theft is fine and now we need to legalise it.
I'd just add that I think, again, it's a delaying tactic. I said earlier that from the tech company's point of view, to kick this down the road as far as they can, it works for them. And we've seen this rodeo before. We're familiar with it. It's why it's important to reiterate what everyone's saying, that the current copyright framework works. It brings tension to the relationship so that you can negotiate or have determined a value to the property that you're seeking to license. So any conversational debate around it's not fit for purpose, we need something else, is a total furphy and delaying tactic.
It's pretty extraordinary evidence in one of the submissions that few, if any, tech players have genuinely sought licensing for access to Australian creative data. That was shocking when I read it. Is the way to force those companies to the table to simply start engaging in the sorts of litigation you're talking about and enforcement mechanisms to create a cost for the breach or theft of creative information and material?
Certainly what's happening in the US, but I think the biggest barrier at the moment is this false uncertainty that's been created. And Dean's right, they are delaying, the copyright law is uncertain. It's 100% certain. They know they need to license, but because they've floated this prospect, that seems to be getting a very good airing from the Productivity Commission about, it should be able to be done for free. That is, I think, acting as the biggest barrier to genuine licensing development in this country.
And if I can just add to Annabelle's point, I've also heard that argument, has your organisation thought about litigation? You go, why should our members, our 124,000 members, have to spend their own money to defend their own rights in a context where there's no cause? Absolutely no cause. It's beyond infuriating, really, to sort of expect your membership to, go off to court. Again, another delaying tactic.
And it also speaks, I think, to one of the biggest problems I, as a creative, can see is this concept of culture having value, and how much value do you put on that, and how much legislation can support the value that you're placing on cultural identity and cultural creation. Because there shouldn't really be an argument at that level if these tech companies are acknowledging, or it's legislated that they should acknowledge, the value of what they're using and they're stealing, in fact. And I think that, goes some way to saying there is a deficit in understanding about cultural value. I mean, in France, for instance, if you are a retired singer-songwriter, you're no longer performing or writing, you get a pension. And that's how much your country values you. They say, well, we're not just going to let you cease to be able to provide for yourself and whoever. We will support you. And I think they're in all of the mix, there needs to be more of that consideration going on here.
Sorry, I was just going to give the opportunity to anyone online who wanted to add to that.
I would just mirror APRA's sentiment that I think what we on the side of the music industry are, we're not seeking to be anti-technology. I would say that the music industry has been nothing if not extremely tech forward in how licenses have adapted throughout the history of recorded music, from physicals into the streaming and digital era, and even into a more recent case of Universal sorting out a very complicated licensing deal with TikTok for UGC type content. And I am an early advisor on a company called Sound Patrol that is creating a watermarking technology that Universal Music and Sony Music are in the middle of adapting and enforcing with some of the bigger AI players. So it's I can just mirror APRA's sentiments to say it's totally doable. And I think in addition, that $116 billion loss of revenue that they're claiming to report is it's an insult, it's laughable at best and an insult at worst. And the idea that that AI training is analog to how humans learn and practice music in their own development as artists is completely wrong, particularly when this training is happening very specifically for the profit of technology companies and their investors at the expense of creatives. Yeah.
I think it's, sorry, Senator, I think it's really apparent that there's an inherent imbalance in the parties here. You know, we're recognising that most of our members are small business people. They're independent artists, they're creative artists. It's almost, I find it gets my blood boiling that we have to defend our rights as creative artists, as small business people against multi-billion-dollar tech companies when, as has been pointed out, copyright laws are there to protect us. It's worked very well. The point's been made that we've been very adaptable over the years in adapting to new technologies, new laws, new technologies, new ways of disseminating information, because after all, that's the purpose of an artist, is to have a conversation, is to pose those questions to the people we're talking to. It comes back to what's been talked about, that human-to-human connection, which is intangible. It has a value, of course, but I think we're talking a lot about the cost, and the way we determine value is different in both parties. Value to the tech companies is what can we make from it. Value to us is what can people learn from it. And I think it seems we've gone very quickly down a path, as I say, of having to defend our position. When I first saw the Productivity Commission report, it felt to me like a discussion paper, but it was quickly taken up by particularly Scott Farquhar, which again got me going, about his adoption of this as, oh, well, clearly that's the way to go and we think that's great. I think the Productivity Commission is scrambling to get back to a more reasonable point, and I think discussion face-to-face with the member organisations and the artists is absolutely essential right now.
We are running up against the clock, so I'm just going to get some other questions in if we can. It seems to me, so first of all, you've basically said the existing Act is fit for purpose. So it's a furphy to be, it's a red herring to go around saying there's something wrong with it. The question is making sure it's actually implemented and enforced. And that's to the point of saying these big tech companies should be getting a licence, not an exemption or an exception to the rule. The PC was, I think, seemed a bit on the back foot when it came to the questions of consultation. So I just want to clear this up. Were you consulted before the first iteration, the interim report?
No.
We were not consulted before the interim report was released.
No.
So as the kind of key organisations in the music industry responsible for licensing and the implementation of the copyright rules for your members, PC didn't even bother to pick up the phone and say, what does this mean for you, or how does this work, or...
Correct. That's correct.
I just find that extraordinary. We'll obviously ask the publishers' associations later on the day whether that's their experience as well. What about government? Because and I'm just thinking, Ms. Hurd, you said the biggest impediment at the moment seems to be this uncertainty that's been created both by the PC or believed by the PC, as opposed to it's obviously being pushed by these big multinational tech companies who, look, they're trying it on, aren't they? I mean, that seems to be what it is. They're trying it on. You know, they'd like to cut some corners with their business, so they'd like a bunch of the information they need for free, and they think they can roll over artists and creators. It seems to be what's going on here. Where's the leadership then? I mean, are you feeling as though, or are you experiencing a vacuum in clear direction and leadership from the government on this? Because if the PC hasn't consulted you, the tech companies are running around saying they need this rule changed for them. Do you need a strong statement from government about the copyright rules and what it means for your industry?
I mean, I would certainly say it felt like we had got to a position in this debate, which was both the Productivity Commission interim report and then the Productivity Roundtable, neither of which any of us involved with, where we almost had a bit of a fait accompli in relation to the path that we were heading down, or even the framing of it, as I think you pointed out this morning, or the PC was trying to answer on. It's being framed as a problem we have to solve without any evidence base. And without any input from creators. And so we definitely felt like a process had happened that we had not been involved in at all, even though our property was potentially going to be taken away in the biggest government intervention in copyright law ever, I think. We have spoken to some in government. Some have been harder to get to. And, we have seen indications that they're not minded to change the Copyright Act, but there hasn't been a government position, a final government position put on the table.
I would like to just drill down on who you have spoken to, because I think it is helpful. There's a variety of different departments and ministries that are kind of involved in this. So who have you managed to be able to speak to about this issue and your concerns?
Well, I think there have been different meetings happening, so I can't speak for everyone. Dean, do you want to go first?
We've spoken to the Attorney General and have been advised that there was no intention to water down, dilute the Copyright Act and introduce text and data mining exceptions, similarly with Minister Burke. And to be honest with you, in the many meetings we've had across the House, we've had a very sympathetic ear with, without exception, to be honest, anybody saying we see the argument of the Tech Council and yes, they should get a free kick on that ingredient. Everybody has said they understood that creators should be paid for their creative IP.
Is there anyone you've tried to see and you can't see? You haven't been able to get into? Ministers, departments?
I think what we've tried to do is make this issue as easy as possible as a rights holder group, and we've written as a rights holder group to all of the relevant people in this building because we feel this is an existential issue for all of us. And we haven't had a lot of luck at getting to some of the ministers that are on the innovation technology side.
Yeah, right. So innovation, industry, science, those ministers haven't engaged with the creative industries.
Well, the meetings haven't happened yet.
Okay. I'm sure they're meeting with the tech people.
I couldn't say.
Senator Henderson.
Thank you very much, Chair, and thank you all very much for appearing today. We're most grateful. Mr. Ormiston, to you first. Training in AI application on music usually requires copying entire works or a large chunk of works as a reproduction defined under the Copyright Act. So can I ask, do you currently have the capacity to license works to an AI application or company or platform?
Yeah, our position is that there will be major rights holders who are members of AMCOS for existence. So, for example, so major publishers who might choose to license their rights directly, which AMCOS can facilitate. AMCOS's role then would be to say, well, we can provide a blanket licence for everybody who's not licensing their works direct. And that's not uncommon at all. So in many of the major tech licensing that has occurred over the years with audio streaming, etc., there might be deals where our members would say we would prefer to do that deal directly ourselves. That's a clear communication between our members and us, and then our function is to go, okay, well, how do we ensure that everybody else is covered as well, and what's the nature of the blanket licence we would put forward?
So do you have any blanket licences in place at the moment?
Not in relation to AI. What I can say, there's a number of very small players, and it's interesting when the Tech Council and the Productivity Commission talk about innovation. We've been approached by some very small parties who've said, we'd like to look at the opportunity of this generative AI service that we want to bring to market. How would we go about that? And we're in the midst of a couple of conversations where we would say, well, let's look at the data set that you are seeking to use. We could put in place a pilot licence because at this point you don't know what the commercials are going to look like. So we've had those conversations, and we sort of sit back and smile to ourselves and go, these players don't really have a lot of money. They're small Australian players who want to get into the innovation space, but they completely get their head around you've got to pick up the phone and call somebody, ask about what rights might need to be cleared. And we've had a conversation with them around not just the ingesting of the data and that training piece, but what happens in terms of the generative AI service and what comes out of it. So looking at the ecosystem of generative AI, which is what the conversation should be, and people get the fact there's several economic points through that training right through to the generative AI service where the creators should have an interest in that, an economic interest. So, you know, in amidst the problems we're having with some of the big players, there are some small Australian startups that are doing the right thing and coming in and having a conversation.
So I just want to try and get the lie of the land currently. So there are no blanket licences for AI use in this country covering any of the artists you represent. What have you negotiated any individual licences between an AI company and one of your members?
No, not at this point.
Have any of your members got separate licences?
Their
own licences?
There will be some of our members, again, on a very small scale, where they have licensed specific works in that space. So yes, there is some of that going on, and we're aware of it, and we go, that's a positive thing.
Are you looking at how you might be able to do a blanket licence? Have you had any discussions, or is that your objective, to go to one of the big AI platforms, for instance?
We take the view that big players know who we are and what we do. We're ready to sit and respond to somebody to say, tell us about your business. What is it that you're actually doing? And we will work out how we can construct a licence to suit. And as I said before, that's probably going to be a combination of direct licensing and blanket licensing if they want that breadth of repertoire.
But we're not at that stage yet, is that right?
Well, we're not at the stage of blanket. There are Australian rights holders that are licensed for AI training. There's an example of a company called, and I think it would be great to get Tusha's opinion on this, but there are Australian companies that are involved in a deal with a company called 11 Labs, which is an AI company, technology company. It's profitable. But most of these deals will be global deals, and that one in particular has been done between this AI company and Merlin, which is the organisation that represents independent record labels. So there are two copyrights in music, sound recording, which is me, and the underlying work, which is Dean. From the sound recording side, that's all been licensed with Merlin, that overarching body, and there are Australian rights holders that have opted in to be a part of that training for that product. The thing about that product is the rights holders have set the boundaries around how the material is used, so you can't put in a prompt that says, make me a song in the style of Christine Arnoux or Briggs. There's only certain uses, and that's all part of the agreement and the agency that we talk about. On the publishing side, you can talk about the publishing
the
side.
other thing I was going to say as well was I think although the ones that are happening internationally, like 11 Labs, also have an opt-in element to them.
Exactly.
So rather than what's being currently proposed, which is we'll take your property, but you need to opt out actively. So this is all about creating a licensing deal, and if someone doesn't like the sound of it, then they don't need to opt in. It's a framework that's there.
But if they're opting in without any payment?
Oh, no. So with the licensing, there'll be a license where you're not obliged to be involved. So it's a framework's put in place, a licensing framework, and if you like the sound of it, you can opt in. Yes.
There are Australian rights holders receiving money from that deal right now.
Just watching the clock, I'm sorry. So can I understand that there's no changes to the law required to do these licensing deals?
Correct.
No, correct.
Are there any changes to the law you would like to see to improve the protection of the rights of artists in this country?
It's a whole other
question. Have you considered that?
Well, I think it's really that transparency point. Are there ways that we can make it easier for rights holders to enforce their copyright with regard to AI?
Can you perhaps consider that more and provide any further information on notice? What about breaches? What roles are your organisations playing to manage breaches of copyright law where AI applications or engines or platforms are illegally using Australian music?
I think part of that question goes to your previous one around what we require, transparency. It's very difficult to know what actually has been ingested, and so currently in the US there's 53 individual actions occurring in terms of litigation.
So is that US litigation concerning Australian?
There are Australian
artists
affected by that.
Could you provide on notice more details of that litigation, just so we can get an understanding of what it is? Thank you.
I can give a brief example, if I may. Sorry to jump in. But the company I work for is called Concord, and we have a litigation with a company in the US called Anthropic, which is an AI platform. They have scraped and data mined a whole swathe of music across audio, but also literature, and they recently settled on the literature case, and I think it was in the tune of $80 million as a settlement, and now we're awaiting the settlement on the audio streaming case. So as Dean said, there's 53 examples. That's one of them. So I think there's a lot of publishers and rights holders waiting to see how the US litigation plays out before, blanket licensing and digital licensing follows from there. So.
Okay. So just to go back to can I just go back to the breach issue? So without the transparency obligations that you're seeking, or that greater transparency as to what's actually going on, have there been any instances of breach where you have been able to act on behalf of your members?
We haven't brought any litigation in Australia yet.
Or any breaches, any notices, or that haven't yet gone to litigation?
Not in Australia.
Right, okay. Look, I might... sorry. Can I just to you, Ms Hurd, and I know I'm just watching the clock, we're running over time. You've spoken about this uncertainty over this proposal to legalise the theft of music, copyright works, including, of course, music. Have you sought any guarantees from the government at all?
We've certainly made our views known to the government in the strongest possible terms. But as part of that, we've tried to provide as much evidence as we can of how we see licensing actually working, because part of this whole debate is, the tech companies make out like it's so difficult and the scale is too big and it's too inefficient. But what we've tried to demonstrate is we're talking about the same music data set that we already license on Spotify, for example. So we've tried to provide as much evidence as we can. We obviously didn't have the chance to do that with the Productivity Commission before they put out their interim report, but ARIA has since met with the PC and we put all of this on the table, and it came as a bit of a surprise to them, which came as a bit of a surprise to me, considering the proposal they'd put in there. So yes, we're certainly making our views known.
And Mr Ormiston, in relation to your conversations with the Attorney-General, did you receive any assurance that there would be no tech and data mining exemption in writing from the Attorney-General?
Not in writing. We only had that meeting recently and were told verbally that the government wasn't of a mind to amend the Copyright Act to include an exception for text and data mining.
And have you asked for that to be made public and for the government to yell that from the rooftop, so that you don't have to be in this situation of such terrible uncertainty, which of course is threatening the livelihoods of the members and the people you represent?
Yes, we've made the case very strongly. We probably haven't called for those words exactly as you said, but as I said earlier, we've been meeting with people across the House, government and all parties in relation to the matter to elevate it. We're yet to have our meeting with the Productivity Commission. We've been seeking a one-on-one meeting. We were advised that we were invited to a meeting this afternoon with a number of other rights holders, but
what a coincidence, Deirdre. Just today they've sought to meet with you, have they?
No, to be fair, we were invited last week to join the meeting this afternoon. But as Annabelle said, we are the major player in the industry. If you were serious about wanting to sort all this out, we would have expected.
You would have thought you would have got a phone call. Yeah. And I'm sorry, the gentleman online, apologies. Mr Goff.
Oh, no.
There was someone else who
was wanting to put something in.
Tushar, Mr Apti, do you want to say something? Sorry, I think you were trying to speak before.
No, I think I was just going to reiterate that the major point here is that it's all very doable, and that's sort of one of the key takeaways from our side of things is the technology companies are acting like it stalls innovation. It doesn't. The companies are acting like licensing is too tricky. It's not. And I know I have licensed certain segments of my catalogue to generative apps in the past. Licenses have been done And yeah, we're just hoping we can do this for the industry at large to, protect creators and the Australian voice.
Thank you very much.
And just to add to that, I think when we had the conversation initially with YouTube and subsequently Spotify to license the same rights and the same works we're talking about today, we were told that price and that the price we were trying to charge at that time was a barrier to entry and a barrier to innovation. And if you look at Spotify and YouTube today, they are monolithic global companies that really built their businesses off the creators' rights. And we license them fairly, and over time those licenses have obviously increased. And we are open for business. We're open for licensing on behalf of creators and IP, and the framework exists, the framework works, and we want it to continue, and it doesn't need to change.
Thank you very much to you all for your evidence. No further questions, Chair.
Thank you. I think that's a very good point that it hasn't stopped Spotify making money or profit, being able to enter into licensing agreements and respecting copyright. Or TikTok, for that matter. Or Meta.
They all have deals with our companies to license music already. They know who to ring.
Yes, but if they could get out of it, I'm sure they could.
It's a commercial issue. It's not a copyright issue.
Yeah. I just want to clarify one point because, and then we will have to wrap up. But in the Productivity Commission's report, they cite the US as an area where an exemption is effectively given because of the fair deal arrangements, and yet we're seeing fair use arrangements. Yet we're seeing 53 court cases. So is it right to say actually copyright exemptions are not settled in the US?
It's absolutely correct to say that. I mean, our copyright law is very much aligned with copyright around the world. There are some bits at the edges that are different. But in general, it's strong, and the US protects its copyright like nowhere else on earth because they have the creative industries based there. That's such a huge part of their economy.
So that's a fundamental mistake
it is an
in the
error
Productivity
to
Commission's
say
report.
that copying and training for AI purposes in the US is allowed. That is wrong. And that's been a complete myth that's been perpetrated through all of this discussion.
Just to be clear, the Productivity Commission has published glaringly wrong material in their report, of which then they're basing their findings.
Yeah, it is. The limits of fair use in the US are what is being tested in all of these cases, but there is no text and data mining exception in the US, and there has been no case that's come down and said it is okay to do this. And in fact, there have been massive settlements, which the authors can talk to, with Anthropic to pay something like, $1.5 billion because they were hurtling towards a potential company-destroying copyright infringement damages payout.
I just feel like the more we learn about this, the more discredited this report
It definitely feels like you're being gaslit, that's for sure.
The only thing I would add to that too is that the fair use context in the US means you need to go to court and litigate really to define your argument, whereas we would argue that that's why the Australian Copyright Act is such a great framework, because it's very clear what's in, what you can do, what you can't. The exceptions are tried and true and tested, and that's really what all businesses need. And so it makes the negotiation possible, and you either negotiate a value or you don't, and you get determination of it. It's very, very clear.
All right. Well, thank you very much for being here today and giving us your evidence, and good luck with your meetings with the Productivity Commission.
Thank you.
Thank you very much.
Thank you.
Give them everything.
We are going to suspend for our lunch break, and we're going to be back at 1:45. I now welcome representatives from the Copyright and Tech, from the Copyright Agency and Digital Rights Watch. I think we've got Ms. O'Shea on the line. Yes, we can see you.
Yes,
Great.
Great. You can hear me as well.
We can hear you. Thank you. What we'll do is we'll get both of you to give us your full names and the capacities in which you appear, and then give you a chance to give us an opening statement. So we'll start with the Copyright Agency.
So I'm Libby Bolt. I'm Director of Policy, Government and Member Relations at Copyright Agency. Thank you for the opportunity to appear before you today. I'm here to represent our 40,000 members who are writers and artists and people who work in many areas of publishing in Australia, including education publishing and news media. Our members are not against ethical AI development in Australia. To the contrary, they see opportunities for their work to enhance the benefits of AI development for Australians and to be properly compensated for the value of their work. Creative content and AI development are in what we sometimes call a permanent loop. AI is better with quality content, and developers paying for humans to create content means that human-created content will continue and continue to enhance AI development. You've heard a bit about copyright licensing already today. Copyright licensing arrangements for AI are now happening in Australia and globally. They take many different forms. They include deals with large publishers and also collective licences or blanket licences that cover content from a multitude of rights holders. Those two things can work together. An AI developer can have licensing deals with large publishers as well as collective licences to cover smaller rights holders. Collective licensing is what we do. We manage licences that cover masses of content for tens of thousands of copyright holders, big and small. We are a not-for-profit organisation and we distribute about $100 million in copyright payments each year to writers, artists and people who work in publishing. These payments come from collective licence arrangements that we have with the education and government sectors as well as with the business sector. As you've heard, multinational AI companies are pushing really hard to water down Australia's copyright legislation. That is not in the best interests of Australians. The framework that we have in Australia now enables AI developers and people working in the creative industries to work together, and that's what we should keep. Thank you.
Thank you. Ms. O'Shea?
Thank you, Senator. Thank you for the opportunity to speak before you today. My name is Lizzie O'Shea. I am one of the founders and the chair of Digital Rights Watch. Digital Rights Watch exists to ensure fairness, freedoms and fundamental rights for all people who engage in the digital world. Digital Rights Watch takes an approach of applying human rights frameworks and principles to questions of technology policy. And our starting point is that Australians have a right to enjoy and participate in the arts, and that people who make cultural and artistic works sit in a unique position in society. They contribute to our collective understanding of ourselves, but they also retain an individual claim over what they make. Now, of course, artists are in dialogue with each other and also with the community at large, but they make work that is fundamentally personal, and this is referenced in how the relevant human right is articulated. So the right to culture is a fundamental human right. The right to protection of literary or artistic production is explicit in Article 27 of the Universal Declaration of Human Rights, to which Australia is a signatory. That right refers to how everyone has the right to protection of the moral and material interests resulting from any scientific, literary or artistic production of which he or she is the author. Australia has also endorsed the UN Declaration on the Rights of Indigenous People, and Article 11 recognises the right of Indigenous people to maintain, protect, and develop culture, including with respect to designs, visual and performing arts and literature. Now, of course, copyright is one of the ways in which this fundamental human right is protected in Australian law, and it covers licensing arrangements, of course, and articulates when there's been a violation, but also moral rights, which I think is worth referencing in this context. Moral rights include the right of attribution, the right against false attribution, and the right of integrity. So the right of an author to ensure that their work is not subject to derogatory treatment. Now, what I would say is that very few human rights are absolute. That's well understood within human rights law. There's an understanding that human rights can come into conflict with one another, but resolving that conflict ought not be an exercise of sheer power or market dominance, but a process of considering how rights conflict and seeking resolution that is democratic and considered. And we would say there are three tests that need to be justified in order to engage in interference with a right. That is legality, whether it's authorised by law, which is one of the reasons why we're here today, to talk about a potential change in law that might give rise to that. But then I think the other two necessary criteria that are very important to consider in this context, where I think the human rights approach can be very valuable, is purpose, whether there's a justified and legitimate aim which is narrowly defined and understood in the context of the right that is being infringed, and then whether the measure is necessary and proportionate, whether the measure is not overbroad and is designed to serve a specific protective function. And I would argue in each of these cases, it's not clear that the benefits that are proposed to be gained from, for example, introducing some kind of exemption for large language models or foundational AI models justifies, according to human rights principles, the violation of the right to culture and artistic expression. I'm happy to talk in further detail about any of those matters throughout the course of this hearing.
Thank you. Senator Gosh, have you got questions?
Certainly. Thank you, Chair, and thanks everyone for being here today. One of the matters that's been raised already in the evidence is the large-scale theft of existing material in order to feed large language models. And I wondered if you had any perspectives on the way to address that from a legal or rights-based approach.
So, yes, most of that has occurred, not all of it, in other countries, and that raises particular challenges for authors and other rights holders who are here in Australia. It does need to be addressed, so I don't think, we're not saying that you should just draw a line under it and forget that it ever happened. It does need to be addressed. The current discussion, however, is about what's happening in Australia. And so this proposal for a text and data mining exception is about what happens in Australia. And so that's our current focus, is to talk about the ways that things should develop with ethical AI development in Australia using licensed content that will contribute to investment in the future creation of Australian content by Australian creators.
The other matter I'll just raise, to the extent the question is directed at me, is that there is also an accepted set of principles for discussing what a process might look like for providing some form of compensation for rights that have been violated, but also proposals for changes to legal regimes that affect human rights. That is commonly understood as the panel principles, and panel is an acronym. It stands for participation, accountability, non-discrimination and equality, empowerment and legality. So it basically sets out ways in which reforms, including as they may apply retrospectively, involve the community that is affected, and they aren't treated as a secondary consideration or a set of people upon whom a policy or a process is imposed without involving them in the process. My only other comment, I suppose, is to point out that there has been discussion about how this is occurring in other parts of the world, and it's being facilitated through different provisions in different legal regimes. They are contested, as I'm sure senators are well aware. Anthropic is currently trying to resolve a very large class action lawsuit without much success. The settlement has been rejected by the relevant judge. There's not a huge amount of public material about what that looks like, but it's quite clear that retrospective consideration of these business practices by courts involve their own sets of complexity, which suggests that there is room for, I think, high-quality policy making that complies with the human rights approach in order to give protection to people whose artistic work has been produced, but also to avoid facilitating business models that seek forgiveness rather than permission, which may result in large, complex litigation that is also very expensive for the public in terms of resourcing.
Thank you. One of the other observations that was made by some of the earlier witnesses was that the current Australian copyright regime is fit for purpose and simply needs to be enforced appropriately. With that as a starting point, are there additional rules, regulations or processes that you would like to see government implement in order to better protect creative industries or to ensure that artists are properly compensated for their work?
So certainly we agree that the copyright system in Australia is fit for purpose. It's very good, it's very clear. It clearly sets up a framework for licensing. If somebody wants to use works that have been created by someone else that they've put their skill and experience and investment into, then they need to get a licence for that, and licences are available. So we completely agree with the position that the current system is fit for purpose. Licensing is happening and developing, and things are developing quite fast, and that should be allowed to continue, for those licensing arrangements to continue. If there is watering down of the copyright system, then Australia's creative industries will miss out on the opportunities that AI development here would otherwise deliver for them.
Thank you. Thank you, Chair.
Thank you. Senator Henderson.
Thank you very much, Chair, and thank you so much for your time this afternoon. So we've heard some pretty alarming evidence already today about the impact that this TDN fair dealing exemption would have on the Australian artistic and creative industry. Can you sum up your concerns as to where we are currently at?
Do you mean, sorry, Senator, in relation to the proposal to introduce a text and data mining exception?
Yeah.
So
in relation in relation to what the Productivity Commission is canvassing as one of the potential so-called solutions.
Yes. So what that would do is to take away an enormous opportunity for Australia's creative industries to earn revenue from the value of the works that they invest in, from these new uses of those works. So there's an opportunity for Australia's creative industries to work together with ethical AI developers so that both can benefit from the opportunities that are now there. If the Australian Copyright Act is watered down in that way, those opportunities will be taken away from the Australian creative industries, and AI developers will be given a free ride, an unfair free ride.
And so do you believe the Productivity Commission has got this badly wrong?
Yes.
And what's the impact on your members?
Well, it will take away, as I said, those licensing opportunities which are starting to develop, which is already delivering some licence fees, and will continue to do that if we keep the current framework in place. So that will be taken away, that opportunity. And the way that the copyright system is set up for creators is that it enables them to have ongoing income when new uses of their works come along. So if there are new technologies or new uses of their work where their content is going to be used, then that provides an opportunity for them to be paid for the value of their work for those new uses. This is one of them, and they should be able to earn that revenue from this new use and not have it taken away in an unfair way.
How do you characterise Australia's copyright laws currently? Are they fit for purpose? Would you like to see some improvements?
We think they are fit for purpose. They're technology neutral, they're flexible, it's a good framework that's set up for licensing arrangements to occur. and we're not looking for any changes to the copyright system.
Ms O'Shea, could I ask you to respond to those questions? Your concerns about where the Productivity Commission is going. I assume you do not support the Productivity Commission's canvassing and almost waving the white flag in relation to Australian creatives. If you could address that, and also whether you are seeking any improvements to the protection of artists.
Thank you, Senator. I mean, I'm not sure I'm necessarily the best person to describe how any laws might need to be reformed, so I defer to other colleagues or other members of this panel and previous panels before you. What I would say about the Productivity Commission is that the interim report appears to me to be overly reliant on projected benefits put forward by industry of large foundational models, large language models, and that therefore comes at a cost to others, which is designed to facilitate further advancement of those specific kinds of approaches to AI. So it's a very narrow consideration of artificial intelligence. There is a lot more opportunity to explore frontier technologies in different ways, including in small language models that are potentially more sustainable, also more likely to have data sets that are that have integrity and that could be facilitated in an ethical or compliant way with copyright provisions, for example. And so my view is that the way the Productivity Commission has approached this job is to look at a very specific narrow form of AI, which is large foundational models. Their needs are for constant access to more and more data, more and more information to train their models. So that's resulted in expressing this potential exemption. Of course, it's also resulted in an expression around throwing up the possibility of relaxing privacy laws at a time in which most people don't support that. Now, I understand that's beyond the scope of this particular inquiry, but my point is that the Productivity Commission is taking a very narrow view of the technology that it wants to support and wants the legal regime to accommodate, without any sophisticated analysis of the potential benefits that might flow. It's very difficult to assess the integrity of the hype that surrounds this industry. And reports that are coming out now, you know, there's an MIT lab report, which I'm sure many of the senators will have read, but refers to 95% of US businesses experimenting with generative AI receiving no benefit from it in terms of productivity or otherwise. So I think there's a reasonable basis for questioning that side of the ledger. If we are going to have to accommodate various violations of our rights to facilitate these businesses, largely based overseas, to continue developing and selling their products, I would like to see what that actual benefit is likely to be and how it will be directed at solving real-world problems for Australians. That would be maybe a circumstance where you could apply a human rights approach and work out whether that benefit might be worthwhile. But in this instance, it appears that there's very little evidence to support even entertaining that process when we know what the costs will be, which are likely to be extremely high.
Can I just ask about infringement of copyright? Ms Belch, we've heard evidence today from the music industry that they would like greater transparency so that it's easier to detect infringement, breaches of the law. Do you have any recommendations as to how you can streamline more efficient licensing markets for those you represent and also to better detect infringements?
So on the licensing front, we really need to leave things alone. The framework is there. The licensing arrangements are happening and they're growing. So we just need to let that develop and play out.
So you have the capacity to license to AI platforms without any issue?
We are in discussions with our members at the moment. So the deals that have been done so far have been by large publisher members. including in the news media area and scientific publishing area. So those certainly those deals have been done. They're not all public, and we are in discussions with members about a collective licensing arrangements for those activities, and that is an active discussion.
And can you just provide some more information about what a collective licensing arrangement would look like?
Certainly. So we already, as I said before, offer collective licensing arrangements in a number of areas. So one example may be for media monitoring organisations such as Isentia and Meltwater and Stream, whose services you may be familiar with. So we represent a whole range of rights holders, down to quite small ones, for masses of content, including for web scraping that's done by those services. So that's one example of a collective licence. We offer a collective licence to businesses whose staff are copying and sharing other people's content in the course of their workplace, and we have just extended that licence to allow staff of those businesses to use third-party content as part of prompts for AI tools that they are using in the workplace. So if they are using an enterprise AI tool or an enterprise version of, say, ChatGPT, then our licence will allow them to use, at the moment, news media content as part of the prompts for those tools, and later in the year we'll extend that to other sorts of content as well. So that's another blanket licensing arrangement.
So a collective licensing arrangement would still be one licence for all of your members, licensing with one particular entity. You're not looking at doing a bulk purchase, if I can be crude in how I describe that.
So I'm not sure if I've understood the correctly.
Well,
so
in other words,
sorry,
just let me explain. So a collective licensing arrangement, you wouldn't do a licensing arrangement, say, look, we'll cover all AI platforms that are domiciled in Australia. So you would still do it on a company-by-company basis.
Customer-by-customer basis.
Yeah.
Sorry, now I understand what you're saying.
Yeah.
Yes. So in the business sector, we have, I think it's 1,000 licensees of different types of businesses, and we have a collective licence agreement with each of those businesses, and that covers the masses of content from all of our members that they can copy and share within the business.
And so what do you do in a situation, say, for instance, you were going to do a collective licensing agreement with one AI company, and the AI company takes much more from one of your members than any other member? How then do you distribute the proceeds of that licence in a fair and equitable way?
So there are lots of different ways that collecting societies like us distribute the licence fees that they collect, depending on the data that is available.
Okay, so it's
them.
you often tie it straight back to the data and the usage?
Yes.
Under the licence?
Yeah, so it depends on what level of data is available, but yes, if that data is available and one rights holder's content has been used more and another one less, then that would be reflected in the distribution payments.
So given the current law allows you to enter into licensing agreements with any AI company representing your members, would you like to see the government put this issue to bed, stop the uncertainty, stop the ongoing harm that this is doing to your members and to all creative industries in this country by allowing this to fester, potentially for months, maybe a year or more? I am certainly calling on the government to make it very clear that there will be no tech and data mining fair dealing exemption under the Copyright Act. Would you also do the same?
Yes, we think that a definitive statement that a text and data mining exception is completely off the table in Australia, that is what we would like, because we think that the possibility of that happening is an impediment to licensing. I would agree with that.
Thanks, Ms Balch. Thank you all. No further questions, Chair.
Thank you. Well, actually, all my questions were most of my questions were asked already. The only question, just to circle the loop, we've talked about who the Productivity Commission had consulted with. I'm just checking. They hadn't consulted with Digital Rights Watch for their interim report. Is that right?
That's correct.
And have you had any consultation since?
No, we have not.
Okay. And the Copyright Agency... The Copyright Agency was consulted in the original, for the initial report. I imagine you raised all these issues. I mean, how effective was that consultation?
So that was a meeting between our CEO, Jo Johnston, not the commissioners that you heard from this morning, but with an assistant commissioner and one of the researchers. So the meeting wasn't with the commissioners. I think that the fact that there was a call for feedback solely on a text and data mining exception is an indicator that the position that we put is not reflected in the interim report.
Yes. I found it extraordinary, actually, that today, when asked about why creatives and the impact on creative industries wasn't even considered as part of the feedback questions for their next round of report, it just seems a shocking omission.
Well said.
Yes.
It does appear we have been trying to talk to creatives about this issue because it's obviously a source of significant concern to them. And I think there is a real urgency around that consultation because obviously, the Copyright Act is not technology specific, and there are different kinds of rights holders with different kinds of concerns. There are a lot of creatives who appear to want to have a meaningful right of refusal, a right to not have to participate in allowing their content, their creative work, I'm hesitant to even call it content, their creative work to be used by these systems because there are moral rights they're concerned about, integrity and attribution, among other things, and that facilitating a wide-scale exemption does undermine the freedom to engage in artistic practice. So I think there's a lot of concerns that need to be listened to by people who are likely to be affected by this, which may involve quite diverse interests or perspectives. And it would be beneficial and compliant with human rights approach to facilitate that kind of consultation.
Yes, understood. Thank you both for your evidence today. Very much appreciate it. And if there is anything further, for example, if the Productivity Commission does reach out and bother to consult again, if you want to put in a supplementary submission, please feel free. Thank you.
Thank you, Sam.
Now, we'll just have a short suspension while we get our next panel ready. Go? Great. So we will recommence, and I now welcome a number of representatives from our esteemed authors panel. We have representatives from the Australian Society of Authors and the Australian Publishers Association. Now, I'm going to get each of you to say your full names and the capacity in which you're appearing, and then we'll go to some opening statements. So we'll start at this end. We'll do our in person first, so we'll start at this end of the table and work down, and then we'll go to Professor Walsh and Ms. Ovington. So over here.
Hello, my name is Patrizia DiBiase Dyson. Apologies for the mouthful. And I come here in the capacity as CEO of the Australian Publishers Association.
Great.
Hello, I'm Lucy Hayward, CEO of the Australian Society of Authors representing the ASA.
I'm Sally Rippon. I'm a children's author and also the current Australian Children's Laureate and sit on the newly established Writing Australia Council.
Great.
I'm Tom Keneally, a man of literary ambitions, and I'm a former chairman of the Society of Authors.
Great.
I'm Anna Funder. I'm a writer.
Wonderful. Professor Walsh, can you hear us?
Yes, I can.
Great.
Toby Walsh. I should say I have two dogs in this race. I'm an author and also an AI researcher.
And Ms. Ovington?
I am a writer and also the literary editor of the books pages at the Weekend Australian.
Okay, great. Now, I imagine some of you have prepared opening statements, but perhaps not everybody. So we'll just go see how we go, and then we're going to go to some questions. Start with Ms. Hayward.
Thank you. So the Australian Society of Authors represents over 4,200 members drawn from across the literature sector, including fiction writers, historians and biographers, children's authors and illustrators, poets, educational and academic writers, and more. What we know is that some of the world's wealthiest companies have taken an enormous volume of copyright content, scraped it from the internet and pirate websites, and used it to train their AI models. They've done this without permission and without payment to the authors. And from the ongoing litigation in the United States about this copyright infringement, we understand they've done this because it was faster and cheaper not to pay. To top it off, this technology will go on to displace authors' work and dilute the market. Copyright is how creators earn a living, and it's straightforward. If you want to use someone's work, you have to ask permission. Now, the Productivity Commission has proposed as an option to address the apparent problem of copyright, a text and data mining exception, which would give these companies a free pass and legitimise the theft of Australian authors' work. A copyright exception is unnecessary and unjustified. It undermines First Nations cultural protocols and contradicts the National Cultural Policy commitment to a robust copyright framework and the recognition of artists as workers entitled to be paid for their work. Licensing authors' work for AI training is already taking place, providing creators with the option to say yes or no to the use of their work for this purpose, in other words, to opt in, to set guardrails around that use and to be compensated fairly. It also creates a sustainable economy. These tools are fueled by data and they're hungry. To create better, more high-quality AI tools, developers will need creators to go on producing high-quality content into the future, and if creators want to license their work, they should be paid fairly. We would ask, what is the problem the Productivity Commission is trying to solve? It is clear that the issue is not access to copyright work. These companies have already taken it. The problem seems to be that these companies simply do not want to pay for it. We have to license their content. Why don't they have to license ours? These companies do not need the financial assistance of a public policy intervention to make resources available to them for free. Licensing works. We've done it for a long time. Creators are not anti-tech. This isn't a story of creators versus AI. This is an issue of fairness. The problem we need to address is bringing big tech to the table to respect creators' work and to license it appropriately, as they should have done and know they should have done from the beginning.
Thank you. Anybody else willing an opening statement?
Sure.
Yep.
I'm Sally Rippon, an award-winning author and illustrator. My career is built on the intellectual property I create, but while I was first published at 26, it wasn't until I turned 40 and had published over 50 books that I was able to make a living from my writing. Like many writers I know, I first started making books as a child, folding up bits of paper and writing and illustrating my own stories. These days I visit hundreds of kids in schools all around the country, from far north Queensland to Hobart, to talk about how I became an author. And I show them the handmade books I created when I was their age. And we write stories, draw pictures, and make books together. Earlier this year, I discovered that 67 of my books were included in the pirated books dataset some AI companies have reportedly used to train their AI tools. I feel like this is unacceptable. Some of the world's wealthiest companies have used my life's work without permission and without payment. To ensure the future of Australian stories and the sustainability of authors' careers, the government must resist any calls to water down copyright.
Ms Ovington, I saw your hand shoot up.
Yes, so I am a writer, the author of 15 books, all of which have been taken without my permission and fed into the AI machines. But as the literary editor of the books pages, I wanted to give you a flavour of the kind of thing that is at risk. Because since the release of the Productivity Commission's report, I have heard personally from hundreds of writers who do not believe that their stories, often quite personal stories, should be fed into these machines without permission. Now, in my role, I publish 5 pages of book reviews every week, and I concentrate, where possible, on Australian stories. So in recent weeks alone, that has meant books about nurses, Australian nurses who took care of AIDS patients during the crisis in the 1990s. I publish a poem every week, if I can, by an Australian poet. I had a book reviewed about Zara Holt, the businesswoman who stood behind Harold Holt at the time that he was Prime Minister. We published an essay by Stephen Orr, the writer, who is trying to save the books that libraries are now throwing out because they say they don't have enough room on their shelves. We published an essay by Jonty Claypole from the Secret Life of Books podcast on this topic of the Poet Laureate. Who should it be and how should they approach the role? We published a review of Jana Vent's new collection of short stories as she strikes out of broadcast journalism and into writing. A page on Tony Jordan, who's written a book about a small girl who grows up in a home with greyhounds and gamblers. We published a review of a book by Adam Courtney on what it was like to grow up with Bryce Courtney, Australia's favourite novelist, as a father, and who was also a fabulist, of course. We published a book about Australian fatherhood, about Bluey's dad, Bandit, and whether he's a good role model, and a book by a debut writer who also happens to be an AFL footballer, about what the macho life is like inside football clubs. And we published a review of Mark Dappin's book where he reflects on Chopper Read and our worship of him and what that says about our culture. And an essay about our Indigenous titan, Alexis Wright, who is now in line, we hope, for the Nobel Prize for Literature. All of these works are protected by copyright. And the beautiful thing about our law in Australia is you don't even need to register it as a creator. You don't need to go to a lawyer. You don't need to get a signature or pay any fees. Your copyright is yours when you create the work, and it lasts for your life plus 70 years. Now, if these works can be fed into machines without permission, then what the AI companies have done is legitimised, in my view, the greatest act of copyright theft in history, and writers will lose the right to tell the stories their way. And many of these writers are already so vulnerable. They earn very little, and the payments may be small in the context of Facebook, but enough to maybe cover a car repair or a big gas bill that comes in unexpectedly. And it is not, in my view, in Australia's national interest to enrich these multinational companies at the cost of Australian writers who are telling stories that contribute to our cultural life.
Thank you.
Thank you. I'm Tom Keneally, and there are 79 of my editions on the Atlantic Monthly website that lists plundered books. But I'm really here for the ghosts of Frank Morehouse and Barbara Jeffress and similar figures from the Society of Authors who introduced copyright to us. And may I say, it's and I hope the committee understands this, I'm sure you do, that it is copyright. It's not copy charity, it's not copy privilege, it's not copy indulgence, it's copyright. And our right has been parleyed away by ignorant people who don't realise what copyright is. And for Frank, I wish Frank Morehouse were here, living and breathing, to address you, but you've got to put up with a inferior knuckle dragger from Homebush instead. I was the chairman of the society when ELR was introduced after a long struggle with the universities. My daughter, Meg Keneally, who's a novelist, she writes this: "This is not a victimless crime. You have stolen our early mornings and our late evenings. You have stolen the time that we in turn have stolen from our loved ones to make a book." And this has to mean something, and I'm very delighted it means something particularly to your committee. And thank you for the chance to speak here.
Thank you. Dr. Fonda.
My name is Anna Fonda. I'm a former international lawyer for the Australian government and the author of 3 books, all of which have won national and international prizes and have been published in many countries around the world and hoovered up illegally in many editions. Each of my books is about human conscience and courage facing totalitarian regimes. They are Stasi-Land, about 4 people who refused to betray others to the East German Stasi. The novel All That I Am, about the presumed murder in London in 1935 by Nazi agents of 2 German women in exile who were among the earliest activists resisting Hitler's regime. And Wifedom, Mrs. Orwell's Invisible Life, about George Orwell's brilliant first wife, Eileen O'Shaughnessy, who saved his life, co-wrote Animal Farm, and about how and why the men writing his story have erased her from it. My books take between 4 and 7 years to write. They tell stories that would otherwise be overlooked or forgotten. They are stories that the algorithm would never find. I think of them as interventions in history and as contributions to Australian and world culture. It's true that writing is a vocation. It's also probably a compulsion to make sense of the world and make an artwork to convey it. But I would not write books if I could not make a living from them. Writing is both my life and my livelihood. It is not a hobby. If Australia would like books to delight itself, to know itself, to be itself, and not a source of raw materials for American or Australian computer companies, we will need books. But without copyright, no one will write them.
Professor Walsh, is there anything you'd like to add specifically?
I just want to make 2.
Oh dear. If you can hear us, Toby, you might need to log back in and log out again. We will go to some questions. Oh, have you got something to add? Yes? Okay,
Thank
you go ahead.
The Australian Publishers Association thanks the Senate Committee for the opportunity to address emerging technologies in publishing. Australia's publishers invest hundreds of millions each year to create world-class children's books, novels, non-fiction, learning resources and research publications, of which these incredible authors, their work. These works vivify Australian life and sustain our education and civic capacity. Our content, as you have heard, is being scraped globally without permission or remuneration from AI training, undermining our members' ability to invest in new Australian stories and voices. Licensing offers a clear, lawful alternative. Publishers are both licensors and licensees of high-quality content. HarperCollins' recent deal shows that opt-in licensing works, giving AI companies curated data that improves accuracy while ensuring fair compensation and respecting the author's moral rights. Other Australian publishers are currently negotiating such deals, and they are seeking trustworthy partners. The market is just now coming into its own, with global headwinds shifting towards licensing as the solution. However, if licensing is forsaken for a text and data mining exception, involuntary, unethical, unremunerated industrial scale copying will be entrenched, threatening the future of Australia's publishing industry. Thank you.
Thank you. We might just... Professor Walsh, are you there? No. I think we'll go to some questions, if that's okay. First of all, Ms Hayward, from your agency's perspective, were you consulted by the Productivity Commission?
So after the release of the interim report, we did have a meeting with the Productivity Commission. So not prior to, but we did make a submission to the interim report alongside the Australian Publishers Association. So after the fact, but nonetheless, you're one of the few organisations, I'd say, now that's been able to have a meeting from the creative perspective with the Commission. Was it clear to you that they understood what copyright meant and what this exemption would mean? It was not clear to me that they understood what this might mean. It was not clear to me that they were investigating other solutions to the apparent problem that they were posing, which is that copyright is somehow an impediment to AI training and development, which I know Professor Toby Walsh can speak about in more detail. But it is certainly our view that there are serious omissions in the report and in the consultation regarding the productivity of the creative industries, as well as the economic contribution. I think we heard earlier today that no modelling had been done on the creative industries. I'm not an economist by any means, but I don't know how we can say that there will be an increase to GDP without taking into account the decrease from a copyright exception.
Yes. Dr. Fonda, you've written books. You've just went through the importance of them and the unique place they have in literature in terms of the topics you cover, the writing style, the length of time it takes you. But they're now stolen, are they?
Yes, they have been stolen by AI, according to The Atlantic, in many editions, many countries, many languages, all of them.
And what have you done about that?
Well, there's nothing I can do. There's nothing that I can think of doing. I'm here. I've written about it for the newspaper, and I'm hoping that we get a solution here that protects us. I feel as if I spend an embarrassing amount of time writing those books. It feels to me like I'm spending 4 or 7 or 5 years building a block of flats, and the income that I should be getting from that is like rental income, is royalties. And what's happened is these squatters have moved in, are not paying rent, are making money out of my flats, and this proposal would legalise that arrangement.
Well, basically gifts them the apartment, doesn't it?
It gifts them the apartment that they are already squatting in, and then they are making money out of my work every time it's Googled.
They also pretend to accuse us of holding up AI. I am as much looking forward to what AI will do to the world as anyone, but we're not against it. We are singled out as the Luddites in the road of AI. And I find that an obscene accusation to go only equalled by their assumption that any mug can write a novel and can do it over a weekend.
But Tom, we may be Luddites, but our work is so valuable to them because they've scraped the internet, a lot of which is rubbish. If you want things, thinking and writing of quality, it's in books. So the reason they want our stuff is because it's valuable to them for money, and yet they are not prepared to abide by the law in paying us for that value. So like colonialists, they pretend there is no value in this land. We can take this sugar, this labour, this ore or oil. It's worth nothing to the natives. We're going to take it and make money out of it. But we are the natives. You know, it is valuable to us, and there is a system for payment.
Ms. Ovington?
Yes, I would also like to emphasise the point that it's not all about money. I have spoken to a number of writers who simply say they will never agree. They will never agree to have their works fed into these machines. Two writers I have permission to speak on behalf of, Gina Chick, who won Alone, who wrote a book about the death of her daughter, who was just 3 years old when she died of cancer. And Trent Dalton, whose novels are based on the life of his parents who struggled mightily with addiction to various substances and time in jail. They are extremely personal stories presented in the way that these authors wish to present them. And both authors have said to me, they will never agree, not for any money. It is also about permission. They did not seek permission to steal these stories, feed them into the machines, munch them up and spit them out again. That too is important.
Professor Walsh.
Thank you. I just make two quick technical observations. First of all, it's not technically necessary for them to do this. Colleagues of mine have built a data set of material that's in the public domain, things that are out of copyright or things where there are permissions, and have built a ChatGPT clone that does just as well as ChatGPT. So it's only the commercial race that has encouraged them to skirt the law and do this. There's actually no technical reason they need to do this. That you can build systems if you take the time. It took them obviously another 6 months to do that. And secondly, about the fair use, it's wrong to compare this to the way that humans read books. It's done on a completely different industrial scale. We're talking about hundreds of thousands or millions of books that are being read. A human couldn't read that number of books, couldn't memorize the content of the books like these systems can. It's already taking money away from the creators of that content. So if you might have noticed when you type a Google search query in today, you get this AI overview. That's provided by a language model, Google's Gemini probably, that was used on scraped content. The click-through rate now has plummeted. It's half what it used to be. So publishers are not getting the traffic coming their way. It's decimating the publishing industry because they're in competition now with the people who were previously providing the content that people would click on.
Senator Gosh.
Thank you. Can I pick up on where you left off there, Professor Walsh, and just ask the panel, is there a moral or philosophical distinction between creative work that's been produced by a human and creative work that's been produced by an AI model or an AI agent? And if so, how should that be reflected in the way we regulate this space, be it copyright or otherwise?
I could say a couple of a layperson's view on this, really. There's an enormous distinction between creative work produced by humans and what machines produce. Those machines are effectively sophisticated predictive text machines. So they can only work on what has been fed into them, and they will give you the most likely sequence of words in a mathematical algorithm. So it's not actually creative, it's predictive on the basis of hoovered up text that's already there. So creative work is about human communication and human self-knowledge, and that is a completely different thing. It's predictive text. My work is about stories that, for whatever reasons in our society, haven't been told. Those are the sorts of things that predictive text will never find for you. The stories of women lost to history, the stories of anti-Nazi or anti-Stasi activists who were ordinary people. So I think there's an enormous difference. The predictive text machine wants to feed off human creativity. I think that tells us everything.
There is I hate to say this, but there is a fascist coloration to the way it was presumed that our material was just taken, the way it was presumed that it should be taken, the way it was presumed that we were Luddites if we didn't joyfully agree to the surrender of our work. I have in my tie drawer a pistol holster which my father picked up on the battlefield of El Alamein. It's got a huge swastika in the back. And really, the difference between what is being proposed and that huge swastika is merely military might. Although it, God knows, it may come to that. We might lead the Writers' Army to glorious extinction in the Battle of Mossvale. In any case, I see this as very much the neoliberal version of they're not productive. However, we are productive because I know that during one of the artists' organisations during COVID estimated that our contribution to the Australian economy was $2 billion. That includes the entirety of warehousing books and driving trucks to deliver the book and people who work in bookstores. But it is not an insubstantial or despicable pittance, even though the novelist is paid rather like native spinners are making cloth at the end of the production line. We are primary producers, and the primary producers always get it in the neck, particularly under fascists, but not today, ladies and gentlemen.
And that's 30,000 workers as well in the book sector in Australia. So it's quite an enormous number of people.
Yes, when you go to the warehouses to sign copies, as you must have done, Anna, you see how many people there still are involved in book warehousing.
Sorry. On the leaving aside the moral and philosophical issues for a moment, we do think transparency for books is important. This goes to the question of the dilution of the market that we're seeing. So not only is there this infringement, but then there's also these tools being used to dilute the market for authors. So we know that in 2023, Amazon changed its upload policy to a maximum of 3 books a day. That is after the release of generative AI tools, if that tells you anything about the number of books being uploaded to the platform. As we heard, no one's writing a book in a day. So we are worried about the flood of AI-generated content on global retailers. Discoverability for Australian authors is already hard enough. That's going to make it impossible. But also, we're going to damage consumer confidence. If you're looking for a book and all you can find is low-quality AI-generated content, do you give up? Do you never find your next Sally Rippon book?
Can I add, Ms. Ribbon? Yeah. So as the Children's Laureate, I've been travelling the country the last couple of years, and you're probably most aware we have a national reading crisis. A third of our children in Australia aren't reading at levels that are expected to help them through life. And so children's authors travel around the country year after year, engaging with children, showing them that, yes, acquiring literacy is a skill and it will take time and it takes effort. And part of the way that we do that is we show them how long it's taken us to create books, that we've been doing it since we were children ourselves. And we show them the handmade books that we made when we were growing up. And we get them to write. And we see that's an effort. But at the end of the effort, there is a reward. And my concern is that if children think that books are just something you can download on a computer, you can feed into a program, why would they bother putting in that effort? I think it's so important we catch children, we help them recognise the importance of reading, and we don't just see that as something you can churn out of a computer.
And Professor Walsh, I think you had your hand up earlier.
I was just going to say that Anna described it beautifully, that ever since Ada Lovelace, the marvellous Victorian mathematician, the first computer programmer, wrote about this, we've doubted that computers would ever be created because they don't have the human experience. They don't have our emotions. They never fall in love, lose a loved one, have to contemplate their mortality. And great books speak to those themes, and computers will never be able to speak to those themes the way that humans can.
I think there's also an issue of democracy. Tom is alluding to it by calling us to the barricades in Mossman behind your grandfather's fascist pistol. I'm sure we're all there. But if in places where there is no local literature, which there would not be if no books were being written here, there will be no histories of Australia, there will be no accounts of our life here, there will be no Trent Daltons telling us stories of what it was like to grow up in Queensland. All of the people Caroline was mentioning, if you don't have your own local literature, you can't know yourself. And that applies, that's almost beyond economics. We live in a culture of which an economy is a part, and that culture is made by literature in large part and by writers, everything from political journalists to novelists. Countries which don't have a national literature are colonised countries, communist countries for obvious reasons, fascist countries don't have their own literature. It is very undemocratic to kill off a national literature, because that is how people know themselves, that's how you communicate, and it's how you communicate among yourselves and with your leaders. So a free and open society has healthy literature, and that's what we're trying to protect.
And your working material, Anna, is the language that is shared by 200 and 300 million Americans, and by the British, and by Malawians, in South Africans, etc., etc. So we are in a world in which English is pardon the contradiction, the lingua franca. And we just need a little bit of protection to get it there, because we've only got 25 million Australians to read our work. If you're going to have your dreams realised by some of the authors that you have mentioned, Anna, then copyright must be protected. The human copyright, as well as the IT copyright, even if Mr. Zuckerman has to bear a night on the street with the rest of us.
Thank you. Thank you, Chair. Thank you. Senator Henderson.
Thank you very much, Chair. Ms Rubin, you mentioned that some of your works have been misappropriated. Can you detail whether you've been able to enforce your rights and remedy that blatant theft of your works?
No, not as far as I'm aware. So I'm a member of the ASA, and I do get royalties from the Copyright Agency, also from ELR and PLR, which for a long time, until I was able to make enough from my books, were what sustained me while I taught writing as well and brought up a family. But I have no way of retrieving the money from those books that were stolen, as far as I'm aware.
And they were stolen by AI platforms?
I think originally, and you might correct me on this, it was LibGen that originally pirated all of the data. That's
LibGen, the Lib Library Genesis dataset. So it's a pirated books website, and we understand that some AI companies like Meta, OpenAI and Anthropic have reportedly used that dataset to train their AI tools. That's 7.5 million books, 81 million research papers.
And so Meta has entered into a contractual relationship with LibGen?
No, they've downloaded.
They've just taken
that
works.
I'm not sure that they have, but I would assume that they've just downloaded the content.
I mean, hang on, Chair. Sorry,
I just want to clarify.
No, Chair. I've just got the call. Sorry, I just would like to finish this. Thank you. Thank you, Chair.
Clarify for the hands.
So this is a very serious theft. You've got Meta stealing the works of Australian authors as well as authors from around the world. What action have you taken in relation to that conduct? Because that's just disgraceful.
So they've used the pirated books data set, LibGen, or that reportedly they have used it. So we don't know this only through the ongoing litigation in the United States. It was revealed in the discovery in one of the 50 court cases that this LibGen data set was reportedly used by Meta. And so as regards what Australian authors can do, the difficulty is that the AI training occurred presumably offshore, maybe in the United States where these companies are. So they don't, it's a jurisdictional issue. The infringing act occurred offshore. So what we've been saying is we need government intervention on this. We need to make sure that authors are compensated for the use of their work in this data set. So it's too late to seek consent for the works that are already included in these AI tools. We've been told by these companies that they can't remove them. That might be debatable, but it's too late. So authors should receive ongoing compensation for the length of the time that their works are included in those tools, and then licensed content should be used going forward.
So what changes to the law do you require to better protect authors? And isn't it open to you? Meta is domiciled here in Australia. Isn't it open to you to simply say to Meta, we're not going to cop this? We're not going to operate as authors in this country and have Meta or any other tech giant steal our work.
Yeah.
And frankly, you need to put the flame to the feet of Meta and any other tech company that does this, because this is just completely unacceptable. And on this committee, time and time again, on many, very many different issues, we've had to pull Meta and other tech companies into line when they've done the wrong thing. So surely it's open to you to do that now.
So as I said, I'm not a copyright lawyer, but the infringing act occurred overseas. So there's, we're slightly frustrated authors in being able to pursue that. So what we want is absolutely to abandon this TDM proposal, because that's creating uncertainty. Why would AI companies start to license content or continue to license content if there's the possibility that they might get it all for free anyway? So actually the impediment is having a TDM exception on the table. So that is what we would hope to see. The ASA has also been calling for some kind of mechanism to bring big tech to the table to license work, because past bad conduct demonstrates to us that they have a flagrant disregard for copyright, and they will do what they can if they can get away with it.
All right. Well, can I ask on notice if you can provide us with more details about how you've called, what mechanism that you've called for, or just any materials that you can provide us, because if your works are being stolen and you can't do anything about it, that is not good enough, and we should not tolerate that in our country. So we would welcome any further information. I'll be as quickly as I can. I know I want to get back to the chair who wants to ask a couple of further questions. Dr. Funder, you used to work for the Australian government as a lawyer. Can I just check in what capacity, which part of the government?
I worked in the Attorney General's Department as Senior Counsel in the Office of International Law.
So what do you say to the Attorney General now about her failure to raise her voice in the protection of your rights? Because we've seen lots of muted discussions, but nothing that gives creatives in this country the confidence that their rights are not going to be eroded.
I'm very hopeful that this government would not. I'm surprised at the amount of. I'm gratified in one way, but also surprised in another way at the amount of time that we are taking to discuss this issue, because it seems that the government is saying we have no plans to get rid of copyright protection for all creative industries in this country, and that's a line that they're repeating and repeating. So it may be that the Productivity Commission has come up with this fairly crazy idea to give away Australian cultural life for free forever to computer companies. But the government appears to be holding firm, and I would encourage the Attorney-General to continue to do so.
Well, maybe the Attorney-General could put out a media release or hold a press conference, or maybe the Prime Minister could hold a press conference, put out a media release making it clear that these rights are not going to be eroded, because that has not yet happened. Sorry, Mr Keneally, did you want to add to that?
I just wanted to point out how a cottage industry, like writing a novel, can quickly become a massive economic factor by becoming a movie. I remember seeing one day the filming of Christopher Koch novel, The Year of Living Dangerously, in a grove. There were electricians, there were costume artists, there were makeup artists, there were lighting artists, there were cameramen and women. And on that basis, I talked to a famed former Premier of Australia, Prime Minister of Australia, about this, and he said, well, I knew that if I gave you blokes a few dollars, it would all come back to us in spades. So we're not asking for charity again, we're asking for copyright.
We do have the screen industry representatives coming up after you. So
yes, I've got a Baz Luhrmann movie coming up, so that's why I'm not here on my own. But that's purely on my own behalf. But that's purely accidental. But it will, if they stop making movies, are really our dreams, and if they stop making movies of some of our books, that would be a terrible loss to us and to our children.
Thank you. Ms Overington, I just want to go briefly to you. You've spoken about your work being misappropriated. Is News Corp Australia able to support you in these breaches, in these copyright breaches?
Well, I write my books myself. I'm, as Thomas Keneally just described, a cottage industry. I'm not paid by anyone other than the publisher. But I would address that issue.
I've misunderstood that. I thought it was in relation to your work for News Corp. So thank you for clarifying.
No problem.
Yeah. So go on, please.
Oh, so yes, on the ethical question which was raised before, I think Australia has an opportunity here to be a moral and ethical leader in the world, because our copyright law already is gold class. It is the best in the world. It means that if you create something, if you write something, you own it. And if somebody wants to use it, they have to ask your permission, and if necessary, they have to pay you, and no one can take that away from you. And there are exemptions like these are being discussed all over the world, because the big AI companies are strolling the halls of power everywhere, seeking exemptions to copyright law, and they're getting them. They are getting them. But in Australia, we have an opportunity to stand firm and say, not here. Just like with our gun laws, and just like with the social media ban on for children under the age of 16, we can be first and we can be best, and we can definitely be on the side of right, because it is wrong to take things from people when they have created them without asking their permission and without offering to pay.
Ms Hayward, can I just very briefly turn to, last question, to another quick issue. Do our laws deal adequately with prominence and accessibility for Australian published works more broadly? I'm talking about things like e-books on Amazon.
I'm sorry, I don't quite understand
searchability for Australian authors over being flooded with international or, I guess now, AI slop.
Yeah, so certainly what we'd want to see is some kind of labelling for AI-generated content. That's obviously a regulation that we'd like to see. So we are considering ways that we can address labelling as an industry, so we've been in discussions about that. But I think transparency is needed for a range of reasons, not just on the training inputs, but also on the outputs.
I was also asking about prominence, but look, I might just put that and a couple of other questions on notice. We've run out of time. Thank you. Thanks, Chair.
Thank you. Thank you all for your evidence today and for coming along. We really appreciate it. If there's anything extra that you think we should know, please take your information as a supplementary submission. And certainly if you have any more interaction with government or the Productivity Commission that you think we should know, please hand it on through. Thank you.
Thank you.
Thank you.
And we're now going to go to our screen panel, and we have representatives online from Screen Producers Australia and the Australian Writers Guild. Now, I just want to check that you can hear us properly.
Yes.
Great. So I will get each of you to give us your full names and the capacities in which you're appearing today, please. And we'll start with Mr. Diener.
It's Matthew Diener, the CEO of Screen Producers Australia.
Thank you. And the Australian Writers Guild? I see there's two of you there.
Yeah, I'm not sure why. Can you hear me okay?
Yes, I can. Okay, that's...
Claire Pullen, I'm the group of the Australian Writers Guild and the Australian Writers Guild Authorship Collecting Society.
Okay, great.
Chair, we also have mentioned Andy Barclay from Screen Producers Australia.
Okay, sorry, Mr. Barclay, if you could introduce yourself.
You're on mute, Andy.
This Davis person's not here. He's next. In the next panel. Okay. Could we just get that off so it's not confusing?
Apologies for that. Andy Barclay from Screen Producers Australia, Director of Industry Growth.
Thank you. Could we go to you first, Mr. Diener? Have you got a short opening statement? We are running well and truly up against the clock, so
sure.
We'd prefer to get to questions, I think, if we could.
Yeah. Thank you, Chair. I might make a few statements and maybe submit our opening remarks to the committee. I want to, of course, acknowledge institutional owners and indicate we represent 800 businesses. AI is delivering gains and productivity benefits, but we believe all of this must sit on firm legal and market foundations. There's a live issue due to the number of unlicensed trainings that I think you're hearing. Most models have been trained on copyrighted works without authorisation, and we reject TDM exemption like a lot of people in the creative industries. And we do not want to see cutting out the people who own the rights and weaken incentives to invest and create new content. We do think that because of the available evidence, weakening copyright through broad TDM exemptions will not improve our capability or innovation, and we need to do something that is done properly here that empowers creatives and crew, and rather than replace them. We're very clear to work with everybody in the sector to do that. I think it's opportune for us to kind of flag very briefly. There's a number of things that the previous panel talked about, including the very impressive Thomas Keneally. We've got some tweets or some Truth Social messaging from the President of the United States. There's a number of issues in the screen industry generally that I think we should be remiss not to talk about. There's a heightened anxiety going on here. We've got continuing issues about the availability of local content on digital streaming platforms, which is not addressed. We've got rising costs and challenges meeting those rising costs at federal and state levels, and that isn't being met again. We've got a collapse of investment from commercial broadcasters because of changes that happened in 2021. Our national broadcasters are struggling after budget cuts. We've got to deal with a number of tax reform commitments that have been made but yet not enacted by government. And we have got a very brutal contracting environment that is undervaluing the true nature of our industry and challenging the ability for us to create and monetise intellectual property. The government is yet to address this abuse in market power. It's indicative of global technology businesses, of which we're talking about across creative industries, but it is the practical reality. Without interventions and management of these relationships, we've got a major problem, and they're flowing into relationships, including with the ABC. So all of that is a critical piece.
Thank you, Mr. Diener. Ms. Pullen.
Wadamoy, everyone. Thank you again to the committee for making the video facility available. I'm on my way to Mumbai for our International Guilds meeting where we'll be talking a lot about AI. For those of you that might not know, our collecting society distributes millions in royalties to screen authors every year, an income stream that those authors have because they have copyright. My members' copyrighted works have been infringed by big tech companies and fed into large language models without their consent or any compensation. Artists and creators deserve to be able to make a living from their work, not just because every worker deserves that, but because artists take time to develop their practice and their craft. So what they make is good and people want more of what they make, which contributes to our creative economy. This entire sector of our economy, where workers are already precarious in their incomes, is at risk because of the behaviour of big tech companies, not helped by the Productivity Commission interim report. Now, I have the benefit of an arts education focused on the critical interrogation of text. So on reading the Productivity Commission report, it is very clear that regardless of how they might try to retroactively frame it, they are advocating for the interests of big technology companies, mostly foreign-owned, at the expense of Australian creators and small businesses. The arguments from the Productivity Commission are incredibly similar to those of the big tech companies. Both are characterised in our experience by a lack of understanding of copyright and a disinterest in our cultural sovereignty and the survival of our industry. Also missing from the Productivity Commission report was any economic modelling on the contribution that creative works make to our economy, which seems an odd omission. So we did some, and this will be in our submission to the committee. But I can say that I represent workers who create a contribution to the economy of about $500 million a year. And it is our collective view that it is in Australia's economic and cultural best interest to ensure we can all keep creating.
Thank you. I'm going to go to questions. Senator Gosh.
Sure. Thank you very much to both witnesses for being here today. Can I ask, what is, in your view, the best way to ensure that Australian creatives get paid for their content in the AI landscape? Or put another way, how do we get big tech to come to the table and get on board with offering the opportunity to provide or deny consent to use works and then pay for works that they're using?
I might go first, Matt and Andy, if that's all right. I think the second part of your question is where we should start. When we surveyed our members on this about a year ago, and we're doing another survey at the moment, a lot of our members don't want their content licensed. They don't want their works to be fed to these models. So that's kind of where we start, is whatever framework we come up with has to be based on what the rights holder wants to do. So that's sort of the starting point. And in terms of being paid, there's a variety of models across our industry. Screen is slightly different to the other areas of performance writing that my members work in. I'm open to any and all options that are put to me. I think what I would say is that not a single tech company has come to us and said, we want to license your members' work, we want to talk about how this might work and what value you can add. How do we do that? Like, I operate a collecting society. I could probably figure out a way to do a licence for some work that my members create. Probably need to talk to Matt and Andy about how that would work for the Part 4 cinematographic work as opposed to Part 3 literary work. But no one's come to us and said, how do we license this? And that's the starting point, is needs to talk to these big tech companies who, I think it's become clear over the course of today, have form on not behaving terribly well in our territory before AI.
I agree with that, and I think that the starting piece it is this idea that you don't even need to have a conversation. We're dealing with companies that transcend most global economies or national economies. So the capacity of essentially an independent mum and dad, either business or creative or however you frame that, as a capacity to engage, we're very much in needing a leadership piece from government to set the parameters clearly so that we've got that pathway for engagement. Because I don't think you can do anything. And I agree with there needs to be a permission-based system. There needs to be structure around this. We've got so many good things in our current environment that could be applied to what is working for licensing regimes when and if that is being appropriately agreed by various various parts of our ecology, but you can't just take, and you need to set an expectation from government as part of that exercise. I don't know if Andy wants to say anything further to that, but please feel free to.
No, I have nothing else further to add for that.
Could I just ask, it seems very clear that, like other areas of the creative industries, Productivity Commission didn't consult with you, and previous to that, of course, these tech companies have not been in any way concerned about abiding by existing law, and that is copyright. You've obviously had to deal with these big tech companies previously when it comes to the transformation from broadcast to streaming and the relationship there. Have you felt as though government has learnt anything for how tech companies have engaged with the screen sector in Australia on the streaming issue versus now dealing with AI and the lack of payment for your members' work?
Shall I go first, Claire? I feel like it's a good Senator to make the analogy there, because I feel like it's not exactly the same conversation, but it's analogous of a sort of land grab. There's a sort of it feels like there's a set play in place by a number of these businesses, which is to sort of almost change the market through dominating, taking over pieces, sort of disrupting traditional forms of communicating or marketing or contracting, and damage all of that, and then sort of try to, people can't race fast enough to deal with that, and then government in particular is sort of chasing its tail in trying to catch up with how that market behaviour is operated, and we end up with effectively everybody scrambling for what's left from that carnage, and I feel we're in the same sort of problem here, where we haven't kind of moved quickly and firmly enough to navigate the framework we want. I think other territories have seen this coming better than we do. They set up frameworks. They enable the sort of environment to operate with at least a clear set of rules, and they get adjusted over time. I think, Australia, for example, with the streaming regulation, anticipated some of this by when it did a free trade agreement. It set up the idea that they could set these in train. We were the first on the convergence review in 2011, 12, maybe before that even, to set out what it was that we thought was an expectation from streaming services, and then we drag our tail and don't get onto it because of either a feeling, and indeed maybe it's the size of our economy, but these businesses seem to come in and bully government to some extent to say essentially that you will lose productivity, economic success, jobs, unless you agree to the demands of the day, either in copyright form. You will miss out on this golden goose of Australian creativity or Australian production, Australian data centres or whatever it is. And it seems that we get beholden or captured by either the intense lobbying, and we know that that's incredibly big and unable to be matched pretty by any other industry in this process. So it's a kind of a game of trying to keep up with it, but in the absence of very firm markers, and indeed seeing through the kind of I wouldn't say. The kind of, to be really unfair, but the bullshit of it, to kind of see through that and go, okay, this is what's real, what isn't. Sorry,
can I ask, and we are really tight on time, I want to, you've said that our government has kind of, and this is successive governments, of course, but they're kind of dragging their tail on responding fast enough and being bamboozled by these big overseas tech companies. We've seen that with screen quotas. We're seeing that now with AI. I guess to contrast that with what was announced in the United States overnight, 100% tariff on films outside of America. And it's just extraordinary. So these companies want to come to Australia, steal our work, make a profit off it, and the President of the United States wants to whack 100% tariff on Australian film. I mean, it's just they want their cake and eat it too. What's
yes.
your response? I mean, I just find it extraordinary. Like what is an Australian film industry meant to do when we've got governments not standing up for our industry against these big tech companies, US-based mainly, and now you've got the US president protecting them and their profits more than anybody else's? Where's it going to leave Australian film?
Do you want me to jump in, Claire, or do you want to? I mean, I think it is a massive exposure. We're not. Look, there's two things going on. One of the major thing I think that we have over-egged in our market, and we've got to make sure we don't, and we're not as bad as other territories, is the role of location-based international work. It has a role to play, but we need to double down always on our own stories, our own creatives, our own writers, our own directors, our own talent to tell our own stories. That's a starting piece, right? So the market, from that message from the President, the people who would be most concerned about it are the United Kingdom and probably Canada, who have very much built big industry pieces. Australia doesn't have quite that level of exercise, but what is missing is the counterbalance from what was been developed over the last couple of years, in that we haven't done the streaming regulation. We haven't lent into our institutions and doubled down on investments through our own creative storytelling. That is we can't fully inoculate ourselves, but it is the counterbalance to what's going on here, and it needs to be an urgent response from government to deal with these things, because the market in Australia and the industry in Australia shouldn't be exposed to global forces like that. It should be that we've got this baseline of absolutely important creative work and ability for people to have careers and not have to leave the country to deal with opportunities in other territories rather than in our own. So, that is the message. And it is the case that Australia has these great opportunities to partner in the Asia Pacific with co-productions in India and lean into Europe, which has been a stable base of kind of ongoing work. So we have these opportunities to move the dial here and not be beholden to essentially one marketplace. And I think that the lesson is we do all this at our peril and across the economy, not just in creative industries. But Claire, do you want to add to that?
Thank you. Claire, if you could respond just briefly, and then we're going to have to move on. So thank you.
I'll be super quick. Films are produced outside the US because taxpayer money is spent in those jurisdictions, attracting production wherever they are. Australia is not unique in that. We spend a lot of money attracting foreign productions here. What we should be doing, I think, with those incentives is incentivising the development and ownership of Australian intellectual property by Australians. So we can use that money to incentivise a different part of the pipeline. The problem with that is we can do all of that and retool that taxpayer money to deliver a more certain market and more certain jobs. And then Meta and Amazon and Google are going to have a transcription software, listen to it, pirate it, and feed it into an AI model and destroy all the value we've just created from that film.
Thank you. Thank you all for joining us today. Apologies for the swiftness, but we are running up against the clock. So much important evidence we've collected today, and I just want to thank you for participating. If there's anything extra that you'd like to give, please put in a supplementary submission.
Thank you, Senators. It's a good time, not necessarily a long time, but it's great. Thank you.
Thank you.
Thank you, Mr. Diener.
Great. Our next witnesses are joining us from the Human Technology Institute at the University Technology Sydney, both online. Thank you, Professor Davis and Ms. Sasha. Could we please get you both to say your full names and capacities in which you appear?
Thank you, Chair. I'm Professor Nicholas John Davis, here in my capacity as co-director of the UTS Human Technology Institute.
Thank you.
And I'm Sarah Sacher. I'm a Responsible Technology Policy Specialist at the Human Technology Institute.
Thank you both for joining us. Now, do you have a opening statement, or are you keen just to go to... Yep, okay, great. Professor Davis, go ahead.
Thank you, Chair. The UTS Human Technology Institute, we focus on AI and regulation, most recently looking at the economics and productivity implications of AI adoption. And our expertise is really at a human-centred approach to AI policy, examining, with a focus on legal and human rights. And I say that also to not make the claim that we are experts in intellectual property law. So our evidence today draws on our response on the Productivity Commission's interim report on harnessing data and digital technology. And there and here we make three, I think, important points for this inquiry. First, it's really important that Australia and Australian policymakers take into account both the opportunities and the risks in our response to AI. We're seeing that many stakeholders advocating a laissez-faire regulatory approach to AI justify this by reference to very optimistic best-case scenario modelling on the economic impact of increased AI adoption. But we need Australia's regulatory and policy response to be founded on a realistic assessment of opportunities and the risks likely to flow from that adoption. And we should be wary of adopting a path based on gains to the economy that are at best speculative, while downplaying the known risks and harms, some of which, in fact, many of which, the creative sector has been the first to experience. Right now, the creative sector in Australia is facing threats to intellectual property owned by Australian artists, musicians and writers. Those threats, which include unlawful copying and reproduction of Australian-owned works by foreign actors and others, create serious risks for Australian creatives, their families, as well as undermining an important part of the Australian economy. So Australia's policy response must really properly take into account these economic and social risks rather than relying on just one side of the ledger, those positive economic assessments promoted largely by self-interested parties. And let me be further clear, it's not an exaggeration to observe that a significant part of Australia's cultural life is at stake. Some things cannot be reduced to a purely economic argument. The value of arts and culture is one of them. So 2 final points here. The second point of our submission is that we need to take a proactive regulatory response, one that pays proportionate attention to both AI opportunities and harms. And the key to this, we see, is strengthening existing laws to provide better protections, supporting the law, regulators, courts to effectively enforce those rights. And of course, we do need flexible legislation to address and understand high-risk use cases of AI. And third and finally, good regulation can support productivity while also protecting people's rights. We have shown in our research, and we strongly believe, that proportionate, pragmatic regulation for AI will lead to higher productivity by providing regulatory certainty for business, by making AI products and services more trustworthy for citizens. And these goals are aligned with and complemented by protecting the rights of Australians. Chair, Senators, we really must avoid a future where a handful of large corporations capture most of the productivity gains, while Australians and local industries miss out and bear a disproportionate share of the risks.
Thank you. And as you said, your work is broader, obviously, than just the impact of AI on Australian content, but you're seeing and content creators, but you're seeing that as a particular issue, and I imagine specifically because of the interim report from the Productivity Commission. Firstly, were you engaged in any of the consultations with the Productivity Commission as a kind of third-party expert of, how these issues interact?
We've been in previous reports in dialogue with the Productivity Commission, but we weren't involved in the consultations prior to the release of the report, specifically on that text and data mining exception.
Okay. And have you seen how other countries around the world are dealing with this issue? I'm interested as to international examples. Keeping in mind, of course, is that a lot of the deals that have been done, licence deals that have been global deals, actually. So, that sit outside jurisdictions or across jurisdictions.
For this, I'll pass over to my colleague, Sarah.
Thanks, Nick. And I'll just note again that we aren't IP experts, but having looked at the international law in this space, I think a sort of key point to make is that there isn't necessarily a North Star that we can look to, and it's quite an uncertain legal space internationally. And sometimes you hear the argument that Australia is falling behind by not sort of following some of these jurisdictions, but I think that it's actually less clear a path for Australia than it might seem. We know that in the US there have been many challenges to the fair use case exception, and it's quite an uncertain area of the law. In the EU, there's been a recent report put out from the European Parliament Legal Committee that's sort of querying whether the opt-out provision is fit for purpose in the EU. The UK had a bit of a false start by initially proposing a broad text and data mining exemption for consultation and then withdrawing it, and now they're trying a new approach that's more aligned with the EU approach. And these are the jurisdictions that we would generally look to, but I think Australia's approach, as Australia develops an approach, we can definitely learn from these jurisdictions, but it's maybe a lesson for us to think about an approach that is aligned with our own legal and political system and our own values, and maybe forge our own path on this.
Mm-hmm. Thank you. You talk about being able to do both things at once. Use technology like artificial intelligence and these large AI-generated models to be both productive and boost productivity, but to also protect rights. Am I understanding from you the subtext of that being that if you don't protect rights, the medium or long-term productivity gains actually decrease anyway?
Exactly. So 3 important channels that we look at here on this productivity equation. One is if we fail to provide regulatory certainty, we know that the market will pause investment, and particularly investment in not just the technologies themselves, but the $5 Australian for every $1 in tech that's required in training and organisational support, workforce transition, workforce planning, those complementary investments that actually result in the productivity upside. It's not the paying the subscription that matters, it's how you use it in an organisation, to think just of that analogy. Those complementary investments are quite sensitive to a clear pathway on regulation. So you see this distorting effect in the literature and the evidence on productivity, where people will fail to make those big changes that get the longer term sustainable gains, and they'll default to kind of more small and edgy and less useful cases, as well as you'll end up with lots of shadow AI in the economy that will kind of distort things and harm us in other ways. So that's one channel. The second key channel is an offsetting set of costs. So even if you think there are benefits in some parts of the economy, if you fail to protect rights, we will see costs in livelihoods destroyed, industries taken away. One metaphor that's been resonating in my thinking about the text and data mining proposal, this exception, is that a broad exception in this space would be like strip mining Australia's creative industry, just taking off the topsoil, carting it away and processing it for data. Once you do that with topsoil, you don't replace it easily, right? If we were to create an opt-out model, right, a model where you say, well, creatives have to tell someone somehow that they don't want to be part of that system, that's a bit more like fracking. We're going to come at it sideways underground and extract value from you anyway. And you've got to really know what's happening, be sophisticated and on your game in order to pass that. So those costs to the industry, to the economy, to individuals by undermining rights, I think you had Lizzie O'Shea as a witness earlier. Mm-hmm. If you're going to make a change to rights, it must be justified and proportionate, and we're not seeing that on the productivity side of the equation there at all. So that's the second angle here. The third angle here is really public support and trust, uptake and engagement with these systems. Right now, Australians are rightly sceptical of AI systems where we have one of the lowest levels of trust in the world. That's not something to be changed because we're untrusting people. That's because we need trustworthy systems. And when we look at data on regulation, I think it's 61% of Australians favour a balanced but firm approach to AI regulation that does do what you mentioned, Senator, protect rights while fostering innovation. And if you take away a balanced approach and just leave a firm, strict AI regulation, which you would think that would turn more people off, actually the numbers jump even higher to 64%. So Australians are rightly concerned about these systems, and they're willing to sacrifice some of those productivity gains to protect their rights.
So at the moment, Australia has no standalone regulation for artificial intelligence, and particularly these AI generated learning models. From your research and your work, do you have a view as to whether we need a standalone AI Act?
I might start and bring in Sarah, but I'll say I don't think that a standalone AI Act is the best way forward. The most pragmatic way forward is to work at the targeted law reform and the pragmatic regulatory uplift that we need under existing technology-neutral law. I think it would, and our research shows that it would potentially be duplicative as well as highly complex to go in that direction. It wouldn't provide the regulatory certainty that will drive investment in our analysis. And the truth is, we already have great law, including in the copyright sector. Laws do apply, and I think previous witnesses have given evidence to this effect. Licensing regimes are in operation, and the laws are there. What is the biggest challenge in this space is actually enforcement, and some absolutely critical areas of law reform where Australians do need and deserve better protection, particularly around privacy reform, which is something that the government has committed to do. So maybe I'll pass over to Sarah just to add to those points.
I just might add that I think a really key point is to have coordinated reform to technology neutral law and to prioritise where the harms are most acute. So privacy, copyright, that we know where these sort of issues arise, to do that urgently and to do it behind a really clear regulatory objective that ensures that our law reform processes are aligned and that are achieving a goal that takes into account, again, both the opportunities and the risks and doesn't lead to fragmentation and complexity, and to have a really clear articulation of things like risk so that we can have a sort of cohesive approach, because this is a technology that obviously cuts across many different policy areas and parts of the economy, so that cohesion is really key.
Thank you. I'm interested. I mean, you've said that enforcement is the biggest challenge, and I guess we're hearing that all over the place when it comes to how Australia deals with these big global tech companies, majority of which, of course, based in the US, but they scatter their businesses. Interests across various parts of the globe to make it harder for enforcement to happen. It's been put to us today that one of the key missing planks in all of this is the transparency of what these AI models are scraping, what data they're collecting and mining, and making sure it's tagged appropriately so people at least know. How do you enforce copyright law if you don't even know your work's been stolen?
Yeah, I think it's just to kind of comment on that, Senator. We do see this story that this narrative that the most powerful large language models, or large language models even at all, cannot work without access to this scale of really unlawfully obtained material, and that therefore there's this really stark choice: do you want the large language model or do you want your rights? I think that's really misleading right now. The first point being that countries such as Switzerland have gone into training from scratch large language models that are performing at about what the frontier was a year ago, so not like the frontier right today, but incredibly good models, using purely lawfully obtained licensed materials where you can actually view their robots.txt. You can view the file of everything that they have sucked up. Now, some of that may be copyrighted material that hasn't been properly compensated. I can't speak to the details because I haven't gone through all the data. But the point is they have made a huge effort to not repeat the errors and moves of their predecessors in saying, yeah, let's just suck up every artistic work of people like my colleague Anna Funder and others and use that to train the model. And even though they've not done that, they still have a pretty great large language model. So I think breaking that narrative for a start to say that it's not just a matter of necessity is a first key step here. The second step is to realise that international enforcement of copyright and rights is very hard, and it's even harder when these are incredibly powerful kind of corporations and organisations. That's always been the case. But I really struggle to see why then the answer should be that we give them more. And I'm just worried that then the answer is, oh, well, if we can't enforce it, let's just give away the farm. We're searching in this area of thinking about a text and data mining exception. On that issue, I feel fairly strongly. I would love to find new ways of enforcing Australians' rights in a situation with these massive power asymmetries and sovereignty issues.
Thank you. Any other burning questions? No. Thank you both for joining us today and giving us your time and submissions. We really appreciate it. If there's anything extra, please put in a supplementary, any supplementary information you think would be helpful.
Thank you, Chair. Thank you, Senators.
Thank you. Great. Our final panel for this afternoon is the Attorney General's Department. If we could just invite you all up to the table. You know the usual drill about parliamentary privilege and protection of witnesses and evidence. I've previously reminded our senators that we, around the rules of asking for opinions on policy of department officers, doesn't preclude questions asking for explanations or factual questions about when and how policies were adopted. And of course, if you are not able to answer a question, you can refer the questions to superior officers or to ministers. For the Hansard record, could I get you both to state your full names and the capacities in which you appear?
Jenna Priestley, I'm the Assistant Secretary of the Commercial and Copyright Law Branch in the Attorney General's Department.
Thank you.
Ryan Webb, I'm the Director of the Copyright Enforcement and AI section in Jenna's branch.
Great, thank you. Do you have an opening statement for us?
No, Senator.
No, okay. We will go straight to questions then, and I might just kick off by asking, does the Australian government have a position on whether text and data mining should be given an exemption under Australian copyright?
I think that's a matter for government, but I would point to numerous public statements that the Attorney General and other ministers have made that the government has no plans to weaken copyright law and that they value the contribution of Australia's creatives, artists, musicians and journalists.
Have you, obviously this cuts across a few different departments, so I appreciate you being here today. Ultimately you're in charge of the Copyright Act, but there's obviously a lot of conversation out of this Productivity Commission paper that cuts across other departments. Is there a cross-government or cross-departmental task force working on this issue, or how are you engaging with Treasury, with industry, science? I'm trying to understand who's really driving this
So yeah, we are responsible for the Copyright Act, and in December 2023, the government established the Copyright and AI Reference Group, which contains around about 70 members from the creative, the media, the education sector, collecting institutions, collecting societies, and the tech sector. So that's a mechanism that we're using to engage with industry stakeholders, and then sort of separately to that, as with any sort of policy development, we're engaging closely with our colleagues across government on copyright specific issues. That includes the Department of the Prime Minister and Cabinet, Treasury, Industry, Science and Resources, and the Office for the Arts and Communications as well.
When was the last time the reference group met?
So the reference group itself hasn't met since March, so before the election, but we have been having targeted conversations with a range of stakeholders over the last few months.
Okay, so the reference group itself hasn't met since before the election, since this Productivity Commission paper came out. Why is that? I mean, I assume if the reference group is specifically about AI and copyright, I mean, there's been a lot of concern raised. I'm interested why the reference group wouldn't have met.
So since the last reference group meeting, the department has been taking significant amount of policy work to understand the issues and the perspective of different industries. While we haven't had a full reference group meeting, as I mentioned before, we have had targeted conversations with a range of stakeholders, which has helped inform advice to the Attorney General on potential next steps. Our advice to government is currently under consideration by government, but our intent is to hold a full reference group meeting shortly, hopefully next month. And we've advised the reference group of our intent to hold a meeting shortly as well.
Okay, and that's because there will be a position to be discussed. You're saying it's currently, the current position of government is being considered?
I'm saying that we are intending to hold a reference group meeting next month.
Right. Next month as in October, which is tomorrow. So next week?
We don't have a date settled yet, Senator.
Okay. Would you expect it to be in the next week?
I think we would like to hold it as soon as possible, but it is a big group of people, so they need an appropriate amount of time to prepare for the meeting as well. So I think our intent is to hold it as soon as we can.
Mm-hmm. And is the intent to discuss a way forward on this issue?
I think our intent is, yes, to have a discussion about potential options on a way forward on this issue.
In terms of your targeted conversations, who have you had targeted conversations with?
So I don't have a list of the specific people, but in general terms, we've spoken to representatives from the creative and media sectors, the technology industry and the education sector. I'll just defer to my colleague to see if there's anyone else that I've missed off that list.
No one that wouldn't fall into one of those categories.
Could I ask you to take on notice the list of who you've had targeted conversations with, please?
Yes, we can take that on notice.
And the times of those meetings, given particularly, you would have seen a lot of the evidence today that a big part of the creative industries, in fact all of the creative industries, were left out of the Productivity Commission's consultations.
We can take that on notice, Senator.
Do you have has the government got a response to the fact that the Productivity Commission did not consult with the creative sector?
I think the Productivity Commission sits within the Treasury portfolio, so I think that the Productivity Commission operates at sort of arm's length from the government, but I don't think it would be appropriate for me to sort of comment on the government's position.
Government doesn't have an official position as to whether they think that's appropriate, that the creative sector's been left out of the conversations?
I don't think that's something that we can comment on as the Attorney General's department.
We might put on notice a question to the Minister for Communications and Arts, whether they think it's appropriate. In this reference group, are there representatives from other arms of government involved in these conversations, or is it just the Attorney General's Department?
So in terms of the membership itself, it's the Attorney General's Department as the chair and then industry bodies, but we do invite other arms of government as observers. And I'll just turn to my colleague who has a list available to see if he's got the information on hand about who we have invited to reference group meetings in the past.
We absolutely have made a practice of inviting our colleagues in government who are working on adjacent areas of AI policy to our own to attend those meetings as observers. There have been occasions where things that we've been working on have crossed over to some extent, say with the Department of Industry and its own consultation on AI regulation, where representatives from that department have given a little bit of background on work that they've been doing to reference group participants. I believe, just having a quick glance down the list that's on our website, technically the CSIRO may count as a government institution that is also a participant, but as Jen has said, most of our observation from within government has been as an observer rather than as a participant.
Mm-hmm. And does the Attorney General's Department have a framework by which you're considering whether the Copyright Act is fit for purpose?
So I think our position would be that Australia's copyright law provides an adaptable market-based framework that is capable of providing economic rights to those that create new material, underpinning licensing arrangements through which they can permit others to use their copyright material. And I think generally what we've heard from stakeholders is that the Act is fit for purpose. As part of our consultations with the reference group early on in the reference group process, we did conduct a consultation where we sought information from reference group members about potential areas that we could focus on in considering whether the Copyright Act needed amendment in response to AI. So I think transparency was one of those issues that was identified through that process, and we've conducted a consultation on that with the reference group late last year. This issue around how the Copyright Act facilitates the use of copyright material as an input to AI development was another issue. Remuneration for overseas use of copyright material was a third issue, and I believe the fourth issue was around whether additional protections were required under the Act. So that's sort of the general framework that we've been operating under to date.
Mm-hmm. Have any of your targeted conversations been with OpenAI?
I'll have to take that on notice, Senator. I can't recall a conversation off the top of my head, but I'll take that on notice to double check.
Dr. Webb, have you spoken to Dr. AI? Dr. Webb, have you spoken to OpenAI about this matter?
I've never personally spoken to OpenAI. We definitely haven't since the release of the Productivity Commission's report. We can check references just to make sure that there's not something I'm forgetting from last year, but certainly not recently.
And how about the Tech Council? Has there been any targeted conversations with the Tech Council?
We do have semi-regular conversations with the Tech Council. I just would again need to take on notice how recently that was and whether we spoke about this issue specifically.
That would be helpful to know. The Tech Council are a member of this reference group?
Yes.
And OpenAI a member of this reference group?
Yes.
The reference group membership is available online, is it?
That's correct.
Yeah. Okay. I'll hand over to other colleagues for now. Senator Gosh.
Thank you. Thanks for being here today. I'm interested in this enforcement element because I think some of the evidence we've heard today is that the Copyright Act and the rights that it creates are fit for purpose and, in fact, in some ways are of a very high standard. But there is a gap between those rights as they exist and the enforcement of those rights, particularly in relation to companies that operate overseas or breaches of the laws that might occur overseas. And I was wondering if you could speak to your work in enforcement and how it relates to protecting the rights of Australian creatives.
I would note that copyright is a civil enforcement system, so it does require rights holders to enforce their own rights. There is no government regulator, but I guess we are aware of this issue around enforcement, and it's not specific to AI. I think it applies to copyright enforcement more broadly. So we have been looking at options to make the process easier for rights holders. For example, we've recently been working with IP Australia on its IP First Response tool, which is an online tool which provides information to rights holders about different enforcement options to help them sort of navigate the process. That's currently being released in an alpha version, and at the moment the alpha version that's available online is mainly focused on the registered rights, but we've been working with IP Australia with the intent that the next version include more information on copyright. And we have also been considering reform options to reduce barriers for rights holders to use the legal system to enforce their rights as well, and this work that we've been doing with IP Australia forms part of that.
I understand that the government doesn't enforce the rights of individual holders, but perhaps if you might let me know what falls within then the copyright enforcement and AI section of the department and what you do, Dr. Webb.
Certainly. So a large part of my work is to support the department's engagement with the Copyright and AI Reference Group that Jenna has just recently described, and to coordinate with other departments to provide advice to government on options it could consider to address copyright and AI issues that have been brought up by stakeholders through that forum and through other consultation forums such as this one and other parliamentary processes. The enforcement side of our work, I guess it's a function that isn't isolated to AI. It's a function that, since enforcement is a significant concern for a lot of rights holders and has been for many years, part of our policy responsibility in terms of advising government is on whether our settings are striking the right balance for people who have been granted rights under copyright law to then be able to use our legal system and other mechanisms that industry has come up with to enforce those rights. That's an ongoing conversation in a policy sense rather than a regulatory intervention sense, because as Jenna said, we don't, as the Attorney General's Department, have any regulatory powers or a role in enforcing other people's rights. But we ran a copyright enforcement review several years ago to seek broad views from the sector on how well they thought the copyright framework that we have now is working. One of the issues that came up with that was the one that Jenna's just mentioned about seeking to find some options government could consider to make navigating the legal system easier for rights holders who believe that their copyright has been infringed.
Did that review or did the reference group consider, or has the reference group considered other jurisdictions where there are options that maybe are a bit easier, more streamlined or less conventional than trying to enforce rights in courts or tribunals?
Yeah, so as part of that review, that did look at some overseas options, particularly in the US and the UK, around small claims jurisdictions. And that was something that we sought feedback on and I think was generally supported by stakeholders as part of that review.
Thank you. Thank you, Chair.
I will just go to Senator Henderson in a sec, but has OpenAI paid for any Australian content to be used in its training models?
That's not information that we would necessarily have, Senator, beyond what's in the public domain.
I think the only news report that springs to mind was the licensing deal that was announced with News Corp, which, while with News Corp globally, included News Corp's Australian publications.
Yes, I think that's right. I guess I'm wondering why we're consulting with them if they're not even following current Australian law.
I'd say that the reference group, we've taken a very open approach to membership on the reference group, so as long as people meet the criteria that are in sort of the terms of reference, we have kept that forum quite open because we are aware that there's lots of different sectors, different people, individuals, academics with an interest, and we want to make sure that we're casting our consultation net broadly to provide informed advice to government.
The law currently requires companies like AI to pay for the content, doesn't it?
As a general proposition under Australia's copyright law, if you're doing something that involves an act comprised in copyright, so copying, communication, broadcasting, unless there's an existing exemption in Australian copyright law, you do need to seek permission and agree terms from the copyright owner or a representative acting on their behalf.
And if you don't do that, you're stealing it.
Well, this is for when the act comprising copyright occurs within Australia. That's the law that applies within Australia.
I find it's clearly baffling to me that there's a company operating in Australia, has lobbyists in Australia, spend hours upon hours marching the halls in this building, lobbying politicians. They're on government reference groups, and they're stealing Australians' work. They're operating illegally. And yet they're just welcomed into the Parliament House, welcomed into government offices, welcomed into ministers' offices. I mean, no wonder these tech guys think that they can just write the rules for themselves. Senator Henderson.
Thank you very much, Chair. Good afternoon to you both. Can you confirm whether the government has abandoned the text and data mining exemption for the Copyright Act?
So again, that's a matter for government, and I draw your attention to public statements that the Attorney-General and other government ministers have made that the government has no plans to weaken Australia's copyright laws.
Could you please provide on notice all of the statements made by the government and all correspondence concerning this issue to government ministers, please?
We can definitely undertake...
Do it within your own department.
We'll take on notice, but I note that we might not have access to all of the statements that have been made by the Attorney-General and government ministers, but we'll do our best to collate as many as we can.
I would have thought that your minister, you would have access to all of those statements. It's your department.
Just from the Attorney-General, the statements
from
the
Attorney-General,
yes.
yes.
We can take that on notice, yes.
And then if you could also provide on notice all of the correspondence received by the Attorney-General in relation to this matter.
From stakeholders outside of government.
Yeah.
We'll see if we can take that on notice as long as there's no privacy considerations or anything like that.
You just need to comply. Obviously, there are standing orders concerning requests for documents. Privacy may or may not be an issue.
Okay, we'll take that on notice,
Yep,
Senator.
thank you. Was the department itself consulted in relation to the Productivity Commission's interim report?
We did meet with the Productivity Commission earlier in the year to talk generally about copyright and the different views that we had heard from stakeholders about various copyright and AI issues. We didn't see a draft of the interim report.
Has the Minister or the department raised any concerns about the PC's interim report?
We have made a submission to the PC, which provides some information about the department's work on this issue. I don't believe it's been published on the PC's website yet, though.
We have a copy of it.
If we could please have a copy of that. Do you have that with you?
I have one copy with me that I was hoping to be able to refer to in my answers if needed, so could I take that on notice and provide it afterwards?
Yes, thank you. That would be appreciated. So that submission was made at what time?
I would have to go back and check our
Prior
records.
to the interim report being handed down?
No, after the interim report. So it's a submission made
and so in terms of the
substance report.
And in terms of the substance of that submission, can you summarise what has been said in that submission?
I can.
I mean, have you raised concerns about this particular issue and the protection of copyright owners' precious property?
So what we have set out is how the Copyright Act operates in Australia, that it provides an adaptable market-based framework, that it underpins licensing arrangements, and that licenses are familiar existing legal mechanisms that can support innovation and contribute to productivity. We've noted our work on the Copyright and AI Reference Group.
And in that submission, did you oppose the proposal for a text and data mining fair dealing exemption?
We didn't express a view on a text and data mining exception.
And why is that?
well, it's under consideration by the Productivity Commission at the moment, but I would just refer back to the public statements that the Attorney-General and other ministers have made about not weakening Australia's copyright laws.
So was the submission made in the name of the Attorney-General?
No, it's in the Attorney-General's departments.
Okay, and so there's been no concerns raised in relation to that particular provision?
No, the department's position, the position of government is a matter for government, so we were providing factual information as part of our submission to the Productivity Commission.
Yeah, just let me finish, Sarah, sorry. The decisions the government makes are a matter for government. What I'm asking is factual questions. So why weren't concerns raised about this proposal?
In our submission to the interim report, which we provided after the report was raised, we've set out the factual information about how Australia's copyright framework currently operates and the work that we've been doing as the reference group.
Is that because the Productivity Commission got elements of its report wrong?
I think largely our submission as it related to copyright was trying to provide some information on the licensing aspect that was referred to in brief in the Productivity Commission's report, but at less length than the text and data mining exception, to try to, I guess, shine a little bit of light on the other side of the conversation that many stakeholders have told us that they see as a solution to this issue. But we've tried to, as much as possible, reflect the diversity of opinions that we've heard from stakeholders through the reference group.
I mean, I know you're probably trying to be diplomatic here, but based on the interim report, it doesn't look like the Productivity Commission understood intellectual property law in this country. Is that a fair observation?
I don't think I can express an opinion on the Productivity Commission's report. I can only sort of talk to our submission that we have made.
But there were deficiencies, weren't there, in terms of the Productivity Commission's understanding of IP law, including the extensive licensing regimes available to copyright owners?
I don't have the Productivity Commission's report with me, so I can't go back and refer to it line by line to be able to provide a view on that. So I think we can take that on notice.
So can I also ask you for the department's view about the consequences for losing copyright protection to AI platforms? We've heard some pretty damning evidence today. Was the department or the minister aware of those consequences? And I guess why didn't? I mean, the whole process of producing the interim report seems very deficient, inadequate consultation. The Productivity Commission has, in a number of respects, just got the law wrong or mischaracterised the law. It's not a good reflection on the government's work, I would put to you. And I know you don't... I don't want to put you in the position of expressing an opinion, but can I ask you, does the minister and the department appreciate the dramatic consequences that would flow if there was a TDM exemption in copyright law?
So again, Senator, I'd point you back to the Attorney-General's public statements that the government has no plans to weaken copyright law. As part of the work that we've been doing with the reference group and our targeted discussions with stakeholders and our own policy development work, we've of course been seeking to understand the impacts on different industries, including the creative and media sectors, and we do understand the monetary but also personal impacts on creative workers.
I just want to take you to reports about the Productivity Roundtable a number of weeks ago. There were reports from the sidelines that a deal had been entered into between big tech and the unions on text and data mining. The ACTU claimed this was a breakthrough. Could you explain what that deal was? And how do you make such a deal without involving the rights owners?
I think that we can speak to that deal, Senator, as it was a discussion between the unions and the tech council, so I just don't think that we're able to answer that question.
We're certainly aware.
Do you have any information about it? Because that goes to the heart of the minister's concerns. If there's deal-making happening on the side of the Productivity Commission, which undermines the rights of copyright owners, surely that would be of interest to the minister and your department.
the subject matter is absolutely of interest, but we don't have any inside running on this or any involvement. So we've seen the media reports that I imagine the committee may have as well. But my understanding of those media reports was not that they said they had struck a deal, but they'd agreed to enter into discussions about how a framework to support payment could be struck. But again, we don't have any personal involvement in these discussions.
Has the Minister or the Department sought any information in relation to those discussions? Because, I mean, just on their face, based on the media reports only, it appears to be grossly undermining the rights of the copyright owners. How can the ACTU be entering into discussions with the tech giants about the copyright of Australian creatives, which don't involve the creative sector?
I would say that the Media and Entertainment Artists Alliance, so I'm not sure if I've got that acronym correct, but they are a member of the ACTU, and so I would say that their views could be potentially taken into account through that forum, but no, the department at this stage hasn't sought any further information about the content of those discussions.
Can I just get clarification as to whether the ACTU is on your reference group?
The ACTU is not in its own right, the MEAA is.
All right, look, if you could just on notice if you have any further information in relation to those discussions, because if the Minister was truly concerned about what's going on with the Productivity Commission's proposal and some of these, and the urgings of the big tech companies, which of course undermine the rights of copyright owners in this country, then I would have thought the Minister would have made some representations about this potential deal. So if you could take on notice any information or materials or correspondence that you or the Minister's office might hold in relation to that matter, we would be grateful and provide those to the committee.
Take that on notice,
Thank you. Can I just ask what progress has been made in relation to the proposed Copyright Small Claims Tribunal?
Yes, so, sorry. We have been doing policy work to consider if government were minded to introduce a copyright small claims forum in Australia, what that would look like. We've had targeted consultation with around about 22 stakeholders to gather further information to support that policy development and inform advice to government.
If you could provide details on notice about those consultations, with whom you've been consulting, when, how, and any briefing notes or advices or the other accompanying materials to support those consultations, I'd be really grateful. And just finally, when it comes to generative AI, what output side protections are you considering, if any, to protect the interests of the smaller holders? I mean, we've heard, for instance, some pretty alarming concerns from authors whose work was stolen overseas, and in fact Meta was involved in unlawfully taking the work of Australian authors and ingesting it into their AI platforms. What work is being done to protect smallholders in relation to output side protections and in relation to blatant acts of theft like we've heard earlier today?
So our focus to date in our policy development and with the reference group has been looking at the inputs side of AI development, given that has been such an important issue to stakeholders across the board. But we are aware that the outputs issue is also an important one that we'll need to consider, and our intent is to consult with the reference group in the future about outputs issues.
Okay, look, I think I will leave it at that. Thank you both very much for your time. Thanks, Chair.
Thank you. Any other questions? No. Okay. Thank you. You've taken lots of questions on notice, and any further ones, I guess we'll come and see you at estimates.
Thank you, Senator.
Thank you. Well, that ends our hearing for today. So I just want to thank all of the witnesses for participating, both in person and online. I'd like to thank our Secretariat staff for managing us so well, and Hansard. And we'll call it a day. Thanks, everyone.